Okay, looks like we're good to go. Okay, so welcome everyone. Let's get on the record, start our introductions here. This is docket 5 UR 110, the joint application of Wisconsin Electric Power Company and Wisconsin Gas LLC for authority to adjust electric, natural gas, and steam rates. This is Michael Newmark, the Administrative Law Judge for the PSC, and we're conducting this party hearing session over Zoom and live streaming on YouTube. We have parties and commission staff in attendance, one member of the public. So the connection is open to the public. Unfortunately, it just came to my attention that the phone number to dial into Zoom has an additional number at the end. So if anyone's listening for whatever reason wants to call in, you want to dial 6799 and leave out the 2 at the end. Apologize for that extraneous number there. We're also accepting public comments in the case. We've done two public hearing sessions so far. We'll have one more in person, and I'll just show the notice for that. The in-person session will be November 3rd at 2 p.m. and 6 p.m. at the Washington Park Senior Center. But up until November 7th, we'll accept comments in writing, either through the commission's website or by US mail. I did have the current tally for comments. It's not in front of me anymore, but it's in double digits at least. So you know. Okay, so we can go off the record just to review the documents that I sent out this morning, actually. So let's go off the record for that. First of all, the service list. Any additions or corrections we need to make? I think we have Lucas Fikes on this one from the beginning. And I don't know if Attorney Phillips is going to appear today. I don't believe she's on either list. So I just wanted to point out, we can add her to the list. Usually in order to get her on the list ahead of time, I just need to have something in writing. It would probably just facilitate things to have, if she is going to appear, just have her include her contact information in the application, and then I can just throw that name into the service list right away at the beginning of the process. So that might just speed things along a little bit. So anything else we need to discuss about the service list?
Your Honor, we should add Kate Phillips to the service list in both cases, please. Thank you.
Yes, yeah, I understand that. Thanks.
Oh, thanks.
All right. So before we get the offered evidence list, just want to make sure who we have in attendance. I just want to make sure we have all the parties, which parties we have in attendance. So I'm just going to go by what I see here. So let's just get on the record. So I just wanted to note in attendance here today from the parties, we have the joint applicants and Cub, Clean Wisconsin, IBEW, I don't have the local number in front of me, but Witness Stone is in attendance. IUOE Local 240 is in attendance. MMSD, Renew Wisconsin, Roundy's, Walmart, Walnut Way Conservation Corp, and WIG and commission staff, of course. Just want to make sure we have that on the record. And let's go off the record now and discuss. First, let's go through the offered evidence list, just corrections, and we'll deal with other preliminary matters. So let's go off the record for that. And we see the offered evidence list here in just a minute. I should. Okay, so I know there's a few additions that are not on the list just recently. So that's the sur rebuttal filed by the applicant. Besides that, do we have corrections to the list?
Your Honor, you had made a note about the PSC staff's exhibit data request responses, that it was only opening for you with a right click. And we're not having those issues with that document. We've tried it on multiple staff computers, and I think if you hit control and click on it with a left click, it should open as normally.
Yeah, I think part of the problem is the Excel files need that second step. I don't know. It could just be my computer, but I've just seen that.
I'm here to raise that possibility.
It could be. But anyway, but thanks for mentioning that. So just generally speaking, though, the list itself, did I miss any filings or anything misrepresented here? As far as we know from yesterday, I guess. No, all right. Hopefully we got that right. And we do have, so we have the SIR rebuttal and the exhibit. I didn't reflect that in here. There's also a few documents joint applicants will be using on Cross. I got the email for that. And I think that's it in terms of updates. Okay.
Your Honor, this is Krista Westerberg. We had also filed some exhibits that we'd potentially use for Cross.
Can you put your video screen on?
Yes.
Okay, so so that's on. You filed them or did you email them?
We emailed them as a zip drive yesterday.
Okay. So I could have missed. I may not have caught that. Did you send a copy to me?
I sent it to the same people everyone else sent theirs to.
Sent their.
Hey, love. Yep, I'm in a hearing. Okay, beautiful.
It's good to know we still have we still have some love in the house here. Okay, so I don't think I got that message as far as I can tell.
All right, I'll forward it to you. I apologize for that.
Okay, and they're just documents used on Cross.
Yes.
Okay. All right, so then getting back to the list. I updated my comments to reflect the new filings that updated my comments using the template from the last case. Let me be clear. I updated my comments. Hopefully I got all the updates correct. If there's anything confusing about that, just contact me. I don't think I left references to Wisconsin Public Service in there. I think I got the page numbers updated, but you never know. And that's it. So as far as let's get into some other matters.
Your Honor.
Yeah.
So my SIR rebuttal, public service reference 447661 was omitted from the list.
Oh, hang on. SIR rebuttal. Okay, I'm not sure how that happened. Okay, yeah, so let me.
Excuse me, Cubs rebuttal is also missing from the list, Your Honor.
Okay, I have the right. I have errata on here. Okay, well, let me.
Everything else looks right.
Okay. Let me quickly add that in because I'm going to forget if I don't do it. responses.
Would you like the reference numbers?
No, that's okay. I got it.
Okay.
Here. Just takes a second here. Okay. Just Keim and Singletary for rebuttal.
Yes, that is correct.
All right, well, let's double check. Anything else we're missing from the list? Obviously, that can happen. Okay. All right, so let's get into other matters here.
Your Honor, I've just been made aware that we have one other item that is missing from the list.
Yeah, go ahead.
We're missing Mitchell Horry's rebuttal testimony, which is reference number 447950.
Yeah, I think I just misplaced.
Okay, I see.
All right. Okay, well, we still have a moment here. Well, we can always fix this as we go along, but at this point, we got some of it shook out here. Okay. Why don't we handle which witnesses we can excuse at this
Your
time?
Honor, excuse me, I'm sorry. I had one more issue on the offered evidence list.
Okay.
And I apologize to raise this, but the issue with live links and exhibits, we have an issue, and I see some other parties having that same problem with filings, where we run a program to disable all the live links and they go away on our side. It's my understanding that a lot of word processors and programs on the user's end will have settings that automatically put those hyperlinks back in. In the past, we've been instructed to go in and physically edit all of those exhibits to change URLs so that they're non-functioning. And if that's the way, we need to proceed, we'll do that again. But it's very, very time consuming and very inefficient, especially I think on some of us smaller parties. I'm wondering if the issue with that is the concern about containing the record to the documents filed and excluding things that are accessed through links. Would it be possible for parties to agree to a stipulation that would exclude that evidence from the record explicitly, or some other way that we can save everyone the time of editing PDFs? And I apologize if this is, something that's been hashed through a long time ago, and I'm fairly new to this.
Yeah, I think, at this point in the game, I think we're going to stick to the rule. This is something you can raise in pre-hearing and pre-hearing conference when we're adopting the facilitating matters order. That's the time to raise issues with what's required for filing. I understand there's issues with this. Do your best. I think that I didn't see Clean making the attempt to disable those links. Maybe I missed that.
No, Your Honor, you're right. We didn't go through and edit them. I wasn't sure if, last time we filed the program didn't work. So I ran it and double checked it so that they weren't live on my end, but understood, and I'll raise it next time for the next case. Thank you.
Okay, so I was going to move into maybe we can excuse some witnesses where there's no cross. Do this earlier in the process this time, may be helpful. So,
Did you want this part on the record?
well, just a second here. So,
Okay.
so I did come up with a list of who there's questions for. And also we have some time constraints here. So there appear to be questions for the witnesses that appear on the list here. So let me just ask generally if we can do it this way, maybe the quickest way. Are there questions for any other witnesses?
Your Honor, yes. And this again, I think attributes to me not including you on the email that went out at 1:30 yesterday. So again, I apologize for that, but we had two others that aren't listed here. Mr. Korduki and Mr. Zagonik.
Okay. Okay, so how about other witnesses? Anyone else? Okay, all right, so I guess what I had highlighted, the witnesses that should appear, ones that are not highlighted will excuse. Any objections to that?
Your Honor, I'm sorry, Your Honor, Steve Heinzen for Week here, and I just have a clarifying question. You had some questions for witnesses yesterday on a couple of issues, including cost of service and revenue allocation. And I am wondering whether it would be okay for those we identify, like we did yesterday, to put in their answers to the questions that you asked by affidavit.
Okay, yeah, I don't have a problem with that.
Thank you so much.
Identifying where their position's located in the records.
That's correct, yes, and it would be consistent with the questions in their answers yesterday. So yes, thank you so much.
Yeah. So does that cover your questions for your witness? I think there's just one other clarifying question for Bauer that I had.
And and perhaps that was the same question that you asked yesterday as well, having to do with, what does class 6 mean?
Yeah.
Okay, so he did respond to that yesterday, and we could include something on the affidavit to that effect as well, if that's okay with you.
Okay, that's fine with me.
All right, thank you so much.
So is any other questions for those witnesses, or can they be excused?
Judge Newmark, this is Emily Vandre with MMSD. I just have a clarifying question. We were not a party to yesterday's hearing. So you're saying that you'd be okay with, for those witnesses that would be dismissed, that would be putting their testimony and exhibits in by affidavit, that we could answer those questions you have at the bottom in those affidavits?
Yeah, go ahead and do that. That's fine.
Okay, thank you.
So, Your Honor, this is Barry Naum for Walmart. Just as a follow-up to this discussion, and I am new to practice before this commission. So would those affidavits then be due at the due date that's specified previously for the filing of revised testimony then?
Right. That's the deadline for witness affidavits.
Okay, thank you, Your Honor.
Same date, yeah. So does that cover, let me see, we're getting a little, so who in MMSD, we don't have any questions for any MMSD witnesses?
No, but Your Honor, as long as we're covering these issues, we do have one commission staff witness who has a time constraint. He has to be free by 6:15. And I'm sure we all optimistically hope that we don't go that long, but just in case we do, our witness, Justin Adams, needs to be on before that.
We'll keep moving on. Let's proceed with what I'm asking right now. Okay. So,
Judge Newmark, I'm sorry. On witnesses who need to appear, I think Todd Shipman is not highlighted on your list, but I thought Renew had indicated Clean had indicated they had crossed him. You just passed him there.
okay, they didn't mention that last time. Okay, thank you.
Your Honor, we don't need to cross Shipman anymore.
Okay.
Okay.
We'll let him go and file an affidavit for him then. Thank you.
All right, so let me just get an answer. Are there any questions for the WIG witnesses at this time? None. Okay, so let me just make sure we have them set. And no questions for MMSD. Okay. All right, so let's get on the record, and I'll excuse the witnesses to which we have no cross-examination questions, and to which my questions regarding party positions on various aspects of the case will be answered in the witness verification affidavit. So we'll start off with Graves. Actually, Shipman, Ellis, Lane. Oh wait, were there questions for Ellis? I'm sorry.
Your Honor, I don't.
Yes,
believe
the applicant has questions for Alice.
I'm sorry. I don't believe there are any questions for Ms. Lane.
Yes, I'm listing who's excused.
Oh, that's yeah.
So let's start over. Okay, Graves, Shipman, Lane, O'Donnell, Stone, Tetzlaff, the MMSD witnesses, Jankowski, Obanoff, Persal, and Schaefer. Renew witnesses, Barnes, Cal, and Vickerman.
Your Honor,
Yes.
similar to yesterday, witness Kell will be doing a live verification.
It's up to you whether you want to call them or not. But I'm allowing filing by affidavit. Where did we go? Oh yeah, Roundies, Bieber, and if we could have witness Bieber include those answers to those questions. I think is he dealing with cost service study, rate design, or?
Yes, Your Honor.
So
he'll do that.
Yeah. For Walmart, Cronauer, Teague, Walnut Way, no questions for witness Colton. Okay, he's excused too. Wig, Bauer, Colin, and Manny excused. Witness Adams, any questions? Or does he have anything to add? We didn't have any questions yesterday, right?
No, and he doesn't have anything to add, but we are planning to have our witnesses verify their testimony live.
There, fine. Okay, so they're all excused. And let's get started now with some other matters here. We do have at least one motion to strike. There's a motion to strike from the joint applicants related to witness Ellis, I believe. Was there anything else? I can't remember. Did I see something else cross my desk? Okay, all right. So I have the motion here. I just extracted a part of it. We get Oh, yeah, that's the motion. Okay, that's good. Okay, so I have to be honest, this motion comes to me with no surprise, and that may indicate where I'm headed with that. But I mean, when I open up a file and I say, oh, someone's going to object to this, I know it's coming. So let's have a response from Clean Wisconsin.
Your Honor, we're prepared to respond in writing tomorrow by tomorrow's deadline. If you'd prefer, I'd give some of that argument today. I can.
I'm sorry. So the way the process works is pending motions are heard before the call of the first witness.
Understood, Your Honor.
Yeah.
So the joint applicants, you know, as the motion explains, assert that we should have filed this as direct testimony. We had, you know, reasons to do that, but also we believe the, you know, statutory and administrative ability to do that. Looking at chapter 227, where the joint applicants find their, you know, the legal justification for their motion. It includes, you know, that of course, hearing examiners aren't bound by common law or statutory rules of evidence. It goes on to say that they shall admit all testimony having reasonable probative value, excluding immaterial, irrelevant, or unduly repetitious material. We don't think that Mr. Ellis's testimony is unduly repetitious. It is responsive to direct testimony filed by Dr. Keim, which was in the second round of direct. Dr. Keim's testimony, you know, clearly was responding to Ms. Bulkley's direct, and we, you know, instead of adding new issues, the joint applicants assert that we raise a new issue. The issue in Mr. Ellis's testimony is the ROE. We are continuing that discussion about the ROE. They speculate as to, you know, they speculate that we, for some reason, didn't file direct with Mr. Ellis. That was never our intention to file direct. We had reason to believe that CUB was going to address the ROE issue. And as you know, we submitted direct testimony on a PIM. The direct of Dr. Keim didn't go as far as we thought the ROE needed to go, especially for us to be able to, you know, argue for a PIM to be approved by the commission. So that was why we decided at that point to add on to the testimony, and you know, instead of, it's not a new issue, and it is, you know, within the scope of the direct filed in the second round.
Okay. All right. So do we have a response to those particulars from the joint applicants?
Just a couple things very briefly, Your Honor. Mr. Corte just spent a lot of time talking about the rebuttal to Dr. Keim. We're, of course, have not objected to Mr. Ellis's testimony to the extent it is responding to Dr. Keim. We think that's fine. We are objecting to it to the extent it is responding to Ann Bulkley and Todd Shipman's direct testimony, which was filed back in April. So, and we've proposed in our red line version what portions of the testimony should be excised to address that issue. Mr. Corte reference to the chapter 227 provision. If he were right, it would completely swallow all of Your Honor's facilitating matters rules for conducting these hearings. And we think that the facilitating matters are important and try to pay attention to them and conduct our litigation according to them. And then I think his last statement that they thought CUB didn't go far enough and so needed to introduce some new topics proves the point that we're arguing. They have introduced new topics in Mr. Ellis's rebuttal testimony, and we believe that that ought to be done on direct, if at all.
Okay. So I did want to mention everyone's edification. So I have the facilitating matters order. I'm going to put that on the screen, which deals with the rounds of testimony. So the way I read this, the way it's intended, and there's 3 rounds of testimony when it's scheduled. As you know, direct rebuttal and surrebuttal, and they're defined in the facilitating matters order. What the practice of parties is to, if an applicant is filing direct first, and there's a significant amount of time between direct from applicants and direct from interveners and staff, we see that interveners and staff will rebut the applicant direct on intervener and staff direct, or possibly their direct is really just to respond to the applicant. But what's important about the first round of direct is that it provides each party the opportunity to present its positions and produce evidence to prove the facts needed to support its claims. Then, of course, rebuttal is to rebut, opportunity to prevent responsive and countervailing evidence to that presented in direct. And then there's that other provision as you go down the page. The scope of written testimony is narrowed with each round of filings such that it addresses only the testimony filed in the previous round. So there may be some confusion with that, and I think round is meant to mean direct, rebuttal, and surrebuttal as it's defined. First round of testimony is direct. So there may be a little confusion on both sides, but I'm not sure. I mean, we have a practice where parties and interveners and staff have in the past rebutted direct of applicants, like I was mentioning, but that's not really that's something that happens, but it's not what the rule requires. It doesn't go against the rule necessarily. Getting staff and intervener testimony earlier is always better. But just in terms of the technicality here, it's appropriate to respond to direct on rebuttal. So just wanted to make that clear. So if we go to what's proposed by joint applicants in the motion, we have tried to highlight this. So where joint applicants indicate in their motion that they're opposing or objecting to testimony where it raises new issues, that should be stricken from the record because that should have been indirect. Where it's responding to Shipman and Bulkley, that's appropriate rebuttal. So I've highlighted where joint applicants indicate that rebuttal, testimony is inappropriate for direct because it's raising new issues. So the first one's page 7, lines 14 through page 9, line 4. Page 38, line 12 through page 44, line 5. Page 46, line 8 through page 49, line 12. And page 77, line 9 through page 79, line 2. So those will be stricken, the rest can stay. And you'll have to modify your testimony. I don't know how that shakes out with subsequent rounds. I didn't have time to look at that. But to the extent it needs to be corrected, it should be. So I don't know if WEPCO, if joint applicants responded to any of this, but we'll need to correct that. So
Your Honor, sorry, can I ask a clarifying question? The difference between a new issue and countervailing evidence as provided for at the pre-hearing conference. I don't understand what the joint applicants assert the issue is, because the issue is the ROE.
it's your position. Okay, so direct is your position and evidence to prove the facts needed to support your claim. So if you're providing a new theory on ROE, which I believe what the new issue is, what they're talking about, the new construct for ROE, that's new, should have been indirect.
Yeah, that's correct, Your Honor.
If they're critiques of this, of modeling that was done, is that a new issue?
In my opinion, the portions of testimony flagged are introducing new issues.
Understood.
And the rest of the motion is denied.
Thank you, Your Honor.
All right, so let's move on.
Your Honor, I have just one clarifying item, and it was discovered after we filed the brief. The line descriptions in the text of the order or the motion that you're looking at actually don't quite line up, because we had when we converted PDF to Word, there was a pagination issue. So, Mr. Corte, we can provide refined page and line numbers for those issues if that's helpful.
Do you have those in front of you?
I don't, I'm sorry, but we can provide them.
Okay, can you send them to me as well?
Yes, we'll do.
Now the transcript will be inaccurate at this point, and I'll have to think about possibly just correcting the transcript to reflect the correct citation.
Understood. One just observation about what we now understand to be the meaning of the facilitating matters. It's going to result in situations like this where very substantial rebuttal testimony is filed. And as these cases have been going, the timelines have been getting very tight. And as between rebuttal and surrebuttal, in this case, there's very little time. And it puts the applicants in a very difficult position to have to respond to, in this case, 70 pages or something, 80 pages of very substantive rebuttal testimony in a very short timeline late in the case without adequate opportunity to seek discovery. Just an observation. Yeah.
I understand. Yeah. All right. So anything else preliminary we need to discuss? I feel like we're forgetting something, but I'm sure we are. Just can't tell anymore. All right, so let's get started then. I think we're good for our first witness. And so, Attorney Wilson, if it's quicker to have you go over the questions that I posed in this case, knowing the answers, what we know from yesterday, I feel free to do that. Just let me know how you want to proceed.
Yes, we're happy to do that.
Okay, so let's take our first witness.
Okay, the applicants call Mr. Dukas.
I have a lot of screens here. Let me see if I can find your witness screen. There you are. All right, raise your right hand. And do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right, go ahead.
Mr. Dukas, please state and spell your name.
Theodore Idukas, that's E-I, D as in David, U-K-A-S.
Mr. Dukas, did you prepare and cause to be filed direct, supplemental direct, rebuttal, and surrebuttal testimony in this case?
I did.
If I asked you the questions in that testimony today, would your answers be the same?
Yes, they would.
Did you prepare and cause to be filed 7 exhibits in this case?
I did.
Is the information in those exhibits true and correct to the best of your knowledge?
Yes, they are.
Okay, Mr. Dukas, there's reference in testimony from Local 420 about the company's staffing plan for the test year. Is the company's staffing plan in the record in this case?
And it comes down to the term, what you mean by the term staffing plan. If you mean no, a head count, staffing head count number we plan to fill with hires, then yes. And I would say the place to find that in this docket would be, it's a response to a data request BS 1.3 and its attachment, and the reference number for the data request response and its attachment are 441409 and 441410.
Thank you.
I'm sorry, and just sorry to clear my answer. If you mean a plan in terms of a document or guideline or something to provide direction on how to fill those positions, there's nothing specific for this rate case or those staffing numbers. It would just be according to our current guidelines and procedures that our Human Resources Department uses to fill positions generally.
Thank you. Your Honor, does that cover the questions you want to ask, Mr. Dukas?
Yes, it does. The questions, just want to make sure we still have Dukas 8 will be filed. The data request response RR 40 that's indicated in the offered evidence list.
Yes.
I'm sorry, Your Honor, I should have counsel do this, but old habits die hard. Yeah, yes, Your Honor, and I think on your offered evidence list, the reference number you have is for the one for the Wisconsin Public Service case that was incomplete. The WEPCO/WG version, which is complete, the reference number should be 436595.
Great, thanks for that update.
It's not cut off.
Excellent.
All right, Mr. Dukas is available for cross.
All right, so let me just add that we can accept that testimony on the record. Also, I can accept all the testimony that we've discussed on the offered evidence list, pending refiling and witness verification. They're all on the record, and the refiling would include, the conforming the Alice testimony to the motion order on the motion. So yes, witness Dukas is ready for cross. Any question?
I'm sorry, Your Honor. I forgot an issue in connection with Mr. Tetzloff yesterday. You had asked a series of questions about offshoring customer care.
Oh, is that to you, Dukas?
Yeah. Do you want to get into those?
Sure. Let's do that. So yeah, let me ask. Originally for off the record for a second.
Yeah, I don't think you'd indicated those questions on this offered evidence list for whatever reason, but
yeah, there was for another witness originally, but okay. Well, witness Dukas, let's get on the record. I'm just curious in terms of statement that witness Tetzloff had mentioned. He indicated a term of phrase that he was using that may have given the indication that there was offshoring of customer care center functions. And could you just elaborate exactly what functions of the customer care center are offshored and which are conducted onshore?
For Your Honor. Yeah, so our customer care center, we do have a physical customer care center and employees located in the service territory. And I believe the offshoring comment, so our company directly does not hire employees that would be located outside the United States. We do have some of our service customer care functions, service center functions contracted with a United States-based company That company, and they perform credit and collection services for the company. Now that contractor, US-based contractor, they, I do believe, hire some of their employees from outside the US. But obviously, as a contractor, we don't control, who they use as employees. So I hope that answers your question.
And just to complete the circle from the last case, what functions do the offshore entity perform?
I'm sorry, entity.
What functions does the offshore entity perform for?
Thank you.
Yes, to my understanding, the US-based contractor that does have outside the US employees, they perform credit and collections functions for us, for the company.
Okay, great, thanks. All right, I think that's all I have, as far as I can remember. So any cross for the witness? No, all right.
Your Honor, no, sorry, this is Krista Westerberg. We do have some cross for the
Okay,
witness.
sorry about that. Go ahead.
Good morning, Mr. Idukis. I'm Krista Westerberg, representing Walnut Way Conservation Corp.
Good morning.
Morning. So you said in your direct, you've been at your current position at WEC since 2016, is that right?
That's correct.
Is that also when you joined WEC?
That's correct.
You're familiar with the concept of energy burden, correct?
Yes, I am.
How would you describe your understanding of that term?
My understanding of the term is I'm not an expert in the area by any means, but my understanding of the term is that you're looking at what portion or percentage energy costs are represent to a population, however you define that population, relative to other expenses or costs that that population is spending their income on or incurring.
So a population with a lower income might be spending a greater share of their income on utility service relative to populations with a higher income, correct?
That hypothetical, that situation, it's possible, but it would depend on probably a lot of variables and whatever the data showed for that, whatever population you're examining.
Okay. Would you agree that people with a higher energy burden are generally more likely to experience disconnections and shutoffs and fees that people with higher incomes do not incur?
Objection, this goes beyond the scope of Mr. Idukes' testimony.
Just trying to establish foundation, Your Honor.
Can you read back the question, please?
Question, would you agree that people with a higher energy burden are generally more likely to experience disconnections and shutoffs and fees that people with higher incomes do not incur?
I'll allow
it. I don't know the answer to that because I think there's two different things being compared there. So I don't know if I can say as a general matter the answer would be yes or no to that.
Maybe you can answer this question. Would you agree there's a business cost to utilities associated with shutoffs and disconnections and late charges?
Objection goes beyond the scope of Mr. Idukes' testimony.
Same response.
Well, he does respond to witness Colton, right?
Yes.
So let's just find, I mean, this is going to be a standing objection, basically. Are we going to be doing this?
Well, it can be.
So let's just settle it now. Let's see if it's in the scope of what witness Idukis has testified to.
Well, in Your Honor, Mr. Idukis is a utility executive for several years with a lot of experience in the industry. So I would expect this not to be a difficult question. and just establishing foundation for another question.
Okay, go ahead.
I apologize, but can I have that question either restated or read back?
Let's read it back. Yeah.
Would you agree there's a business cost to utilities associated with shutoffs and disconnections and late charges?
I would say that for shutoffs and disconnections where those are having to be done physically, there as a general matter would be, to my understanding, costs involved. And when you say late charges, when customers in arrears, there are costs the company incurs to finance the debt or the lack of the revenue. So if that's what you're referring to as what there would be a cost to the utility, I would say as a general matter, yes.
Okay. And with your understanding of the application that's been filed in this case, Wisconsin Electric isn't proposing any new initiatives to deal with the issue of energy burden, again, in the application. We're not talking about settlement today.
Right. If you mean, except for, well, the extension of the LIFT or the low income forgiveness tool, which it's an extension, not anything, a new program, but an extension of an existing program. I think very narrowly read the answer to your question would be yes.
Okay. And in the application, the Wisconsin Electric didn't propose to extend that program time into the future, correct? Do you know?
I believe, and I don't recall, well, in the application, I don't recall witness right off the top of my head which witness it was. We did agree that we would continue the program.
That's your understanding.
Yeah, I'm sorry. I don't think we set a time limit either way, whether it would continue to or terminate, but I do recall we agreed to extend it in our application.
And that's the LIFT program you're talking about.
I'm sorry.
The LIFT program, Runner, the LIFT program.
Okay, and that's just based on your memory?
Correct.
Okay. I want to refer you to your direct testimony on page 3. At the bottom of at line 9, sorry. And do you see the reference to the term affordable in that that line?
I do.
Okay. We asked in discovery, and this was one of the exhibits we emailed out yesterday. It's 2 Walnut Way interrogatory 6. We asked to define for the company to define the term affordable as used in this sentence. Can we pull that up?
Off the record. Okay, zip file. This is going to be a little bit interesting here. Let's hope all goes well. Okay, so I'm just going to extract them all at this point. Okay, it's not, I'm not seeing an extraction option here, but let's, what was the exact site for that?
It was a data request response to WWINT6.
Okay, let's see.
I can send that to you individually, Judge.
Coming right up here. Okay, so it's not, it's not marked yet, so is this what you were looking for?
That's it.
There you go. Okay, perfect. All right, let's get back on the record.
Thank you. So Mr. Idukas, are you looking now at the company's response to 2 WWINT6?
I am.
Okay. And the question was asked again about how the term affordable was defined in your testimony, but it looks like Mr. Stasek was the one to respond.
Correct.
Okay. And that response was that the word affordable in the reference sentence refers to the cost-related attribute used to describe the proposed generation investments that will implement our generation reshaping plan that will save customers nearly $1 billion over the first 20 years of that generation reshaping plan. Did I read that correctly?
You did.
Okay. Did Mr. Stasek discuss that answer with you before he submitted it?
He did.
Okay. And that's what you told him your understanding of the term affordable is used in your testimony was?
I would say that we agreed and understood that was the definition of that term. I think told is maybe the wrong verb to use, but I would agree that this response is a correct understanding of what that word meant in my direct testimony.
Okay.
Off the record for a second, Debbie, did you catch the whole answer?
Yes.
Okay, I had trouble hearing that. Okay, let's get back on.
Thank you. And do you want us to move admission of these as we go, Judge, or would you prefer at the end?
Oh, we can mark them at least. Let's mark them. So this would be Aducas 9. And if you want to provide let's see. Let's move admission with each one. That's probably the easiest way to do this. This was INT 6, is that right?
That's right.
Okay, so any objections to receiving this data request? Okay, so it's in. Do you want to continue?
Yes, thank you.
We don't need this document anymore.
Sorry?
Do you need this anymore that you know?
No, thank you.
All right, what's next?
Okay. Would you agree, Mr. Aducas, that Wisconsin Electric is not proposing energy efficiency programs, initiatives, subsidies, or rebates for residential customers in this docket?
I don't think I can agree with that comment.
And is that because there's still the ongoing focus program and other programs that Wisconsin Electric offers?
I would say that my answer is based in, focus on energy as well as the voluntary energy efficiency programs. That'd be, at least part of my answer, but in terms of whether or not there's any other programs being proposed, I don't recall anything else in this docket, but I don't believe that's not my area of expertise.
Okay, so there's nothing new, in other words, aside from the programs that Wisconsin Electric has ongoing, right?
I believe that's correct, other than the dollar amounts might have changed, but the programs themselves, to my understanding, that is accurate.
Okay, and you would also agree, and that's the same for Wisconsin Gas?
To the best of my knowledge, that's correct.
Okay, and you would agree that Wisconsin Electric is not proposing any initiative to expand access to renewable energy to residential customers in this docket?
Yeah, subject to check in this docket. If you're talking about a specific program or tariff rider, as opposed to our generation fleet changing and becoming, going closer and closer towards net zero, then I would agree with that statement.
Okay. And programs that are directed to customers that Wisconsin Electric currently does offer, like Solar Now, are not available to residential customers, correct?
Objection. Are you asking about Solar Now or other programs?
I'm using Solar Now as an illustrative.
Yeah, and actually, I have to change my response, because I do recall we also do provide, I believe it's called the Energy for Tomorrow option, where a residential customer can elect a certain percentage of their usage to come from renewable sources. And they pay a very slight premium. That's not a new program, and maybe that's where I was hung up, but that is a offering we offered and do continue to offer our residential customers. Solar Now, you're correct, that is not offered to residential customers.
And there's no other on-site program like Solar Now that would apply to residential customers, correct? That customers can implement on their own property.
And I don't want to argue, but in terms of we do not prohibit our customers from owning or leasing in a proper lease solar panels or other distributed energy resources that they site on their property or on their rooftops. And then we offer a variety of tariffs, generally referred to as net metering and parallel generation tariffs, depending on the size of the system that the customer chooses to have on their property. In that sense, we do, our tariffs, our programs do allow for that. But in terms of anything other than that, such as Solar Now, again, and I'm saying like Solar Now because these are tariff offerings that have existed prior to this rate case. There's nothing new in this rate case like that being offered, but
right,
yes,
right, okay, and that
clarification.
Yeah, that is what my question was directed to, is anything new? And it sounds like the answer to that is there is nothing new for residential customers as far as expanding access to renewable energy.
Again, other than as new generation that is clean being part of our overall portfolio, there's no new tariff offering or program being offered in the application for residential customers related to renewable energy.
Thank you. And that's whether the customer is low income or not, right?
Correct.
Okay. Same question in this docket. Wisconsin Electric is not proposing any initiative to expand electrification, like wiring upgrades or conversion of gas appliances to electric to residential customers.
And to my knowledge, in this rate case, there's no new program along those lines being proposed, correct?
Okay. Could we pull up in the from the zip file, Your Honor, 2WWINT3?
Off the record. Is that the document you're looking for?
Yes.
Okay, all right, back on.
Mr. Adukas, we're looking at a data request response to WWINT3, asking the company to identify and describe all programs for electrification incentives. And it notes that in a separate docket, the company has launched an electrical vehicle charging pilot. Do you see that?
I do.
Okay, and is that consistent with your understanding that electric vehicle charging pilot isn't available now?
It is available now, correct.
Are you aware of any analysis that the utilities in this case have done as to whether low or medium income customers will be able to take advantage of this pilot?
What I would say is that part of that pilot does involve a carve out of the investment to propose and work with commission staff on developing a low income portion of that electric vehicle charging pilot. But in terms of analysis of low and medium income customers using or electing to use the other portion of the main portion of that vehicle pilot, to my knowledge, I am not aware of any such study. But again, that would not be within my direct subject matter area of expertise.
do you know, and probably the answer to this is no based on your last answer, but do you know what proportion of electric vehicles are sold to low income people?
I do not.
And you would agree that none of the utilities in this case are proposing in this docket any programs to help solarize or electrify any low-income multifamily construction or rehabilitation projects, major rehabilitation projects, right?
With respect to this rate case, as you've narrowed the question, that's I'm not aware of any. That's correct.
And let's pull up, off the record, can we pull up 2WWINT4?
Actually, first let's mark, are you going to offer INT3?
Yeah, let's go ahead and do that. Thank you.
Let's mark that as Dukas 10. And any objections? That's in the record. So which one, and can I close?
Are we off?
No.
Okay.
You should read my mind, you know that. Are we done with INT3?
Yes, Your Honor, thank you.
All right, so now let's go off the record. What was your next?
2WWINT4.
So, and you're going to offer this?
Yes.
Why don't we mark this now? 10. Can I ask for objections now, or do you want to go through the questions first?
I don't have many questions.
I'm asking the applicant. Is it okay just to ask if there are any objections now before we get started with this? Actually, we just ask, let me just ask the applicant. You've seen the data requests. Will you have any objections to offering those in the record?
I don't think so, Your Honor, but we'll want to see how, how they're used in the testimony.
Okay, so it's okay to ask the questions first. I guess I'm just wondering, should we ask all the questions first and then have you object?
Yeah, that's fine.
Okay, we're gonna be doing this for a while. All right, so this is now 10. Is this the document? Looks like it. Okay, let's get back on the record. So we marked 2WWINT4 as a Dukas 10.
Yes. And just to follow up on an answer that you just gave, Mr. Idukas, you had asked, you kind of inferred that the way I had framed my question, that in this docket, the utilities are not proposing any new assistance programs to low income multifamily new construction or substantial rehab developments. But generally speaking, according to this response, the applicants' programs that are available are just through Focus on Energy, right?
Let me read the question. Yeah, but I would say based on this response, I would say the response speaks for itself, but I mean, it talks, we're describing the programs that are available to low-income multifamily new construction and or substantial rehab developments designed to help solarize or electrify the development. So this response, again, I would agree is providing the extent of which at the time it was provided, we provide what programs there are. So I have no reason to believe that this response is not fully accurate.
Okay, thank you. We seek to admit this exhibit then, Your Honor.
Okay, any objections? Okay, that's in.
Mr. Dukas, I'd like to turn to your rebuttal testimony. in the portions where you refer to Walnut Way's testimony on page 8. Around line 2. And you mentioned that prior to submitting direct testimony, Mr. Colton and Walnut Way did not approach us with any of the concerns or proposals that were described in Mr. Colton's testimony. And you suggest there wasn't enough time before submitting rebuttal, that you didn't have the ability to address all of those proposals, correct?
Correct.
Okay. Would you agree that the application for this docket was filed on approximately April 28th?
That sounds correct.
Okay. And do you have any reason to disagree with the motion to intervene date for Walnut Way as being May 27th, 2022?
Subject to check, I have no reason to disagree with that being the date.
Did you read that motion to intervene?
At some point I did, yes.
Okay. And do you recall at what point that was?
Some point after it was filed and before today, but I don't recall exactly when that was.
Okay. Can you say where in that range approximately it was? Earlier or toward the end?
Probably, I looked at it when it was filed, close to when it was after, close to after it was filed, and sometimes subsequent to that again, around the time, close to the time that the direct testimony by Mr. Colton was filed.
And did you see that the motion to intervene identified energy burden and environmental justice as issues?
I do recall seeing those there identified generally, yes.
Okay. And the intervention was granted on, I'll represent on July 13th, 2022. Do you have any reason to dispute that date?
No.
Okay. At the time that Walnut Way submitted its motion to intervene, or at the time that intervention was granted, anywhere in that range, Wisconsin Electric didn't approach Walnut Way with any proposals, knowing what its interests were, correct?
At or around the time intervention was granted, and I believe you stated there was a date in July. I don't recall anyone, I would say from my area, the regulatory or legal, contacting or talking to Walnut Way about its proposals. As to the overall company, and if there's other communications between the Walnut Way organization and the utility, I couldn't speak to, but there's none that I'm aware of.
And other than the offer in your rebuttal testimony at page 8, line 7 to 10, to informally collaborate between now with Walnut Way between now and the next rate case, Wisconsin Electric has not approached Walnut Way with any proposals to deal with energy burden or environmental justice issues, correct? Any substantive proposals?
Yeah, I with that clarification, I would say that's correct.
Okay. And those answers are all the same for Wisconsin Gas, right?
Correct.
I just want to interject just to clarify that Attorney Westerberg used the term informally collaborate, but your testimony actually relates to having the commission adopt an order point requiring the company to confer and collaborate informally. Okay, so still would be ordered by the commission. Correct,
Your Honor. I think the distinction I was using with the word informal meaning outside of a generic type a docketed proceeding versus meeting with the Walnut Way organization to work on something we could perhaps bring to the commission and then propose in the docket.
Okay, got it. Thanks.
In following up on that question, you would disagree. You had disagreed with one aspect of a collaboration process that Mr. Colton suggested, which was to for the utilities to pay $250,000 to facilitate stakeholder participation, correct?
That's correct.
Okay. Just looking at some of the other things that the applicants are seeking to recover in rates. Looking at some of the data request responses we saw, and we could pull these up if you'd like. $658,000 in this docket for institutional or goodwill advertising. And $86,000 for promotional advertising. In fact, Your Honor, why don't we just pull that up? It was PSCW FR 13.
Okay, off the record, I think you have on your list, I'll just show you what I'm seeing here. So there's a,
Yep, that one, the goodwill advertising one.
okay, so are we going to mark this?
Yes.
So we're, can't see Debbie, here we go. So let's get on the record. Take your time, it's okay. All right, what is this one? Dukas 11. And that is the, Dukas 11 is the, okay, I see PSCW FR 13 data request response. Okay, great. Go ahead.
Okay. So is it your understanding from this response that Wisconsin Electric is seeking to recover in this test year $658,000 in promotional or institutional or goodwill advertising?
That's not correct.
What is your understanding?
Well, a lot of these dollars are shareholder dollars. They're this again, I may not be the, I may have to ask Mr. Zagantz, who's an upcoming witness, could maybe address this more detail than I can, but my understanding is this is a, this information is provided as a required piece of information required when we file our application. I do believe that staff recommends disallowing them, and we agree, and these are intended to be funded by shareholder dollars.
Okay. So account 930 is not funded by rates?
I would say I would have to defer that to Joe Zagantz, who will be testifying later this morning, or later today.
Okay, so you don't know.
No, without without checking legally, I would have to. I would cannot answer that as I sit here.
Okay, thanks. Can you say whether industry association dues are included in rates?
Again, subject to check. I believe there's a sharing of those. Some of those are shareholder dollars and some of those are recovered in rates. Depending on whether or not there's a distinction between, in general, whether or not the dollars spent are for the benefit of ratepayers, customers, versus not. So there's a sharing that's done, but.
Okay.
So let me interject. Would it be better to address these questions to witness Zagantz?
Yes, Your Honor.
So there's the dues fees, goodwill, industry association dues, outside vendors, including legal. Are those all accounts that witness Zagantz could better testify to?
In detail, yes.
Okay.
I would say yes.
Okay. And then I'm not sure what. Okay, so let's reserve those questions. And he's getting questioned, right? We didn't excuse him.
Right.
And then we'll have to remark that exhibit. But anything else then in terms of these data requests?
No, I can reserve those questions for another witness. And I think that they would probably be in the staff data request response anyway, if I'm not that exhibit, if I'm not mistaken.
Okay, so no, I don't believe so. So staff did file what it has so far as the data request response exhibit. So you can always refer to that at this time. But my understanding is that because these are data requests that are standard, that come with the application, those are not included in the staff data request response exhibit. So putting them in is fine. It's just, putting them in individually is fine. But, and if you need them, we should do that. But don't assume they're in because of the data request response exhibit. But what we can do is reserve those questions about specific accounts to witness account.
Okay, that sounds good.
And we'll have to strike the Ducas 11, or we won't receive it. I think it's already marked, but it won't be filed or received. So.
Okay. I also want to pull up while we're in that folder 2WWDR4. Oh, and I can ask a few questions about that.
Okay. So that's Ducas, and so you'll be offering that. That's the Ducas 12 then.
Yes.
All right, is that the right document?
2WWDR4, but we can ask about this one too, actually, while we have it up.
All right, go ahead.
That's fine. Thanks. Mr. Ducas, do you have, take a minute, if you would, to review this exhibit 2WWDR6. We've included both the original response and a supplemental response. So there's 2 pages just combined into one exhibit. Okay. And just before we get to this, generally speaking, did you have a chance to look at the documents that Walnut Way sent out as potential hearing exhibits before the hearing today?
I did not.
Okay. This request asks about whether the company has prepared or possesses certain studies about the relationship between disconnect notices and either the reduction of residential arrears or increase in residential payments. It was answered by Dave Barron. Do you have any reason to disagree with the answers he's provided in these data request responses?
No, I do not.
We'd offer that one, and I have the same question for 2WWDR4.
So any objections to Ducas 12? Okay, that's in. I'm having, is there anything? So it's the DR6.
Yes, Your Honor.
We're good with that? Okay, so I'm having trouble finding DR4. Maybe it's labeled something else.
It's in my version.
It didn't come across for us either.
Okay.
Well, if you have the birth number, I can grab that from. And
sure. It's 446.
Let's go off the record and just give me a minute. I got to get that set up for that. So where are you? I need this part of my screen. I need to do this. All right, what's the number?
446212.
So DR4. Okay, so let's bring that up. All right, so let me mark that Dukas 13. And that's the document you're looking for, right?
That's right.
I gotta just bear with me for a second here. All right, there you go. Okay, let's get on the record.
Thank you. And again, sorry for that complication.
Let me just mark for the record. So we have 2 WWDR4 is a Dukas 13. Go ahead.
Thank you. Mr. Idukas, and I realize so this is we're looking at the response to 2 WWDR4, asking for all written reports, evaluations, assessments, presentations, or other written documents which identify metrics by which you measure electric bills are affordable. And Mr. Stasek, I see, provided this answer, but you have no reason to disagree with his response there at the bottom, correct?
That'd be correct.
Okay.
You're offering that for the record?
Yes, please.
Any objections?
No.
Okay. All right.
And lastly, we had asked a similar question when we can pull up the data request response for this if you like, about whether the utilities had assessed or possessed any reports discussing the mobility of households in your service area. Do you recall any reports that the company possesses to that effect?
I personally don't have any knowledge or any reason to disagree with what was said in our data request response. Okay. But unless I saw the response, I couldn't state specifically, sorry.
Okay, sure. Well, let's just pull that up and hopefully it's in your folder, Judge.
Which one would I look for?
2 WWDR8.
So let's do this first. Let's make that Dukas 14. And that's the document.
Yes.
All right, go ahead.
I refamiliarized myself with this response. I'm ready to answer any questions on it.
Okay, and you don't have any reason to disagree with the answer that the joint applicants do not possess data reports, assessments, or other written documents that analyze the mobility of households within their service area?
Correct. I have no reason to disagree with this response.
Okay.
All right, so any objections?
No.
Okay, that's in the record.
Thank you. Those are all the questions I have for this witness at this time.
All right. Any other cross? Okay, any redirect?
Just a couple questions, Your Honor. Mr. Idukas on cross, Ms. Westerberg asked you a series of questions about your context with Walnut Way after it filed its request to intervene. Do you recall that?
I do.
Did Walnut Way's intervention notice ask the utility to prepare proposals for it to review?
My recollection from having reviewed it is that it did not.
And is it the utility's general practice to approach rate case interveners before hearing from those interveners about what they may be proposing in a case?
Objection leading.
Overruled. Go ahead.
Typically, and again, we did have, outside of any, efforts to meet and confer, discuss settlement, I would say no. That's typically our practice would be to wait until hearing from the intervener or party as to what they are looking for before we would approach them to discuss discuss a proposal.
Thank you. Nothing further.
All right. Okay, great. Well, thanks very much. You're excused.
Thank you.
Okay, who do you want to take next?
We've got a couple witnesses up for whom we don't think there's any cross, so hopefully we can get through them.
Nelson, right?
This is Mr. Pecorelli.
Oh, yeah.
Sorry.
That was not close enough. Oh.
Another good beard though. Yeah.
That's,
Have facial hair.
let me just switch your names here so I don't forget. Let's do it from the screen. All right, let me swear you in. Swear or affirm, tell the truth, the whole truth, and nothing but the truth.
I do.
All right, great. Go ahead.
Good morning, Mr. Pecorelli. Could you please state and spell your name for the record?
Jared J. Pecorelli, Peccarelli.
Did you prepare or cause to be prepared direct and rebuttal testimony for this case?
Yes, I did.
If I asked you the questions in your testimony today, would your answers be the same?
Yes, they would.
Did you prepare or cause to be prepared 2 exhibits?
Yes, I did.
Are those true and correct to the best of your knowledge?
Yes, they are.
Do you have any corrections to either your testimony or exhibits?
No, I do not.
Your Honor, I think you just had a couple of questions for Mr. Pecorelli. And actually one of them with regard to that Google Community Mobility Report was only applicable to the WPS case. I think it just inadvertently got carried over.
That's
But-
not a surprise. Okay, thanks for mentioning that.
Sure. Sure.
So that's the only comment I think I had for him. Or was there another?
Yeah, there was one other. It was the explanation of the loss of the 3 wholesale service
okay.
contracts.
You know,
I'm sorry, Ms. Phillips, I couldn't hear what you said.
Sorry. Yeah, it was Judge Newmark also asked about an explanation of the loss of the 3 wholesale service contracts that are identified in Mr. Pecorelli's testimony.
Yeah, and before we get into that, I just wanted to tap in with commission staff and ask if they need that information or if they know it already. Any ideas? Sorry to do that on the fly, but
No, commission staff doesn't need that information.
okay. So
Thank
I'm
you.
gonna, so I'll forgo those questions just to move things along, and we'd have to go into closed session. So
Great. Yeah, we received that information or the information that we needed as part of a data request response.
I should have thought of that yesterday. Okay.
No worries.
So I have no questions then for the witness. I'm sorry, I didn't realize the Google report didn't carry through to this case. So I just guess no one had questions for him at this point. Is there any cross for the witness? No? All right. So that's it. You're excused. Thanks. Oh, you're changing everyone. Okay. All right. Let's get off the record for a second. Keller, correct?
And James Goldschmidt for the court reporter.
Thank you.
Okay, I think we're ready. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right.
Good morning, Ms. Keller. Would you please state your name for the record?
Kim Keller.
Ms. Keller, did you prepare or cause to be prepared and filed in this docket direct, rebuttal, and sir rebuttal testimony?
I did.
And did you also prepare or cause to be prepared and filed 3 supporting exhibits?
I did.
To the best of your knowledge, were your testimony and exhibits true and accurate when they were filed?
They were.
Do you have any changes or corrections to your testimony or exhibits?
I do not.
Witness is available for cross.
Okay, and I don't think I included any objections to sir yet, so let me ask, any objections to that?
Your Honor, commission staff doesn't have an objection, but we do have one question for cross.
Okay, let's handle the objections first. I just want to make sure everyone had enough time to read the sir. Okay, and it is substantially the same as yesterday's filing. So in the pub service case, so it should really be not much surprise here. Okay, so we'll accept those for the record. The other documents are already accepted. So let's have cross. Any questions from interveners? No. Okay, and how about commission staff?
Yes, we do have one question. If I can direct your attention to your sir rebuttal at the top of the 3rd page, lines 3 to 6.
Off the record for a second, just let me.
Sure.
Quickly. And page 3.
Yes. Specifically lines 5 and 6.
Okay, let's get on the record.
Sure.
Okay, go ahead. So go ahead. Just direct us to that testimony.
Yes. What is the specific dollar value for 10% of cone?
2416 a megawatt day.
Thank you. That was our question.
Okay, great. So off the record, Debbie, did you hear that okay?
Yeah.
Okay, for some reason my speakers aren't working as well as yours, so I'm glad. You're the
Well,
person.
they're right in my ear. 2426 a megawatt day.
Okay.
2416.
Oh. Okay.
Yeah, corrected. Okay. That was just luck, by the way. Okay, so let's get on the record. Any other questions? No? How about redirect?
No redirect, Your Honor.
Thanks very much. You're excused.
Next witness is Bill Kordecki.
Cheat on this one. Okay. Just a brief recess while I extract this cat from here. Okay. Let's get you sweared in. Now raise your right hand. You swear or affirm to the truth, the whole truth, nothing but the truth.
I do.
Right, go ahead.
Please state and spell your name for the record.
William J. Korducki, Korducki.
Did you prepare or cause to be prepared direct and rebuttal testimony for this case?
Yes,
If I asked you the questions contained within your testimony, would your answers be the same today?
yes,
Did you also prepare or cause to be prepared 12 exhibits?
yes,
Are those true and correct to the best of your knowledge?
yes,
Mr. Korducki also filed errata, errata was filed for Mr. Korducki's exhibits yesterday. Other than the errata, do you have any other corrections or modifications to your testimony or exhibits?
no,
Thank you. Your Honor, Mr. Korducki is available for cross-examination.
All right, any questions?
Yeah, Walnut Way has some questions.
All right, go ahead.
Thank you, Your Honor. Good morning, Mr. Korducki. I'm Krista Westerberg representing Walnut Way. I have some questions for you about Korducki exhibits 7R and 8R.
repeat that again?
Yes, 7R and 8R. We can start with 7R.
Yes, please.
Okay, so I wanted to look at this first page that the judge has pulled up here about residential gas rates. And I think your testimony is the basis for some of the figures that have been circulated as to what an average increase can be expected to be as a result of the increase requested in this case, right?
Yes,
Okay, so what I understand, your average of $6.39 months of an increase for Wisconsin gas is, or for Wisconsin WEPCO gas is $6.39 a month. Is that right?
you know, offhand, I would have to check that number.
Okay. Did you derive that number from averaging the usage levels that are depicted above that line that runs through the middle of the page?
The usage level that is depicted by that line would be the average for the forecast of the residential class.
Sorry, for the,
Residential class that
did you say for the 4 tests? Forecast?
the natural gas forecast for the test year 2023 forecast average residential usage at 817 therms.
Okay, it's off to. Can you get a little closer to the microphone? That may be.
And the last figure, 800 and something, 817?
Yes, that's 817 therms.
Thank you.
Line.
Okay, got it all. Okay, let's get back on. And let me just say off the record, Attorney Westerberg, if you could direct us a little bit better to what numbers you're pointing to by giving a column and row, so we know where you're headed.
Sure. Well, that was basically my question, is how the average of $6.39 was derived, and seeing if how the relationship of that number to the line depicted that crosses all of the columns on this page.
Yeah, I just don't see the $6.39. Is that a figure from another exhibit, or am I missing it here?
I don't think it's depicted on the exhibit. The original version of Exhibit 7 had that to the right, in a right column, to the right of percent of change. Do you recall that, Mr. Korducki?
Oh, we're off. Oh,
We were off. Yeah.
We're off. Yeah. So do we need that, or is it just, am I just leading us somewhere we don't need to be? I just wanted to make sure you're pointing to where you were headed. So let's just pull up the original.
Well, the Excel version of it had it. Maybe it's on the first page of this one. This is ag, so we would want to scroll up.
This is page 2. That's
I don't see it on this version. It was on, like I say, an Excel version. But I don't think it really matters for the purposes of my question. I just wanted to confirm that the $6.39 a month calculation is connected to that line that was on the Exhibit 7R in some way.
Yes, it is.
so but off the record still, I'm just curious, like if you are producing PDFs from Excel files, we should have all of those numbers depicted on the PDF. Maybe it's just something was printed incorrectly, but probably the best thing to do is refile this with the column to the right.
Okay, Your Honor, Mr. Krodaki can just address that right now, as far as the difference between what's on the Excel file and what's in the PDF.
Well, I think we need to have it filed though, because it was originally filed as an Excel.
Yeah, I have to, I'm not sure, Your Honor, if it was originally filed as an Excel. I'm told it was not filed. It was filed as a PDF.
Okay, so then that number comes from where?
I'm not sure, Your Honor.
Okay, well, let's just leave it at that. So that's fine. It won't be in the record either way, I suppose. So, all right. Okay, so anything else with Exhibit 7?
Yeah, and I can tell Your Honor where I was getting that that reference, just for the sake of completeness, it was PSC reference number 443779. And that is an Excel file.
And is that a data request response, or?
It says it's an exhibit. It was filed as an Excel file.
Okay, well, that's fine. All right, so any other questions for Exhibit 7?
No, we can move on to 8R.
So let's get back on the record.
So Mr. Kordaki, this is the natural gas, the exhibit that was filed for Wisconsin Gas, and the customer level comparison of revenues at present and proposed rates. Would you agree?
Yes.
Okay. Just looking, and this is the basis, is it to your understanding that Wisconsin Gas has projected the average increase in a gas bill to be $5.94 a month?
Yes.
Okay, and that's based again on this exhibit, where that average comes in with that line, is that right?
Yes.
Okay, and it's connected to usage.
Yes.
Okay, so obviously the more gas you use, the higher your increase will be, right?
Yes.
And this exhibit is not accounting, obviously, for the increase in natural gas prices. Would you agree?
Can you repeat the question?
Yeah, to what extent do these figures about the average expected increase account for increased fuel costs, if at all?
It does not reflect the increased fuel costs.
Okay, so if WEC is projecting that this winter, the natural gas prices can it be expected to lead to a $20 to $30 increase per month for the typical customer? That would be on top of what you're projecting in these exhibits, right?
Yes.
Okay. So, and you would also agree that many customers of the gas utilities are also customers of the electric utility, right?
I don't know.
Okay. Well, assume for me that the, well, let's pull up exhibit, this will be an exhibit to Mr. Nelson's testimony, Nelson Exhibit 10. And I'm looking at the last page. Have you seen this document before or something close to it?
Yes, I have.
Okay. The tornado sirens just clicked on here in Madison, so hopefully you can still hear me. But and this is, we've been talking about the projected average increase in natural gas cost for Wisconsin gas and Wisconsin electric gas customers. And you see there on the top, there's also a projected increase for electric, correct?
I would say that's correct. I'm only answering for natural gas.
Okay. You had said in your, well, between the increases in natural gas prices plus the rate increase that's sought here, if the increase attributable to natural gas prices is $20 to $30 and the increase attributable to the rate increase is about $6, we could be looking for some customers at a $26 to $36 increase per month. Would you agree?
It would depend on the customer, but generally you could make that assumption, yes.
Okay. And you had mentioned in your direct testimony that you agree the avoidance of rate shock informs your rate design analysis, right?
Yes.
Okay.
Krista, could you point to where in your testimony, in Mr. Kradaki's testimony you're referring to, please?
Sure. Page 3, line 18. Did you, and you don't think that the $5 to $6 by itself creates rate shock?
I'm only answering to what is presented in testimony and exhibits. If you're asking me the general trend, is $5 or $6, it depends on the customer.
Okay. And what the customer can afford?
As different as customers are, any variable that would make them different, yes.
Okay. Let me ask this a different way. Have you considered all of the costs combined, and by that I mean the rate increase plus the increase in natural gas process, and whether it would cause rate shock for residential customers?
Yes.
And have you, your testimony does not discuss those increase in natural gas prices?
Yes.
But you would agree for some that the increase in residential rates plus the increase in natural gas prices could cause rate shock for some residential customers?
Please repeat again.
Could you read back the question?
Question, and you would agree for some that the increase in residential rates plus the increase in natural gas prices could cause rate shock for residential customers?
Your Honor, I'm going to object to this question. I think it's beyond the scope of his testimony. I mean, Mr. Kradaki takes a cost of service study and he creates a rate design based upon that. I don't think that Mr. Kradaki, I believe this question is beyond the scope of his testimony.
Mr. Twardowski talks about rate shock in his testimony, and I just want to know if what he's considering as part of that when talking about natural gas prices.
And I believe Mr. Twardowski's testimony speaks for itself. I mean, I guess I'm still trying to get to that part of his testimony, Krista, where he's talking about rate shock.
Well, it's right there on the screen. So we don't have many additional questions, but I would like an answer to this one.
Okay, so I think that maybe what's being confused here is the definition of rate shock in relationship to the witness's testimony. So maybe it would clarify if the witness could explain what he meant by rate shock when he said it on page 3 of his direct.
With respect to the reference of rate shock, that is in the context of the revenue allocation represented by the rate design of the cost of service studies that the company had provided by other witnesses.
Okay. Okay, thanks.
You wouldn't, you would agree though, Mr. Twardowski, that there are maybe other aspects of rates that may cause rate shock beyond just cost of service study, right?
Your Honor, I'm going to object again to that question. It's really beyond the scope of Mr. Twardowski's testimony.
Well, he is the rate designer, right?
Yes, he is, Your Honor, but he takes what the cost of service study on the gas side and creates rate design, but that's based off the gas cost of service study, which Mr. Twardowski does not perform.
I'm going to object to the speaking objection. I'm just wanting to know from Mr. Twardowski what things he considered when he considers rate shock. And I know he said he's directed that question to the cost of service study, but I want to know if he's aware of other factors.
Okay, does he discuss that in testimony?
Well, he discusses the concept of rate shock.
Right, in the context of cost of service study.
Yeah, I think that's a hyper-technical distinction that ignores the fact that there are other things affecting customers here that Mr. Twardowski would have knowledge about. He just talked about, he agreed with, we already talked about the increase in natural gas prices and there weren't objections to those questions.
Yeah, okay, I'll allow him to supplement that answer to explain his understanding of rate shock generally.
With regard to rate shock, in the context of this testimony and exhibits, it would demonstrate that you have this group of customers not receiving a more substantial rate increase than, say, any other group of customers, and without justification. So in terms of rate shock, we're looking for something that would be a substantial increase to customers over and above what is called for in the cost of service study, and what would be called for in our supporting analyses.
Mr. Twardowski, is your understanding of the term rate shock, the idea is to avoid a large increase to customers that would be shocking to them, right? Just generally speaking.
Your Honor, I'm going to object again. This is really, again, beyond the scope of his testimony. He just mentioned that his rate shock was in the context of the cost of service study. He takes that cost of service study and creates a rate design based off that. I believe Mr. Twardowski already answered Ms. Westbrook's questions.
Already answered, he did not consider the cost of the commodity in terms of analyzing rate shock. Is that already on the record?
I believe so. Is that, I guess we could just ask the witness to confirm that.
Yes.
Okay.
So I think that's as far as we're going to get with this witness.
Okay. Then I have nothing further.
Okay. All right, any other cross?
Excuse me, Your Honor, Steve Heinzen for the Wisconsin Industrial Energy Group.
Okay, go ahead.
Sure. Good afternoon now, Mr. Kurdecki. I just want to have one or two questions to follow up on the testimony just a moment ago. But in connection with the particular avoidance of rate shock that you have in your testimony, is rate shock something that you need to consider for all customer groups?
In the context of rate design, you're dealing with all customer groups and you're trying to balance their impacts. So yes, consider it for all groups of customers.
Okay, thank you. I have no further questions.
All right. Thanks. Other cross? No? Okay, so before we go to redirect, could you please put that mic even closer to witness Kurdecki? Because it seems, maybe I'm just having trouble hearing him, but okay, any redirect?
Your Honor, I just a couple of questions. Mr. Kurdecki, you recall some questions you were asked by Ms. Westerberg about the $20 to $30 increase that she referenced as part of an overall increase as a result of the price of gas costs increasing this winter. Do you recall that question?
Yes, I do.
Could you just confirm that the $20 to $30 increase that she's referencing also includes our proposed increase based on your own analysis?
Objection, lack of foundation.
Overruled.
Yes, it does.
All right, thank you. No further questions.
All right. Thanks, you're excused.
Yeah, joint applicants call Aaron Nelson.
There we go. All right, raise your right hand. Swear or affirm, tell the truth, the whole truth, nothing but the truth.
I do.
Great, thanks. Go ahead.
Mr. Nelson, please state and spell your name for the record.
Aaron Nelson, Nelson.
Mr. Nelson, did you prepare and cause to be filed direct, rebuttal, and surrebuttal testimony in this case?
I did.
If I asked you the questions in that testimony today, would your answers be the same?
Yes.
Did you also prepare and cause to be filed 18 exhibits?
I did.
Is the information in those exhibits true and correct to the best of your knowledge?
Yes, it is.
Your Honor, I can go on and ask the questions you had.
Okay, great. I just want to make sure I did copy over that ratio question from Pub Service. I did not check if it was accurate for this case.
Mm-hmm. Yeah, I think there are a couple other
adjustments,
changes as well. Like WEPCO doesn't have a response rewards program, so.
Sure. Yeah. Thanks.
Mr. Nelson, can WEPCO and WG's load information for an individual RG1 customer be analyzed to determine that customer's on-peak and off-peak load?
Yes, Wisconsin Electric has the ability through its AMI network and infrastructure to analyze interval data for all types of customer classes, including determining whether or not, or which time period on or off peak load occurs.
I'm sorry, on or off peak, the load occurs?
That load occurs.
Thank you.
Is WEPCO proposing to change the current ratio of on-peak to off-peak residential energy charges for RG3 customers.
Just to clarify, at Wisconsin Electric, the residential time of use rate schedule is RG2. And Wisconsin Electric did not propose to adjust its ratio of on-peak to off-peak energy rates.
What are the residential time of use tariffs for Wisconsin Electric? And I'll ask you how many customers exist for each.
So there's one residential time of use rate schedule at Wisconsin Electric. That schedule has roughly 15,000 customer accounts.
And that's RG2?
And that's RG2, correct.
How many commercial time of use tariffs does Wisconsin Electric have?
There are several. To start, the small commercial CG6 rate schedule has roughly 6,400 customer accounts. The medium-sized commercial CG2 has roughly 8,800 customer accounts. And then the larger commercial CG3 has roughly 6,100 customer accounts.
What activities does WEPCO undertake to inform eligible customers of their time of use tariff options?
For small and medium-sized customers, Wisconsin Electric utilizes its website where educational materials exist, including details of whether or not the particular time of use rate schedule would be beneficial for a particular customer. In addition, Wisconsin Electric provides periodic bill inserts that supply rate options available to each customer within a particular class. As it relates to larger customers, Wisconsin Electric has a key accounts area, and they specifically work with large customers to plan and ensure that their energy needs align with the rate that they take service from.
Your Honor, we see your direction to file Nelson 19. We'll do that. With that, I believe Mr. Nelson's available for cross unless you have further questions, Your Honor.
Yeah, just one follow-up. Thank you very much for doing that. Yeah, just my understanding is that Wisconsin Pub Services account system can be programmed to automatically flag residential customers, individual residential customers, if they can save using a time of use rate. I'm sorry, can flag RG1 customers. Okay, let me start over. So I understand that Wisconsin Public Services account system can be programmed to flag individual RG1 customers if they could save by taking service off the RG3 rate. Is that correct?
As it relates to Wisconsin Electric, that is not in place today. While that potential may exist, I'm not sure to the extent that work would be, what work would be required to fulfill such a task.
Okay. All right. That's all I had. So any other cross?
Yes, Your Honor, Walnut Way has a bit.
Okay. Go ahead.
Thank you. Good afternoon, Mr. Nelson. I'm Krista Westerberg on behalf of Walnut Way. Between your direct and sir rebuttal testimony, you decided that more of the revenue allocation for electric should be directed at residential customers, correct?
Between direct and sir rebuttal, my recommendation shifted to take a more neutral approach to revenue allocation, which balanced the assigned revenues across the classes according to the cost of service data within the record.
And that wasn't exactly my question. The result of that was that the more of the allocation is assigned to residential customers, right?
At my recommendation in my SOAR rebuttal, yes, that's correct, as compared to my direct.
Okay, and so at your direct on page 5, you had recommended 10.71% to residential. Does that sound right?
Could you repeat that reference, please?
Sure, page 5.
Okay, so on page 5 of my direct testimony, the cost of service study suggested 10.71% be allocated to the residential class. However, through designing rates and allocating revenues, only 5.44% was allocated to the residential class.
And you were persuaded that that number, at least the cost of service study suggested increase should be increased, was attributable in part to the testimony of Mr. Muehlmans for PSC staff and Ms. Manny for WEG.
In part, yes, that's correct.
Okay, and then another component that you discuss on page 3 of your SIR rebuttal was worsening economic conditions like higher interest rates, inflation, and lower stock values, correct?
Yes, those are some of the additional factors that persuaded me.
Okay.
Sorry,
go ahead.
Where were you on SIR rebuttal there?
Page 3, about line 8.
Thanks.
You would agree that those worsening economic conditions also affect residential customers, generally speaking?
Yes, generally speaking, they would impact all customers.
But you're not offering testimony about whether those conditions affect residential customers more or less severely than other customer classes, right?
I did not specifically recommend one class of customers were more impacted by those factors than others.
Okay. Could I have you look at Exhibit 10 to your testimony? It's what we were looking at a moment ago with Mr. Korducki.
Okay.
On the last page again. Would you agree this is a flyer that's been sent out to customers describing the rate increase proposal?
Yes, based on the direct filed case.
Do you have any adjustments to these estimated increases based on the changes that we just discussed between your direct and SIR rebuttal?
So as it relates to these 2023 projected increases, there's a number of factors that would influence the final outcome, including any changes to the revenue requirement. So at this time, I do not have any updated numbers based on any further testimony.
Would you expect that all other things being equal and just looking at the changes that you've recommended in your testimony and your SIR rebuttal, that these numbers would increase for residential customers, electric customers?
With all other things held equal, based on the revenue allocation in my SIR rebuttal, yes.
And do you know by how much more that would increase? That $6 figure?
Objection asked to answer.
I think he just testified that there would be an increase, and now I'm asking about how much more is that increase?
He also testified that he didn't have updated numbers.
Yeah, but he was able to testify that all other things being equal, he could say that there would be an increase. So I'm just asking, with that same set of assumptions, what would the increase be?
He could try to answer that. That's fine.
And sitting here today, I don't have an estimated dollar figure.
Okay.
So,
and Would you, to your knowledge, are many of the electric customers also customers of the gas utilities?
I don't know.
Okay. You didn't account for fuel costs when you were discussing the cost of or the revenue allocation in your testimony, right?
My testimony would have been based on the forecasted costs at the time of the testimony. So no, nothing furthering was expected.
Okay. So to the extent you were considering things like rate stability and gradualism and factors in setting rates, you were only looking at the factors described in your in the cost of service study, right?
Correct. As it relates to the cost of service study, my role is to provide rates that reflect cost of service.
Okay. And would you agree there can be other things that might affect affordability and rate stability that weren't accounted for in your testimony?
I'm not sure what you mean by affordability.
Would you agree that things like fuel costs or the customer income might affect whether a particular customer, whether an increase is in fact gradual for a customer?
Gradualism, as it was used in my testimony, was in reference to the cost of service as far as directionally moving towards what those results would suggest.
Okay, so it didn't account for what would be gradualism to a particular customer on the receiving end of a rate increase.
Correct. That would vary by customer.
Okay, that's all I have.
Okay, other cross? Redirect?
No.
All right, thanks, you're excused.
Thank you, Your Honor.
Okay, who are we calling?
Your Honor, we're calling Steve Pecca.
All right, great. So let's swear you in. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Please state and spell your name for the record.
Stephen A. Pecca, P-E-C-H-A.
Did you prepare or cause to be prepared direct testimony in this case?
Yes, I did.
If I asked you the questions contained within your direct testimony, would your answers be the same today?
Yes, they would.
Did you also prepare or cause to be prepared 4 exhibits?
Yes, I did.
Are those true and correct to the best of your knowledge?
Yes, they are.
Do you have any corrections to your testimony or exhibits?
No, I don't.
All right. Your Honor, Mr. Pecca is available for cross-examination, although I know you did have one question for him. If you want to go ahead and ask your question.
I can ask that first, sure. Let me just grab that testimony. Okay, Oh, welcome witness Pekka. Just had a question for you regarding the storm hardening program. And it just, because it mentioned that the company had considered several alternatives to the proposed storm hardening program. And I was just wondering if the record includes at this time any documentation that analyzes the costs and benefits of the proposed program compared to the alternatives that you mentioned.
Good afternoon, Judge Newmark. We have no formal documentation prepared to enter into the record at this time. However, I can offer that we intend to apply our similar electric distribution reliability planning criteria and our experience gained in prior resiliency efforts, as I do reference in my testimony for the system modernization and reliability project in the Wisconsin Public Service Territory, as well as the work that was completed recently in the Neenah, Wisconsin area in the We Energy Service Territory. We'll apply this methodology to the selection and implementation of these future resiliency projects.
I'm sorry, you kind of cut out there. Will apply.
And maybe just slow down a little bit because she's trying to type.
Sure. I can just kind of restate that a little bit. Yeah. So we intend to apply the same electric distribution planning reliability criteria and the experience we gained in our prior resiliency efforts, as I referenced in my testimony, including the system modernization and reliability project in the Wisconsin Public Service Territory, as well as our resiliency efforts in Neenah, Wisconsin in the We Energy Service Territory. That methodology will apply to the selection and implementation and evaluation of those future resiliency projects that we identify as part of our proposed storm hardening program.
Okay, so just to be clear, you're not filing anything in this case in addition to what's already been presented.
That is correct.
Okay. Okay. So is there anything that we have that the commission may have on file for the pub services system modernization and reliability project that we could refer to in terms of what the plans are for, well, I guess, okay. So if I understand your question, it's you're providing a source for how the project would be implemented. Is that correct?
I can elaborate a bit there with respect to the selection and implementation of these projects. We consider a do nothing approach or maintain existing system where we don't already have implementation of resiliency technology or construction to be not an area that or an alternative that we would consider. So application of resiliency efforts across our system is an ongoing effort in which we're pursuing in light of severe weather and other impacts that we've experienced in recent years. So I guess in consideration of other, say, non-alternatives or maintaining existing system where we have not implemented or constructed or done work to the extent that these resiliency efforts would obtain, it was not that was not an alternative, or the do nothing alternative was not an area that we were going to rest with.
Okay, so just in terms of the options that the alternatives that you laid out in testimony, there's the maintaining current system maintenance practices. So you don't have any documentation that that balances the cost and benefits between the program and maintaining current system and maintenance practices.
Just going back to the goal of the program is to increase the resiliency of the entire system, reducing outages, as well as reducing restoration times in the event of severe weather. And that's where identification and leveraging areas that have been rebuilt recently, overhead portions of the system, by enhancing those areas with increased or use of technology, sectionalizing, automation. And those techniques would be used in areas that would be reaching end of life in portions of our service territory that are currently overhead construction. We would be considering undergrounding efforts to support that resiliency effort. So a combination of those three strategies is what's being proposed as part of that goal to achieve our resiliency targets here.
Okay. But there's nothing documenting that, you know, this line going over this road, it should get undergrounded and it's going to be costing so much, and it's better to do that than keeping the overhead line in place.
Yeah, those details will come out when the projects are scoped. The areas that are identified is the first step, but the scoping of the project will determine the manner in which the resiliency effort would unfold. And that would be done through what I had mentioned is reliability planning criteria and modeling, where we would certainly evaluate the constructability and the alternatives that would be used to build that more resilient system.
Okay, I understand that part. Okay, I don't want to beat this to death, but you do have a map, right, in terms of where the project was planning to go?
Yes, we have future project areas that have been identified in two timeframes. The first 5-year timeframe, 2023 through 2027, and then 28 through 32.
Okay, and are those exhibits in the case?
I believe I do have exhibit number 4.
Yes, Your Honor, it's exhibit PECA 4.
Thought I saw it before. And oh, sorry. Okay, so but in this map represents areas where it's just a general area. It's not specifically saying we're going to replace all the lines in that block of colored space.
Yes, that is correct. It's circuit topology. So these areas and polygons are identified by a geographic region defined by a circuit service territory. The exact extent of and implementation of sectionalizing devices, undergrounding, and automation will be determined based on that analysis in terms of its reliability, improvement, and resiliency impact.
Okay.
So these were the areas that were identified. And again, in the first 5-year time frame, the darker shading represents areas where we intend to begin with. Often these are going to be areas where either the system was recently rebuilt and we're able to apply technology effectively in a shorter term. Undergrounding projects by nature tend to require time to implement with additional permitting and other pre-construction activities. So that work tends to lag in comparison.
And then the budget for the program, is that something that you offered in the case?
Yeah, we did an estimate based on the total number of additional devices and ability to underground segments of our system consistent with other asset renewal plans we have in place at the company, including continued conversion of our lower voltage systems, the 4 kV system, which is nearly complete at this time, as well as our 8 kV distribution system, which has been significantly converted in many areas of the service territory, but still serves a pretty large number, about one third of We Energy's customers yet.
So then how did you come up with the estimate for this test year based on, from what I understand, that you're not really sure exactly where the program is going to be implemented at the moment? You're going to be looking at places to put in the implementation.
We're already undergrounding and performing work that is consistent with the storm hardening and resiliency work. This effort increases that work and projects to the order that's identified in my testimony, 60 to 80 miles of undergrounding annually, as well as the installation of additional overhead devices and distribution automation. So our capability to identify, develop, and construct these projects is well within our capability and directed at those areas that we would expect it to target based on historical reliability performance, as well as the condition of our system, which is also included in my testimony as well.
All right, so you know how much you want to do in a certain time frame. You just don't know where it's going to go exactly.
And that would be how we would certainly prioritize that work, as well as other factors.
Okay. All right, great, thanks. Okay, great. That's all I had. Any other cross? Redirect?
Your Honor, Walnut Way has some cross for Mr.
Okay.
Pecca.
Okay, go ahead.
Thank you. Good afternoon, Mr. Pecca.
Good afternoon.
My name is Awais Khalil. Nice to meet you. A couple of questions, and we're going to look at both your testimony as well as your exhibits. Look at your direct testimony to start referencing page 2.
Just give me a minute here. Okay.
Now, you explain that as you've talked a little bit about with Judge Newmark, that the purpose of your testimony is to discuss Wisconsin Electric storm hardening plan, right? Correct?
That is correct.
Yeah. And per your testimony and several exhibits, you explain over a 10-year period a general plan on behalf of Wisconsin Electric to harden or improve the reliability and resiliency of your distribution systems against severe storms like the one seen in Milwaukee and the surrounding areas on August 10, 2021. Is that accurate?
Yeah, that is correct.
Okay. Now, I'm going to reference Exhibit 1. Your Exhibit 1.
Okay, let me grab it from at this point.
Thank you. Now, Exhibit 1 is your exhibit. It's a map showing the overhead distribution system infrastructure that's greater than 50 years old in Wisconsin Electric's service map, correct?
Yes, that's correct.
Is it fair to say that the overhead distribution system infrastructure that's greater than 50 years old is disproportionately clustered in and around the immediate area around the city of Milwaukee? Is that accurate?
Yeah, the characteristic of We Energy's suburban urban 8 kV system is the predominant driver of what's represented here. This is the area that includes areas of northern Milwaukee County, western Milwaukee County, southern Milwaukee County, as well as the adjacent counties, and is characteristic of those urban systems that were developed in the 60s and 70s, and includes facilities that were installed even prior to that time frame. Racine and Kenosha also exhibits similar characteristics in respect to their overhead infrastructure.
Yeah. And I appreciate that explanation. I think it's very helpful and useful information, but it's still accurate that this infrastructure older than 50 years old is disproportionately clustered in Milwaukee and other urban areas, correct?
Yeah, yes, as represented here, this represents distribution infrastructure greater than 50 years old, correct?
Okay, thank you. Let's take a look at Exhibit 3. This is your Exhibit 3, Mr. Pekka, and this shows the estimated outages after the August 10th, 2021 historic storm, correct?
Yes, that is correct.
And it's specifically the dots, different colored dots represent when service was restored throughout Wisconsin Electric's service area.
Yes, that is indicated in my response to the interrogatory 26. Each dot represents an outage that is depicted that was restored during the time frame following the August 10th storm.
Thank you. Now, is it fair to say, is it accurate, based on this map, that your exhibit, that after the August 10, 2021 storm, many Milwaukee residents, particularly on the north side, did not have their service restored until August 14th? Is that correct?
Yeah, the way the dots are represented here, the blue dots, the early restorations are first plotted, and then the later dots are shown over the top of those dots. So there is a mix. You can certainly see there are red dots associated in many parts of the service territory, but the majority of the dots that required longer restoration times followed the storm track itself and include portions of eastern Waukesha as well as northern Milwaukee County.
Thank you. Now, according to this map, consistent with the explanation you just provided in response to my previous question, many suburban residents had their service restored on August 10th or August 11th, correct? The greens and blues are in those surrounding areas.
And I'm going to object to this question. I think that the map speaks for itself as far as, it has a timeline on there as far as when the date of restoration. So I think the attorney for Walnut Way can certainly see those dots, and those dots, obviously provide information as to when the restoration occurred.
Okay, so I think the question was more towards indicating whether those areas were suburban rather than urban. And I mean, we could look and cross-reference a Google map to potentially determine that. But I think if it's the witness's understanding as to whether the outages occurred and the restoration occurred in urban versus rural or suburban areas is a valid question at this point, given that the map doesn't explicitly show that distinction. So go ahead. Should we read that question back?
Question. Now, according to this map, consistent with the explanation you just provided in response to my previous question, many suburban residents had their service restored on August 10th or August 11th, correct? The greens and blues in those surrounding area?
Correct.
Thank you. Can you speak a little bit as to explain why, compared to their urban counterparts, according to this map, few suburban customers were still without service by August 14th?
Yes, I can address that. The path of the storm and the extent of the most severe damage as a result of the storm occurred in the path that was through eastern Waukesha as well as northern Milwaukee County. And based on the configuration and the density of circuits in that area, many more devices, whether it's fuses, reclosers, circuit breakers, operated as a result of the damage caused by that storm. So it is a characteristic of urban systems. There are oftentimes many more protective devices, as I mentioned, fuses, reclosers, circuit breakers that operate, and as a result, many more outages are a result of that. The timeframe needed to restore the system is in part due to manual switching that was needed in many cases, as well as repair or replacement of facilities that were damaged and needed to be repaired. So whether it was removing vegetation from lines, or whether it was switching to alternate sources to isolate the damaged area, those all took time to resolve as well. So the predominant or primary cause for the time frame of and duration of the outages throughout the service territory was primarily based on the track of the storm and the extent of the damage that occurred in its path during that event.
Mr. Pecca, based on your explanation here, is it fair to conclude that infrastructure in urban communities, particularly in Milwaukee, is more vulnerable to an extreme weather event like August 10th, 2021, than suburban infrastructure?
Your Honor, I'm going to object to that question. I think this map specifically talks about one storm in particular, and Mr. Pecca has said a number of times that's the track of this particular storm. That's the scope of his testimony, and it has to do with the storm. And it's true that this storm had the storm impact was greatest in those areas that you see where it took longer time to restore, and that's what Mr. Pecca's testimony is. And that's the scope of his testimony. With respect to this particular map, it was one storm in particular, and that's how the storm tracked. And that correlates to the restoration.
And that's a perfectly appropriate answer for the witness to give. So let's read back the question.
Question, Mr. Pecca, based on your explanation here, is it fair to conclude that infrastructure in urban communities, particularly in Milwaukee, is more valuable to, sorry, my green box is in the way. I have a big green box in my way, I apologize.
Ms. Harden, I'm sorry, Ms. Harden, I just want to clarify, it was vulnerable, not valuable.
Didn't I say vulnerable? I have vulnerable right in front of me. Let me start again. Mr. Pecca, based on your explanation here, is it fair to conclude that infrastructure in urban communities, particularly in Milwaukee, is more vulnerable to to a weather event like August 10, 2021 than suburban infrastructure?
No, it is not fair to conclude that. We have infrastructure in many areas of our service territory with similar characteristics as the infrastructure that was impacted by the August 10th storm.
And I don't want to beat a dead horse here, Mr. Pecca, so I won't ask too many more follow-up questions to that particular point, but I do have one, which is then I just want to clarify, are you saying that the only reason you see so many red dots in exhibit in this exhibit before us, exhibit 3, in Milwaukee specifically, and immediately near Milwaukee, is because of the direction of the storm?
Yeah, the storm track was the predominant determinant in terms of the extent of the damage and the time required to repair damaged facilities.
Now, Mr. Pecca, I want to follow up on something else you wrote in your testimony. If we could go back to your testimony.
Are you leaving this exhibit? I just had a follow-up question about it.
Please go ahead, Judge Mark.
So, witness Pecca, maybe there's a little confusion. I think I've become more confused about what looks like a simple map. The dots that appear that indicate date restored. Can you just explain? Are those circuits? Are there customer reports? What does the actual dot represent?
Each dot represents a protective device or an outage. An outage is associated with a device. It could be simply the transformer that serves customers, the residents. It could be a tap fuse that serves a side of a street or a small group of customers, or it could be a circuit line recloser that serves many blocks of for an area, or it could be the substation feeder circuit interrupter, which could be a breaker and serve several hundreds or thousands of customers. Due to the extent and nature of the storm, there were many taps, lines, transformers, and equipment that operated as designed to isolate the fault and de-energize the system in order to de-energize it and make safe ahead of repairs being made. So the characteristic of urban, or the differentiation between urban, suburban, and rural systems, you have many more devices in urban, suburban areas due to the densities of customers and components that are used. So as part of reliability planning, you try to utilize those devices to limit the extent of outages on the balance of the system. So you don't want to have 2 blocks of customers out for a tree that falls on a line or a dig-in that occurs on the system. You like to limit that to the least number of customers as possible. So the number of dots is directly proportional to the customer densities in these areas. Whereas the color of the dots refers directly to the significance of the damage that occurred during this particular event and the time needed to restore. I hope that helps.
Okay, so I just want to make sure we understand. So the color represents more than the date restored? That's new information. So
the color does represent the date restored, but the number of dots on the chart represent the density of the devices, the protective devices like a circuit breaker in your house that are used to isolate the system when a fault does occur.
Okay.
And that is a characteristic of a distribution system in an urban, suburban area compared to the area of the map that you can associate with rural areas. You may have a device that feeds several miles or dozens of miles of line that serves several dozen customers. So that's a differentiation and a characteristic of an electric distribution system.
Okay, great, thanks. All right, turn it back to you, Attorney Cahill.
Thank you, Judge Newmark. Mr. Pecca, so in your testimony on page 2, you point out that Wisconsin Electric is planning to invest $38 million in storm hardening programs in test year 2023 and $700 million over the life of the program. And then in reference to, I'm sorry, Judge, moving just to Exhibit 4, I'm just going to quickly follow up there. Could I ask, first of all, let me just ask Mr. Pecca, I'm sorry to kind of go a little too quickly here, but is that a correct, that is a quote from your testimony, is that accurate on page 2?
I'm sorry, let's go off the record for a second. Where are we at now? Direct page 2?
Yeah, direct page 2.
Okay.
Yep, I believe you're referring to line 17 and 18.
Yes, that's correct.
I'm with you.
Thank you. And then I want to just follow up using Exhibit 4.
Okay.
Thank you.
Start off small.
Yeah, that's fine. So to help explain where these investments will take place, you include this map, Exhibit 4, correct?
Correct.
Beyond this map, there's nothing in your testimony that specifically discusses where these storm hardening investments will take place during the next 5 or 10 years, correct?
Yeah, nothing in addition to the proposed project areas that are identified here at this point, correct?
Right. So just to clarify, this exhibit is the most specific representation in your testimony as to where the storm hardening investments will take place during the next 5 or 10 years.
Yes, based on our plans at this point, that is correct.
Thank you. Your Honor, there's an exhibit I'd like to move in, one of the exhibits that we proposed, which is Mr. Pecca's response to Walnut Way 2, Walnut Way, interrogatory 25.
Record
Did you say off?
off, yes.
Okay.
Find this first. Okay, so is this what you're looking for?
Yes, Your Honor. Thank you.
Let's mark that PECA 6. Okay, so we've marked, so let's get it back on the record. We've marked 2 WWINT 25 as exhibit, well, PECA 6, exhibit PECA 6. Go ahead.
Thank you. Mr. Pecca, this what we're looking at right here. What's marked as exhibit 6 for you, Mr. Pecca. This is your response to a Walnut Way data request, correct?
Yes, that is correct.
Yeah. Specifically, Walnut Way data request, second set, interrogatory 25, correct?
Yes, that's correct.
Your Honor, I would like to move this exhibit into the record.
All right, any objections? Okay, it's in.
Okay, thank you. I'll direct you towards the second page. Well, yeah, the second page, the map of this specific exhibit. Now, in this map, you include where the city of Milwaukee is specifically over the future project areas over the next first 5 years, correct?
Yes, that is correct.
Okay. And that's what is in black, highlight or not highlighted, outlined in black. That's the city of Milwaukee.
Yes, that's correct.
Thank you. Now, according to your answer here, we'll go back to page 1, Your Honor, or the previous page. According to your answer, over the next 10 years, there are plans to deploy, quote, automation devices on most distribution feeders in the city to aid in faster fault, location, isolation, and restoration, correct?
That is correct.
Can you speak a little bit more about what that is and what that'll look like in practice?
Sure. Within the city of Milwaukee, and it gets back to a little bit around the primary distribution voltages. I mentioned the 8 kV system serving areas kind of on the outskirts of Milwaukee County and adjacent counties. In the urban and portions of suburban Milwaukee County, downtown, as well as the neighborhoods that extend to the north, south, east, and west. 13 kV distribution system is the ultimate or the long-term plan for these areas. A lot of those feeders and circuits were rebuilt most recently as part of our legacy 4 kV conversion efforts, which the company is close to completing with one remaining 4 kV system in the Milwaukee area. These areas have relatively new infrastructure overall and have the capability of having multiple substations and sources that can be used in the event of an outage or an event to be able to utilize capacity and feeder configuration to serve customers. The resiliency and storm hardening efforts that we're looking to employ on that system, which is the general area that includes a good portion of the city of Milwaukee, is to deploy those sectionalizing devices as well as automation to aid in our fault locating, isolation, and service restoration efforts. So again, that deployment of that technology is an immediate capability we're looking to leverage as part of this storm hardening program.
Do you have any further clarity on what percentage of Wisconsin Electric's investments based on these future project areas? What percentage of these investments will be in the city of Milwaukee over the next 5 years?
Yeah, as far as the projects that have been detailed out in the first portion of that period, got approximately 46% of that investment planned in Milwaukee County, including the city of Milwaukee, as you see it on the map here, with additional efforts on Exhibit 4 shown that showed areas that were throughout our service territory. Overall, we anticipate approximately 250 million of the 700 million included in Milwaukee County and those circuits that serve residents in communities, including the city of Milwaukee.
And do you have any further clarity on where specifically in Milwaukee County and these investments will take place?
I object, asked and answered.
Overruled.
Yeah, the locations that are identified here, are you looking at any particular way to identify those by municipality or other means? I may ask for clarification of the question.
Sure. I guess, like I see this map here, and this includes Milwaukee County and obviously significant chunks of the city of Milwaukee, but within specifically within certain zip codes within the city of Milwaukee, do you have the ability, I know it's not here on the map, but the ability to further clarify where these investments over the next 5 years will take place?
Yeah, I can speak to the work that's identified by zip code. I believe that there's approximately 28 zip codes that include the city of Milwaukee. I can say that all of them will be touched in some manner by work that's being proposed in the storm hardening program. The majority of the projects that are focused on the 13 kV system will be in and around, as you can see on the map, the downtown near south side, west and near north side areas in the 2023 through 2027 timeframe.
Thank you, Mr. Pecca. I just have a kind of a general question. I'm almost done here. Based on your experience and expertise, is your understanding that storm hardening efforts are more expensive, generally speaking, are more expensive in urban areas compared to rural and suburban areas?
Your Honor, I'm going to object to that question as beyond the scope of his testimony.
Overruled.
Yeah, I would respond in that it varies. And a lot of it depends on the infrastructure. The electric infrastructure has evolved over 100 years in many areas, especially in the urban areas. There are often times when we can leverage existing infrastructure with the use of technology to deploy solutions that will aid in resiliency in manners that are more cost or less costly than comparative areas outside of urban areas. But also there are times when you come across or can experience other costs that could be higher in urban areas. But it doesn't preclude one solution over another necessarily. It depends on a lot of factors, including the topology of the circuitry, what infrastructure exists that currently exists, as well as customer locations, electric usage, and those factors as well. I would say that it can vary again depending on circumstances and the topology of the system that serves a particular area.
Thank you, Mr. Pecca. I have no additional questions. I appreciate your time this afternoon.
Any other cross? And so I just had one follow-up for you, Witness Pecca. Just curious, how does the company plan to keep the commission informed about the progress of the program?
We currently have PSC 113 requirements that already exist in electric service rules and regs that the company reports on with respect to its long-range plans and efforts with in terms of reliability performance as well as its construction activities, we would plan to continue to report in that manner.
Okay, great, thanks. All right, any redirect?
No, Your Honor.
Thank you very much. You're excused.
Thank you.
So still have a few company witnesses. Let's take the risk of having taken a half hour, or should we just plug through company witnesses? Any preferences among the group? So we do have some time constraints. Let's actually address that first. Let's go off the record for that. So before we proceed with the next person, check in on. Let's see, we have well, looks like we will just proceed and take witnesses later in the day. I think that, yeah, we should still be here for them.
That makes sense.
Yes. Okay.
Your Honor, from applicant's perspective, we should get through Mr. Byer, who's on the line virtually. And then I think that will probably be a good breaking point because the other witnesses I see on the board are going to have more time.
Yep. Okay. That's fair. Thanks for contributing to that. So let's call witness Byer. I think he's connected on his own. I have to find, there you are. Okay. Thanks for moving around a little. All right. So, all right.
Because can I ask who's on for WEPCO? Who just came in?
Yeah, my name is Patrick Proctor Brown.
Okay, that's what I thought, but I wanted to make sure. Thank you.
Thank you.
I'm getting ahead of myself. Will you be continuing on as the company witness, company counsel, or is this your only witness at the time?
I have another witness, but not a company witness.
Okay. Well, okay.
But we can rename after.
Oh, someone did it already. Thank you. All right, sounds good. Perfect. So, witness Byer, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right, go ahead.
Mr. Byer, would you please state and spell your name for the record?
Jim Byer, last name Beyer.
And did you prepare and cause to be filed direct testimony and one exhibit in this case?
I did.
And if I asked you the questions contained in your direct testimony today, would your answers be the same?
Yes, they would.
And is the information in your exhibit accurate to your best of your knowledge?
Yes, it is.
And I have one question from Judge Newmark, I think, about your exhibit. So we could pull that up if you don't mind, Judge Newmark.
I'll do that.
And I believe the question is to explain the black boxes that you see on the exhibits. Mr. Byer, could you go ahead and provide an explanation for those?
Sure. This exhibit is an example of a monthly steam fuel cost adjustment report that we send out monthly. In the past, we only reported the total cost of fuel and the total fixed cost. By request from PSCW staff, they wanted us to break it out into the components that are shown there below each of those totals. And within those components, there are some that are considered confidential, whether due to market sensitivity, as in the risk management component, or in contract sensitivity, as in the diesel fuel and the Guardian reservation rate. So the plan would be that we would file both a confidential and a public, and the public would have these redacted boxes. So my exhibit shows that with the redacted boxes. And it also goes in line with, I think, standard convention in the past. If you look at Nelson Exhibit 8P, I think it's that one, he also has those blocked out, those different components, and has the totals not redacted.
That's fine. Thanks for clarifying. So we will expect the full version in the confidential file.
Yep.
Okay, perfect. All right. And thanks for that. Any, are we ready for cross then?
Yeah, Mr. Byer is available for cross.
All right, any cross? No, all right, thanks, you're excused.
Thank you.
And let's break till 1:45. Back to, I think we can continue to take company witnesses at that point. All right, let's get back to it. Before we begin, I did want to present, let me turn off our, not turn it off, but remove our recess message. Before we begin, I did want to review one thing with the applicants. And I do appreciate the effort to ask the questions that I had, and to catch me when I forgot to ask something. I did have one that I did not ask, unfortunately, with witness Nelson, and I don't think we need the witness back, but it relates to Nelson 13. And it's just it looked like a typographical error on the tariff revision for the RER tariff. And I know he did revise that exhibit, but I think, I'm not certain, but I think the error is still there. Yeah, so let's see, it was sheet, it doesn't have a sheet number yet, right? I guess sheet 230, page 2. So it just had that reference to Wisconsin statute section PSC 19692. So if we could just conform that, like we're doing to the pub service tariff.
Yes, we can take care of that, Judge.
Okay, so I'll note that on my list. So there'll be a 13 R2. All right. So we have everyone we need. Yeah, okay, so who's next?
Your Honor, joint applicants call Mr. Joe Zagans.
Right. See you there. All right. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
I do.
All right, go ahead.
Good afternoon. Would you please state and spell your name for the record?
Joseph L. Zagans, last name is Z-G-O-N-C.
And Mr. Zagans, did you prepare or cause to be prepared and filed in this docket direct and rebuttal testimony?
Yes.
Did you also prepare or cause to be prepared and filed 11 exhibits supporting your testimony?
Yes.
To the best of your knowledge, were your testimony and exhibits correct and accurate as of their filing?
Yes.
Do you have any changes or corrections that you wish to make to your testimony or exhibits?
No, I do not.
All right, Mr. Zagans is available for cross.
Okay, any cross?
This is Krista Westerberg for Walnut Way. We do have a few.
All right, go ahead.
Good afternoon, Mr. Zagans. Can you just tell me what the total revenue requirement for all the utilities combined in this docket is? Just off the top of your head.
No, I can't off the top of my head.
Okay. Would you agree that many of the customers of Wisconsin Electric who will see rate increases are also customers of one of the gas utilities that is seeking an increase in rates?
I'm going to object that that's outside the scope of his testimony, and at a minimum, we would need some foundation laid for that question.
I think the foundation was in his direct and other testimony, and I'm trying to be efficient with time here.
I'll answer, that's fine. Go ahead.
Can you restate the question, please?
Let's read it back.
Question, would you agree that many of the customers of Wisconsin Electric who will see rate increases are also customers of one of the gas utilities that is seeking an increase in rates?
There is overlap between Wisconsin Electric and Wisconsin Electric Gas and Wisconsin Gas customers.
Okay. Can you say, sitting here today, how many electric customers are also a gas customer?
No.
Okay. But at page 3 of your direct, you do describe the total number of customers of these utilities, right?
Yes, I do.
Okay. And can you say if it's hundreds of thousands where there's overlap, hundreds of thousands of customers?
I don't know for certain.
Okay. Are those customers billed for whom there is overlap? Do you know if they're billed for electric and gas on the same bill?
Yes, the applicants do business as We Energies.
Okay. So the $5 to $6 of increase for electric and the $5 to $6 for gas will be on the same bill for those customers for whom there is overlap.
What $5 to $6? I'm sorry.
Were you here for the testimony of Mr. Nelson this morning?
I was.
Okay. Did you see the exhibit we were looking at that had the flyer with the projected rate increases?
Yes, I did.
Okay, that's what I'm referring to. Does that jog your memory as to $5 to $6 amount?
It does. Thank you.
Okay.
That's
So
Nelson,
just
Nelson 10, I believe.
yes, thank you. Right there on the last page.
Yes. Okay. Great.
So would you state then the question again, please?
Yeah, just that the customers who are experiencing an increase in electric, some of those $6 a month on average might also see a $5 to $6 on average increase for gas.
On average, yes.
Okay. Mr. Idukis volunteered you this morning to answer some questions about some of the costs that were described in data request responses for staff. Have you had a chance to look at the documents that we marked for hearing today?
Yes, I believe I have.
Okay. Well, hopefully, I appreciate that. I hope we can get through them a little bit more quickly then. The first that we're looking at with Mr. Idukis was PSCW FR 13, which is labeled Goodwill Advertising in the judge's folder.
Okay, so off the record, we're going to mark these Zagant's exhibits now. Don't get confused with the Idukis exhibits. So Goodwill.
And before we get to that, just following up on the last question.
Are we still off?
I guess not. Let's get on the record.
Before we go on the record, there may be something that's best taken up off, and that's just a housekeeping matter. With some of these exhibits, we don't object to their introduction as long as we're using the version that was filed on IRF that includes the cover page and identifies the respondent. Some of these appear to be compilations or incomplete, and we would just ask that we pivot to those for these questions.
Okay, sure. And in fact, it's probably would take too long to bring them up now. Will this suffice for the purpose of the hearing, Attorney Goldschmidt?
I think we'd like to be able to see in each case who was the respondent for these requests.
Okay, that's fine. That's fine. It'll take a little bit. So where were we? So I have a description. If we have the IRF number, that would go quicker. I don't know if that's available.
I can try to help. This first one is FR 13, so that should be 436804 for the cover sheet.
Hang on a second. 4364. What's the rest of that?
436804 for the cover sheet and 436805 for the attachment.
Okay. I see what's going on. Okay, now I get it. Oh, that's good.
Your Honor, we didn't get objections to these before the hearing. I'm wondering if we can just work with what we have marked for purposes of the hearing. And we can discuss, replacement exhibits later.
Well, I think I just decided we're not going to do that because they wanted to know who the respondent was.
Okay.
Just give me that IRF number again for the attachment.
That's 436-805. And as long as we're working with the official filed versions, we won't have an objection.
Okay, so that's Excel. That's why they're separate documents. Okay.
Correct.
So yes, so let's get on the record. So I just wanted to discuss a housekeeping matter for the next few exhibits we'll be discussing. So I'm assuming we're going to be bringing up the Goodwill, association dues, outside vendors, and the RR39. Or is that?
How about just the first of those? We'll forego the last one in the interest of time.
Oh, okay. So the first, so Goodwill for sure. Okay. Well, just so we know, when you file the exhibit, and that'll be this one in particular for Goodwill. It's PSC filing requirement, data request response. So I have FR13, and that will be marked Zagant's 12. And just when you file, you'll want to include the cover page. That's one PSC filing, and then convert the Excel spreadsheet to PDF and include that in the same exhibit filing.
Okay.
So yes, I think we're good to go with that. So should I start with the cover page first?
Sure.
Okay, go ahead.
So Mr. Zagans, we were going to ask you about the PSC's response to data request submitted by staff, FR13. Have you seen this response before?
Yes, I have.
Okay, and have you seen the attachment?
Yes.
Okay, I have some questions for you about the attachment, if we can move to that.
Okay. Move around a little bit.
And so Wisconsin Electric, one of the expenses it expects in 2023 is almost, $658,000 plus in institutional or goodwill advertising. Can you tell me what that refers to?
I'm not sure what the specific costs are for, but it's for, as it says, institutional goodwill advertising. That's as much as I know as I get the data to put together the revenue requirement.
Okay.
Sorry, that's as much as I know.
As I put together the revenue requirement.
Thank you.
Yep.
And do you know what the $86,905 in promotional advertising would encompass?
Not specifically, no.
Okay. And is it possible that some of those expenses are included in rates or no?
Those expenses are not in our current rates. Is that the question you're asking?
Yes.
Yes.
Okay. And are they proposed to be included in rates in the test year? Do you know?
They are currently in our requested revenue requirement.
Okay.
However, I would say that they're expected disallowances. In other words, we would expect them to be disallowed as part of the proceeding.
Regardless if you get the money in rates or not, you do plan to spend that?
I don't know.
Okay. So let's move on to the association. Oh, do we want me to move that in right now, Your Honor?
I just wondered if you had a question for Wisconsin Gas related to that, just to.
Oh, yeah, thank you. Yeah, do you have the same, are your answers the same for Wisconsin Gas?
Yes, I'm sorry.
Okay.
Yeah, they're the same for Wisconsin Gas.
Okay, thank you.
Mm-hmm.
Now I guess we would seek to move admission of, this would be Zagant 12.
Yes, any objections?
No objection.
All right, that's in.
All right, same question with the industry association dues.
All right, so if we have that PSC number handy, get my browser into position here. There we go.
Your Honor, that should be PSC.
Just a sec, I gotta get my cursor in the right place. Or else you're gonna have to repeat it anyway, so. All right, go ahead.
PSC ref number 436642 for the cover sheet and 436644 for the attachment.
That's RR61. Right.
And actually, this was one of those combined exhibits. I'm more interested in the ones associated with RR60 and not 61.
I see.
Yep.
I want to check we're off the record. Let's go off the record. Sorry about that. Okay, so is that a different?
Yeah, so it'd be 436631 for the cover sheet.
Okay.
And 436623 for the attachment.
Cover page. And the attachment was 632, or did you say 623?
623.
There. Okay, so let's get on the record and mark this Gantz 13, and that'll be the data request response cover page to PSCW RR60 and the spreadsheet converted into PDF of the same response. So let's go ahead.
Yes, thank you. So Mr. Zagantz, directing you to exhibit 13. Have you seen the data request for response we're looking at here from staff RR60?
Yes, yes, I have.
Okay, and have you seen the spreadsheet as well?
I have.
Okay, let's move to that. And these appear to be miscellaneous general expenses as you've identified them to the commission. Would you agree?
Yes, I would.
Okay. And so this indicates that there are at the top of the page, there we go, about a little over 1.5 million you'd be seeking for industry association dues, or you did in 2021.
Yeah, those are 2021 actuals. If you page up, you'll see what the component that's in the test year.
Yes, that's what I'm interested in. Thanks.
Yep.
So we're looking at about 1.5 million in industry association dues. That's Wisconsin Electric and Gas are planning to spend in 2023.
It's those two amounts. I did not hear specifically the total you said. It looks like 1.186 and 0.264 million.
Yep. And then there's a line for directors' fees and expenses. Is that for board of directors?
Yeah, I believe so, yes.
Okay, and so that amount total between Wisconsin Electric and Gas would be just over 2.5 million, right?
Yeah, assuming that's the total of those two numbers.
Okay. And do you know if are you asking for these to be recovered in rates?
They're currently in our company's revenue requirement ask. Historically, though, the industry association dues, the commission only allows recovery for the ones that benefit customers. So typically excluded would be things like lobbying and other goodwill.
But the director's fees and expenses are typically allowed?
I think so. I don't know for certain.
Okay. Would you expect to expend these funds regardless of whether they're allowed as rates?
We will certainly have director's fees and expenses. I don't know if they'll be this amount. This is our estimate.
Okay.
And same with the industry association dues. That's our current estimate.
Okay. Then let's just do this exercise with one more exhibit. And that would be RR 51.
How do you have that labeled in the files here?
That one is vendors.
I'm sorry. That one is
outside vendors.
Thank you.
Thanks.
Oh, go off the record.
So the cover sheet is
okay.
436621.
There. Four, 3, 6.
621.
Okay. That's what I have here. And the attachment
is 436613.
Okay, so let's get on the record. Next exhibit to mark as Segant's 14 will be the response to data request PSCW RR 51 cover page and attached spreadsheet. So just
all right. Let's start with the cover sheet then, Mr. Zagans. Have you seen before this data request response from staff RR 51?
Yes, I have.
Okay. And have you seen the attached spreadsheet?
Yes, I have.
Okay, and that's if we can go to that, that's a spreadsheet containing your vendor costs.
That's right. Vendor costs for actuals and forecasts for the test year.
Yes, and I want to look at the forecast for the test year.
do I need to be somewhere else?
Yes, that would be the spreadsheet that's 436613.
Oh. How small? Oh, I have to get too small. Okay, there.
I think if you go to the left, you'll get to the 2023, the test year.
Keep going.
Mm-hmm, yeah.
It's all the way at the left.
There we go.
Okay.
Great. So you're projecting, according to this spreadsheet, Wisconsin Electric is projecting vendor costs for 2023 to be nearly $7 million.
Yep, 6
And
point.
that's,
Yep.
and that's for legal and consulting.
Looking at the nature of the service in the column, yes, it is predominantly for legal and consulting.
Okay.
Yes.
And the highest number there is almost 2.5 million for Quarles and Brady, your attorney sitting here today.
The highest number on this list is for Quarles and Brady.
Are are you going to seek recovery for all of these costs and rates? Do you know?
Yes.
Okay. Same questions, but for Wisconsin Gas. Obviously, the number is different. It's 1.1 million for outside services for legal and consulting, correct?
I'm say that again. Yes, yes, it is.
Okay, and you'll seek recovery for these costs and rates as well.
Yes.
I guess, well, before we move on, can we move admission of 13 and 14 into evidence?
Any objections?
No objection.
All right, yep, they're in.
Okay, great. Mr. Zagantz, just back at the, is it Zagonic or Zagantz? I'm sorry.
Zagantz.
Okay. The questions I was asking you earlier about the combined electric and gas increase that some customers may see who are in the overlapping service territory. Are you aware of any analysis that the applicants have done assessing the ability of customers to pay those combined expenses who are located in the overlapping territory?
I'm not.
Okay. Nothing further.
Okay. Any other cross? Let me get my, we can be able to see everyone here, just my screen. Any other cross? No? Okay, redirect.
I think just one, Your Honor.
Yeah, go ahead.
Mr. Zagantz, in preparing the revenue requirement for filing in this case, is an analysis of affordability or customer ability to pay something that would have fallen under your responsibilities at the company?
It is not.
Thank you. Nothing else.
Okay. Thanks, you're excused.
Thank you.
So what's timing? Okay. Who's next?
Your Honor, it's Brad Jackson appearing at this time, and we call Ann Bulkley.
Almost forgot about her. Been a busy morning, afternoon.
And Ms. Bulkley, can you move your camera down because you're, there you go.
That
Thank
better?
you. Yeah, I'd like
Thank
to
you.
see people's mouths.
Sure.
Oh, thanks for putting your name in there. All right, I think we're good to go. I'll swear you in. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth.
I do.
All right, go ahead.
Please state your name and spell your last name for the record, please.
Ann Bulkley, Bulkley.
Ms. Bulkley, by whom are you employed?
The Brattle Group.
Ms. Bulkley, in connection with this proceeding, did you prepare or have prepared at your instruction or direction pre-filed direct rebuttal, surrebuttal, and surrebuttal testimony?
I did.
If I were to ask you the questions contained in those pieces of pre-filed testimony today, would your answers be the same?
Yes, they would.
And in connection with that testimony, did you also prepare or have prepared at your direction 18 exhibits?
Yes, I did.
And are those exhibits true and correct to the best of your knowledge?
They are.
Do you have any corrections to either the testimony or your exhibits?
No, I don't.
All right. Your Honor, that completes her testimony exhibits. You had 3 additional exhibits that you wanted her to introduce. Do you want me to kind of go through those with her?
Okay, yeah, I wanted to just get off the record for a second. Just hearing a lot of extraneous noise, like someone moving stuff around. I'm not sure who that's coming from, but if we could refrain from doing that.
I think that's Joe Wilson. We'll
just throw me under the bus, why don't you?
Yeah.
All right. Now we know who's making all the noise.
Right.
So I just saw, okay. Yeah, and I just wanted to, let me just check, there were some adjustments to those questions based on the conversation we had yesterday.
You're back on?
No, we're off.
Okay.
So I just thought, I just want to make sure, there's just to clarify how we changed one of those exhibits. So it will be a little different.
19 is the same.
Yeah.
Yeah, number 20 needs some clarification.
Okay.
And then we did change 21 a bit.
Yeah. Okay. And all right. So I can ask that if you need clarification from me, we can just do that. I can do that with her. But I just want to get back on the record just to make sure everyone had a chance to read Sir rebuttal. Not that that's really an issue, but I just want to make sure there's no objections to that coming in writing. So let's get on the record. So I just wanted to check any objections to receiving witness Bulkey's Sir rebuttal in writing. No, all right, we'll put that in as well as all of her other pre-hearing testimony. So yeah, I did have a few additional exhibits that I was requesting the witness provide. So let me just ask, did any clarification needed for Bulkley 19?
I can't see the.
You want that? Okay. It's
Yeah,
the
I'm sorry.
same as
Just
yesterday.
really make sure I get them correct. Sorry about that.
Make that, and that should appear much bigger now.
Yep, that's great. No, I don't have any clarification needed on that one.
And Bulkley 20.
No, Your Honor, I understand that request.
Okay. So Bulkley 21.
Hold on just a second. I think the description. No, I'm sorry. I think that's right.
You were good with 20?
Yep, sorry.
That's okay. Okay, I'm just gonna try to adjust this a little bit more. Okay. All right, so for Bulkley 21, it's similar to my original request and service docket, but I changed it to reflect the changes that we made during the hearing yesterday in terms of what was being displayed, what was being marked in terms of the dates being displayed on the chart. So just give you a second to take a.
Sure. I believe I understand that request. So yes, that seems like what we discussed yesterday for the other chart. So I'm clear on that.
Good, thanks. All right, so I think that's all we had for that. So, okay, great. So I'm done. Leave you alone. Now let's move on to, so is the witness available for cross at this time?
Yes, Your Honor.
Okay, great. So who's first for cross?
Come has crossed and I can go in any order.
Okay, well, you're good, just as good of order as any other. So I'm gonna just want to pin you so I can see her.
She's on my second page and I can't get there.
All right, we're off the record for sure. So let us know when you're ready. Don't see the arrows on the sides?
Nope.
Can you make the screen bigger?
Nope. It's as big as it can be.
Can
you bring her to the front one? She's on the second page.
I don't think that's up to me. I think that's up to each person's view. Maybe let's try just having you say a few words.
Am I showing up on the main screen?
Doesn't pop up. Okay.
That's okay. She's clear enough. I'm not going to worry about it.
I'll try to be really clear.
All right. Well, just let us know if you're having trouble. We'll have to deal with it at that point. But So, okay, we're ready for cross. Why don't you go ahead?
Okay, good afternoon, Ms. Bulkley. I'm Kara Coburn Ferris with the Wisconsin Citizens Utility Board.
Good afternoon.
Would you please turn to page 44 of your rebuttal testimony? And this is going to be similar to yesterday. In this section, you discuss what you describe at the bottom of page 45 as negative outcomes for utilities that resulted from these below market authorized ROEs, as you describe them. And you give examples of 4 utilities, and you also discuss their parent companies. That's Connecticut Light and Power, a subsidiary of Eversource, Minnesota Power of Elite, Houston Electric of CenterPoint Energy, and Arizona Public Service of Pinnacle West. And these are the utilities and parent companies that you describe as having sustained negative outcomes. Is this a correct characterization of this section of your testimony?
I believe I characterize it as negative credit rating agency responses. That's how I describe that.
On the bottom of page 44 at line 20, you describe these as examples of negative outcomes for utilities. Is that correct?
Yes, that's correct.
Okay.
With respect, as you read the answer to that, it's with respect to rating agency views and market response. Yeah.
Okay. So when considering negative outcomes, have you looked beyond credit downgrades and declining share prices for parent companies when you describe these 4 utilities as sustaining negative outcomes?
I think yesterday we talked about Pinnacle West in particular, and the letter to shareholders that was originally referenced in Dr. Kime's testimony and that I expanded on yesterday, and is discussed in my Sir rebuttal. So beyond the downgrades from the credit rating agencies, the company felt that they did not have, that they needed to defer their equity issuances and change their capital plan to maintain their credit metrics and to protect their shareholders. So they are unable to access the equity markets until after their 2024 rate case. And they indicated in my Sir rebuttal on page 6, I have a quote from that 2021 annual report that says, while 2021 finished strong, we have guided expectations for 2022 as a financial reset year due to unfavorable outcomes in our recent rate case.
Yes.
We also have committed to protect shareholders as much as possible by deferring equity needs until 2024, defending the dividend, and managing our capital program to ensure we maintain investment-grade credit ratings. So beyond just the ratings, I would say that the capital program was affected and the ability to access the equity market.
Okay. So do you have any quantitative evidence of this inability to attract capital?
I believe it's difficult to quantify the inability to go to market. So no, okay. I don't have that actually.
Okay.
The
have
lack
you
of
examined
market evidence?
Hang on, off the record. Can't be speaking over each other. So please be patient with one another. I think maybe when someone's just taking a breath because we're speaking to a great extent, and which is fair enough. We want to get complete answers, but just please wait for everyone to be finished with their thoughts before we interject. Except for me, I get to do that. So, okay. It's back.
My apologies.
So I think the end of my answer was that it is difficult to quantify when they are electing not to go to market. So I think I don't have any other examples there.
Okay. Have you examined the cash flow statements of Arizona Public Service, your main example, or the other three utilities?
No, I have not. I've relied on the rating agency determinations
Okay,
for the metrics that resulted in the negative outlooks or downgrades.
okay. In your expert opinion, would cash flow statements tell you anything about capital flow to these utilities?
Yes, they would. As I said, I've relied on the rating agencies' analysis to determine. Now, the rating agencies are looking at cash flow coverage ratios as a factor in their determination for negative outlooks or downgrades. And so I'm relying on their determination in those credit rating agency reports.
Sure. So have these credit agency reports or these downgrades or the stock price reductions, have they impaired the utilities' provision of safe, reliable, and affordable utility service to customers?
I believe the utilities are all providing safe and reliable service. As indicated, I have no reason to believe that they would not be providing safe and reliable service, as indicated in the APS or the Pinnacle West 2021 annual report. They are managing their capital program. So I don't have a good sense of what capital investment is potentially not being made, but I would believe that the companies have the expectation of providing safe and reliable service.
Okay. Looking at the same section of your testimony.
And I have to interrupt here. Where are we in the testimony?
We're in her rebuttal, page 44 to 48. And so now I'm looking at page 44.
Okay, thank you.
Lines 19 and 20. Would you, Ms. Bulkley, please tell us what you mean by below market authorized ROEs?
Yes, so I think the reference there is with respect to in certain circumstances below all of the analysis that was performed for to determine the cost of equity. So in the CLMP case, the penalty there resulted in a return.
I'm sorry, so, excuse me, so in the what case?
In
CLM?
the CL and P.
Thank you.
Case, the final recommended ROE in that case would have been below, or the proposal from Pura would have been below the return that was determined by any of the modeling that we had prepared in that case. In some cases, it's below the range of authorized ROEs.
So did you prepare the cost of equity modeling in the Arizona Public Service Pinnacle West case?
I was involved. I prepared some of that modeling. That's correct.
Were there other models or other modelers, other witnesses who prepared cost of equity modeling in that proceeding?
Yes, there were.
Okay, turning to the question of these terms that we're discussing, return on equity and cost of equity. Would you please turn to page 3 of your rebuttal testimony and read the footnote at the bottom of page 3? That's footnote 6.
You'd like me to read it aloud?
Please.
Sure.
Well,
Doctor,
hang on. I don't know if that's really necessary. Can you just confirm that she understands it and we can.
Okay, so you mentioned in this footnote that you use the terms interchangeably, yet recognize that the models estimate a cost of equity and the commission determines a return on equity. So given that you you say you use them interchangeably, you treat them as interchangeable. Do you believe that they are interchangeable, or do you believe that one denotes what the models estimate to be the minimum required return, and the other denotes the authorized return that regulators determine?
As the footnote states, I recognize that the models are estimating the cost of equity and that data is used to establish a return on equity. I do realize this has been the subject of a lot of discussion, and I would note that after our conversation yesterday, I went back to review a primer prepared by NARUC where these terms are actually used interchangeably on a fairly regular basis. And so I think it's important to recognize that. I am not the only person who has done that in this particular NARUC report, that this is a US aid report. It's a cost of capital and capital markets primer for utility regulators prepared by NARUC and US aid.
Okay.
And in reviewing this report, I would like to read how NARUC views this, how NARUC refers to the cost of equity and the return on equity in their analysis.
However, so I don't believe that's appropriate at this time. And we have a lot of testimony about what's cost of equity and what's return on equity, but you didn't use that report to create your testimony, did you?
No, Your Honor, I didn't, but there's been a lot of testimony written about whether or not I understand the difference and how these terms could be used interchangeably. And I think it's important for this commission to recognize that even NARUC uses these terms interchangeably. And so that is not a lack of understanding of the terms, but rather common practice in discussing this subject matter.
Okay, but this isn't the first time this issue has come up, that there's maybe a distinction with or without a difference between cost of equity and return on equity. I think I just don't want to introduce a new document at this point that people haven't seen, and we don't really have any reference point for on the fly at the hearing. And I understand your position, but it's inappropriate to bring in this kind of study just by reading it into the record and without having an opportunity to review. So,
Your Honor, could I be heard on this?
Yeah, go ahead.
Dr. Kime yesterday was allowed to cite at least 2 brand new sources.
Your Honor, I object. That was a different proceeding.
He held up a book, a new book that he hadn't cited before, and was reading from it. I don't know how that could be fair, and what Ms. Bulkley is doing could be unfair. This is a NARUC primer that should be familiar to the commissioners who regularly attend NARUC proceedings. So we're not talking about something that's obscure, but rather a pretty basic document industry.
Yeah, I hear you on that, but so I don't know when it was published. I don't know who authored it. I don't know if it actually exists. I don't really know anything about it. So,
so you know, the witness can hold it up in front of the camera, it's okay.
What I can allow is on redirect. If you wish to proceed with questions in this manner, you can. But in response to cross reading into the record, something like this, I can't allow.
Okay.
Okay. So Ms. Bulkley, is it your position that NARUC uses cost of equity and return on equity interchangeably?
In reviewing the document that we just discussed, there are references in this NARUC primer of ROE methodologies and ROE ranges that would typically, in this proceeding, have been identified as COE.
So is that a yes?
That is a yes.
Okay. And is it your position that other witnesses in this proceeding use ROE and cost of equity interchangeably?
I don't necessarily. I have not examined the staff testimony that specifically for this purpose. Certainly, Dr. Keim and Mr. Singletary, no, I would not say that.
Okay, what is your definition of interchangeable? Does it mean synonymous or substitutable?
I have been less precise in defining the cost of equity rather than the return on equity. So as I indicated earlier, the ROE is typically set based on analysis prepared on the COE. And so there will be places in my testimony that probably should reference COE as we refer to the models that have been developed, but rather reflect ROE.
So are you saying then that there are portions of your testimony where cost of equity is used and it should say return on equity?
No, I would say that return on equity has been used where it should say cost of equity.
Okay, so how are the decision makers to know whether you're referring to return on equity or cost of equity?
As I just indicated, where I'm referring to the ROE estimation models and the investor required return, those would both be cost of equity. Whereas the return that the decision makers, the commission or other commissions have made would be a return on equity.
Okay. Just getting back to my question, do you have a definition of interchangeable, which is a term that you use in both your rebuttal and then your SERSER that you submitted this morning to describe your use of the terms ROE and cost of equity?
I think I just described my use of the terms ROE and COE.
I'm asking about your use of the term interchangeable to describe how you use those terms in your testimony, given that they appear 600 sometimes.
Yes, and I'm saying that I have relied on one where it may have been more appropriate to rely on the other. That's my definition for you.
Thank you. No further questions.
Okay, other cross?
Clean Wisconsin has some questions.
Okay, go ahead.
Good afternoon, Ms. Bulkley. My name is Brett Cordy with Clean Wisconsin. Thanks for being here this afternoon. We'd like to start on page 4 of your SIR rebuttal.
And
there on line 40, you state the cost of equity is an estimate of the investor required return. And in the current proceeding, this is the return that investors required to invest in the companies. Do you agree that the cost of equity is equal to investors' expected return?
I don't see that on what page, what line number are you on? I thought you said 40.
4. Line 40. It's what's on the screen right now.
I'm sorry, can you ask your question again? I apologize.
Let's have it read back.
Right.
Question there on line 40, you state the cost of equity is an estimate of the investor acquired return. In the current proceeding, this is the return that investors acquired to invest in the companies. Do you agree that the cost of equity is equal to investors' expected return?
Yes, I do.
So do you agree that if one investor pays a higher price for the exact same stream of future cash flows than a second investor, the first investor would earn a lower return than the second who paid a lower price for the exact same stream of future cash flows?
Yes.
In figure 4 on page 18 of your SIR rebuttal, we're looking at figure 4. You list some projected returns on equity from value line. Are these figure returns on book equity?
They would be, yes.
Would it be reasonable for value line to base its ROE forecasts on authorized ROEs?
They can base their forecasts on what they can choose to forecast how they will. I'm not sure I have a.
In your opinion, would it be reasonable for them to base their ROE forecasts on authorized ROE?
I think it would depend on how it was done. The details of that, I think, would be important to understand.
Would you say it would be facially unreasonable for them to base their ROE forecasts on authorized ROE?
Objection asked and answered.
Sustained.
All right. So in general, can investors buy a stock at book equity value?
Investors buy a stock at the stock price.
Is that the same as the market value?
The market equity value.
So for companies in your proxy groups, is the market price on average higher or lower than the book value on average?
I don't know.
Could I pull up page 10 of Mr. Ellis's rebuttal? I'm sorry, page 12.
Okay, so we need to be careful with that. I just want to, I don't have, well, I guess we do have a red line version, but it's not, doesn't reflect my ruling necessarily.
Page 12 was not included in any of applicants' proposed strikes and not one that you included.
Not that I don't trust you, I'm just trying to.
No, I appreciate the backstop.
On the level here. Okay. So I'm sorry, it was page 12?
Yes, Your Honor.
What lines?
We're looking at the after that quotation.
All right.
So on page 12 of his rebuttal, Mr. Ellis provides calculations of WEPCO and WG's market to book or MB ratios, which are greater than 1 for each individual member of the proxy groups. Do you agree with these calculations?
I have not performed those calculations.
Okay. Could you agree that subject to verification, those appear to be accurate?
I'm looking at Mr. Ellis's summary of those, not an analysis of those. I don't even believe that Mr. Ellis provided an analysis of the market to book ratios in his testimony, just a statement that they are above 1. Can you provide the analysis that was prepared?
We can. We are, expert provided expert analysis and summaries of data, just like you did, Ms. Bulkley.
Well, I'm just saying I don't believe I've reviewed that. I don't believe I've reviewed that analysis prepared by Mr. Ellis.
Understood.
I don't believe that was provided for my review, just his testimony.
All right. I want to go back to the value line thing just briefly and ask if you've examined how value line forecasts ROE.
So we're back on rebuttal.
I don't think we need to pull it up for that question, Your Honor.
Okay. Generally, you're speaking towards that figure.
Yes.
I'm sorry, what's the question?
The question is if, Ms. Bulkley, if you've examined how value line forecasts ROE.
I would have to go back. I'm sure I've read the value line manual at various points, but I don't have the ability to recall that for you in detail off the top of my head. There is a document produced by Value Line that describes each of the reference points on each company report that they produce, but I would not be able to recall that for you off the top of my head.
Okay. I'm going to go back to the stream of future cash flow questions. So previously you agreed that one investor who pays more for the exact same stream of future cash flows than a second investor who pays less would earn a lower return. Do you still agree with that statement?
Yes.
You also agreed that expected return and cost of capital are synonymous. Do you still agree that the expected return and cost of capital are synonymous?
I'm sorry, do you still agree?
The expected return and cost of capital are synonymous.
I'm sorry, I don't recall her testifying that,
I don't either.
so I object.
Any response?
No, please.
Yeah.
That goes back to page 4, line 40 on the surrebuttal. That was the first question I asked.
Well, I seem to recall that answer was given. Let's read the question back.
The first, yeah.
This testimony we're looking at here, it doesn't address the expected return.
Exactly
I
right.
could we go back to the first question I asked?
You mean read the record back on the first question?
Yeah, because I believe I asked that exact question.
Okay, we can try. Let's go off the record.
Well, then I'm going to object to it's asked and answered. If you're just asking the same question again.
Well,
Now we have on the record that she said no.
Let's not pancake objections. Let's deal with one at a time. So let's see if we can find.
I was just trying to go back to that line of questioning, not.
Almost there.
No worries.
Ms. Ferris was longer than I thought. Okay. I'd like to start on page 4 of your rebuttal. Answer on their question. There on line 40, you state the cost of equity is an estimate of the investor acquired return in the current proceeding. This is the return that investors are required to invest in the companies. Do you agree that the cost of equity is equal to investors' expected return? I don't see that on. What line number are you on? I thought you said 40. Question 4, line 40. It's what's on the screen right now. And then she asked if you could have the question read back.
And her answer.
And then after the question read back, answer, yes, I do.
Okay, that's what I thought I heard. Okay. So where are we now? We just confirmed that was a question, it was asked and answered. And so would you now want to proceed with further questions, Attorney Cordy?
Yeah, sure. So let's turn to a utility investor, one who agrees with Value Line's ROE forecasts and buys utility stocks based on that. This investor, who must pay the market price, which is more than the book value, must expect a return lower than Value Line's forecast return on equity, which is calculated based on the lower book values, correct?
I don't know that I can necessarily say what that investor's expectation is.
Earlier, you said that investors can only buy at market value and not book value, right?
Yes.
So if they have to buy outside of book value, wouldn't they have to expect a lower return than if they could buy at book value?
I don't think their evaluation would be comparing book value and market value. I think they would be looking at the market value of the stock. I'm not sure I understand your question.
You testified that Value Line's ROE forecasts are market value figures, correct?
I think we looked at page 19 of my testimony, and I think we said that they were book value.
Yeah, sorry, I misspoke. Book values, right? And that
Correct.
investors purchase at market value.
Investors purchase at the stock price, yes, the market value. I'm not following your question, I'm sorry.
I'm gonna restate it here. So an investor who has to buy at market value, which is higher than the book value, must expect a lower return than Value Line's forecast return on equity, because that is calculated based on book value.
But they have a different expectation of cash flow. I don't know.
You maintain that investors expect to earn a return on an ROE, but ROE is based on book value. And to clarify, investors can't buy at book value. They purchase at market value, correct?
Investors purchase at market value. The first part of your question, I'm not sure I followed. So if you created a premise there that I'm not sure I agree with, because I didn't follow the first part of the question.
I think I have what I need. We'll move on. So since the cost of capital and expected return are equal, we can also say that the cost of equity for that stock is lower than the forecast ROE, correct?
I don't think we can say that at all. I'm not sure whose forecast we're referring to here.
I'm sorry, I have to go back to the investor hypothetical to try to get at this.
Let's go off the record for a second. Debbie, are you okay?
Oh yeah, I just wanted to open my window. I was
Oh, okay.
sweating. I was sweating.
It's you falling over or anything.
No.
Okay. All right, let's get back on.
So assuming an investor accepts Value Line's ROE forecast and buys utility stocks on that basis, this investor, who must pay the market price, which is more than the book value, has to expect a lower return than Value Line's forecast ROE because that's calculated on book value. Correct?
Objection asked and answered at least
I don't
twice.
feel like I've gotten an answer to this question.
Let's let her answer and then we'll.
You just don't like the answer.
I want to hear the
Provide
answer.
you an answer.
Go ahead.
I'm sorry, I didn't hear you, ma'am.
I said I'm not sure I can provide an answer, just like the last time the question was asked.
Okay.
All right. Okay. So because Value Line's ROE forecasts are based on allowed returns, we can also conclude that the cost of equity for the companies in your proxy groups are on average lower than their authorized ROE, correct?
I object. That is not, that's a mischaracterization of the Value Line returns.
Response.
All right, I'll move on. Looks like we get a ruling on that.
No, you can move on. I don't need the rule if you're moving on.
All right, I'd like to turn to page 17 of Ms. Bulkley's SIR rebuttal.
Now, can I go off the record? I got to check whether we've got
Okay.
a line prepared of what Ms. Bulkley would take out of her SIR rebuttal in light of today's ruling.
Okay, yeah, go ahead.
What was that, Berkline?
Um,
Did he say he has to check whether we've got Berkline prepared?
A red line
Or red line?
of Ms. Bulkley's SIR rebuttal, because
Yeah, yeah.
That's fine. That's all I needed. Sorry.
I don't have that prepared yet. So
Okay, well, I have the motion document here. Oh, it's, yeah, that's not gonna, well, there's no site. No, okay. There's, so they cite rebuttal 29, 31. Doesn't, so I don't have page 29 listed as being granted on the in terms of the motion. So if it's limited to page 29, this discussion should be okay.
may I just verify that, Your Honor? Because I think, it was, I think the site was to 29 through 31.
Oh, no, it's the page 29 through, I thought it was the line. Okay.
Your Honor, you in your order this morning allowed their proposed strike for page 23, line 1 through page 37, line 3. So all of that is in.
I did not allow. Yeah, so
Highlighting that matters now.
so I did not include that.
Lighting, I'm sorry.
This is what you allow.
Okay, that's what you allow. To be
So I allowed page 29, line 1 through page 37, line 3. So
I'm sorry, through page.
we're off the record.
Oh, we are.
Yeah. Oh, yeah.
Okay.
Your Honor, I've confirmed that, yeah, that 29 through 31 stays in.
Yes.
That's to be ruled. Yes.
So
proceed. Yep.
we're good with this. All right. Okay. So I think we can just get back on without any. You didn't raise an objection, did you? I don't think so.
No, I just wanted a chance to confirm whether or not.
Okay. All right. Okay. So let's proceed.
Thank you. Ms. Bulkley, on page 17 of your SIR rebuttal, which we're looking at here, you refer to Value Line's projected equity returns, i.e. their return on book equity projections, as we just established. To critique the cost of equity estimates, Mr. Ellis calculates from Value Line's dividend and price forecasts. But here, aren't you comparing the cost of market equity versus the return on book equity?
I don't believe so. Mr. Ellis's calculation was done based on stock prices and dividends.
Well, can you please explain your understanding of Mr. Ellis's analysis?
My understanding of Mr. Ellis's analysis was that he relied on dividends and earnings growth rates from Value Line to calculate a DCF model.
Do you consider stock prices and dividends market data?
If they were actuals, yes. But he's relied on forecasts of prices. So I don't think that's market data.
But either, regardless, you're comparing the return on book equity to Mr. Ellis's analysis of the market data.
I disagree that Mr. Ellis.
Okay, you can object. Okay.
That was asked and answered.
Yeah, okay, that's this thing.
All right. Thank you, Ms. Bulkley. No further questions, Your Honor.
Okay. Any other cross? No, all right.
Judge Newmark, I have a question.
Go ahead, Commissioner.
Hi, Ms. Bulkley. I'm Commissioner Tyler Hebner. Can you hear me okay?
I can hear you. Good afternoon,
Great.
Commissioner.
Hi. In your rebuttal, and I think it's Sir rebuttal, you talk about a credit rating downgrade. And I'm wondering, have you quantified what that cost would be for, you know, a certain type of credit rating downgrade, and what cost that would lead to for customers under various scenarios?
No, I have not. So a credit rating downgrade would typically lead to an increase in a debt cost. And that would depend on the timing in the market when you went to market for those issuances, which I have not attempted to calculate.
Okay. For Cub, Dr. Keim, in his direct on page 79, I'll have the judge pull that up.
Just give me a minute here. I think I'm there. What, where do you want this to be displayed?
I think if you can go down a little further, Judge. Right. So my understanding of his attempt here is to attempt to calculate, you know, what that cost could be under at least one scenario where the ROE is reduced commensurate with Cub's preferred rate of 9% ROE, and then the cost of long-term debt and short-term debt is increased by similarly by 1%. And if you just scroll down a little further, Judge, his conclusion is that on balance, the annual savings would be 0.3% under that scenario. I didn't see any response from you on that particular piece, and I was just curious if you found that to, you know, be reasonable. Is that something that we as commissioners can look at as possibly the pendulum swing? If ROE were to go down 1%, would the cost of debt go up 1%? Is this formulation of that calculation, you know, accurate from your perspective?
So I don't believe that that formulation is based on any market data. It's just an estimate. It's just a illustrative example. And I don't
Okay.
believe that is actually based on an actual change in issuance cost
Okay.
resulting from a downgrade. So that would typically be very hard to estimate what that would be in the marketplace today. So I believe that was described as an illustrative example.
Okay. I think as you talk about credit rating downgrades, you do mention that would increase costs to ratepayers, correct? From your
Yes.
perspective? Okay. Would you also agree that reducing the ROE would decrease, holding everything else constant, just reducing the ROE would decrease cost to customers?
If it were reasonable to hold everything else constant,
Right.
yes, but I certainly at returns like 9%, the testimony that I've provided demonstrates that there would be other consequences and that things wouldn't be constant. But yes,
Right.
if you were to just change that one number in this calculation, you would have a reduced cost. I just don't think that would be.
I'm sorry, you would have a
reduction in cost, but I don't believe that would accurately reflect the market reality of the reduction in the ROE.
Right. Okay. I think that's my question. Thank you.
Sure.
Okay, thank you, Commissioner. Any other cross? All right, do we have redirect?
Yes, Your Honor, a little bit. If we could stay on that page of Dr. Keim's testimony just a moment.
In this place, or should I scroll up?
No, right here. That's good. Ms. Bulkley, if a utility was downgraded, let's say if Wisconsin Electric was downgraded, its credit ratings were downgraded as a result of the commission's award of a rate of return of 9%. Would you agree that not only would its long and short-term debt go up, but its capital structure may also change? But what I'm getting at is you discussed earlier these utilities in the country where they had negative outcomes from the credit rating agencies as a result of unfavorable ROE decisions, and they couldn't or chose not to go to the market for additional capital. And so that's the basis for my question of whether or not the capital structure could change as well.
Yes, you could experience a change in the
Rephrase that. I'm sorry. Can you just rephrase that to put that premise first? That your question's on capital structure. Is that?
Yes, I'm sorry. Yes, I'm asking you, in addition to the increase in cost of long-term and short-term debt, could the credit rating downgrade also affect the company's capital structure?
Yes, I would agree that is also a possible outcome, and that appears to be what will be the case for Pinnacle West in the example that we were talking about earlier today, where they will not be accessing the capital markets for equity until after their rate case, and they will have capital investment that's needed over that time. So that will result in a change in their capital structure. That's an example of that circumstance.
If a company chooses not to pursue additional debt, could a result be an increase in its equity ratio under its capital structure?
Yes, it could be. It could be that the parent company retains. It could be that they reduce a dividend. There are a lot of things that could be done to manage cash flow to cover the capital requirements that are needed without going to market. So there are a variety of things that could occur that could change the capital structure.
And if the equity ratio increased, that would increase customer costs in the next rate case, correct?
Yes, it would.
Objection, Your Honor. I think it's been established that Ms. Bulkley is not an expert in customer cost implications.
She answered questions from the commissioner about that. I didn't hear an objection then.
I wasn't going to object to Commissioner Heatner.
Well, it's evidence is evidence.
I'll allow it to the extent she knows and can testify as an expert on it. Yeah, it's on the record. It's fine.
Sorry.
I have a responsive question to that, but I'll let Attorney Jackson finish, obviously. Thanks.
You're welcome to go ahead as long as we're on that subject. Might make sense.
Okay. In the example of Pinnacle West, should they need more funding, they've said they're not going to raise equity. So wouldn't that require them to instead get loans?
They said they weren't going to the equity market to address this. So what they've done actually is they will be managing their capital program. So they may not, so in the Pinnacle West example, they may not make the investments that they intended to make, and may manage within their existing capital structure. They may retain more earnings would be another option. You could retain earnings and retain more in the operating company, which would change the equity ratio. So there are other ways other than accessing the debt market to manage the capital, the need for capital without going to market.
Okay.
I don't know what their plan will be, but.
So I just want to interject, however, that I'll be including in the record the decision of the Arizona Corporation Commission with respect to Arizona Public Service and their holding companies, Pinnacle West, the company we've been talking about. And just so we're clear, that the reduction ROE is not the only disallowance that was part of the ACC's decision in that case. And the order will show that, but I just want to make sure the record reflects, as we're speaking here today, that when we're talking about the response to markets as a result of the ACC decision, there's more to that decision than just the reduction in ROE, and in fact, a pretty significant disallowance for SCR investments.
Maybe I'll just ask it more directly. Could it be the case that a company who decides they're not going to go to the equity market would instead go to the debt market, and thus their capital structure would actually move towards a lower equity layer and a higher debt layer?
That's possible. We would have to take into consideration in the cost structure then that the greater the leverage of the company, the higher the cost, right? So you have to take into consideration that the more risk that you create in the entity, the higher the overall cost for equity and debt as well, right? The leverage ratio will actually be a factor in that analysis. So as you start to lever up the company, that doesn't come without a cost.
Okay, thank you.
Sure.
Okay, are you ready to continue, Attorney Jackson?
I think so.
All right, smart to defer to the commissioner though.
And just to stay on the same topic, just a minute more. So Ms. Bulkley, I understand you correctly that if Arizona Public Service issued additional long-term debt and increased its leverage, your point is that rate of return for that long-term debt may increase. Do I understand that correctly?
Yes, and excuse me, and you would also expect that the investor required return on equity would increase going forward as well, because an equity holder standing behind debt in the order of pay, in order of priority, would be expecting a higher return the greater the leverage of a company.
I'm sorry, I think you cut out for me.
The greater the leverage
of the company. Sorry.
Okay. think that's all I had for that. If I got to take you back to questions Mr. Corte was asking you, it seemed like a number of his questions were premised on the idea that the market equity or the market value for stock is necessarily higher than book value. Do you recall those questions?
I do.
Is that always necessarily the case?
It's not always the case, no.
The stock price could be equal to book value, correct?
Yes.
It could be lower.
Yes, that's correct. You could have a market to book greater than 1, equal to 1, or less than 1.
Ms. Ferris asked you questions about the 4 utilities you discussed in your testimony that have suffered negative ROE decisions and credit rating consequences. She asked you if those utilities could no longer provide safe and reliable service. I think she referred to it as impaired service. Do you remember those questions?
I do.
You answered no. You thought they could continue to provide safe and adequate service, but in your opinion, is the ability of those utilities to raise debt and equity capital impaired?
Yes.
Getting back to that NARUC primer, do you have it in front of you, at least electronically, that you could read? And so we know for sure that it exists and what it is. Could you read the title and indicate when it was published?
Yes, let me just pull it up again. The title of this document is Cost of Capital and Capital Markets, a primer for utility regulators. And it's produced by it's December 2019. It says this publication was produced for review by the United States Agency for International Development, USAID, and was prepared by the National Association of Regulatory Utility Commissioners, NARUC. The author of the report was John Quackenbush, who is a CFA and has worked on various regulatory commissions, and his credentials are provided in this report. He was on the Illinois. He worked for the Illinois Commerce Commission, the Michigan Public Service Commission.
Was he not the chairman of the Michigan Public Service Commission at one time?
Yes, he was the chairman of the Michigan Public Service Commission. That's correct.
Is there a date on that report?
The report date is December 2019.
Ms. Bulkley, would you be able to provide an excerpt of that report containing the provisions that you were discussing on the record?
Yes, I could do that.
Your Honor, I'd seek to have that excerpt entered into the record as an exhibit, please.
Okay, what we can do is we'll mark it, and that would be Bulkley 22. And I don't think we need to go through the motions of the motion, but we'll just file it as the understanding will be filed as a request for additional evidence, at which time parties can take a look at it and, if necessary, object once they see.
Your Honor.
I'm sorry.
My apologies. We would just ask that the full report be included.
I was getting to that. Yep. But thanks
Thank you.
Thanks for listening. That's all. That's all I'm going to say right now. Thanks for listening. So yes, let's include the full report. So it'll be cover page, full report, and let's have the report be text searchable. Do we know how many pages are in that report offhand?
Yes, it's a 40-page document.
Oh, short in our world. Okay, perfect. Yeah, that's fair. I don't want to. Timing is an issue as it is overall in this case. Generally speaking, a NARUC publication should have some weight, but I want to see it. I think parties need a chance to see it. And to the extent it's being used one way or another, it's best to just have the full report available for everyone and the commissioners to review. So yes, we'll let that in as bulkly. Well, we'll have it offered as bulkly 22, and we'll await any objections. And again, similar to yesterday, if there is agreement that this is a good filing, acceptable filing to everyone, let's just, well, can't do that. If it's possible, if you could preview that to parties and staff, and if you can get agreement that it goes in the record, then you could just file it with an explanation saying parties and staff agree. That would be the most efficient way to do it. If not, there's 3 days to respond. Everyone can just respond saying they agree to its admission. I'll leave it up to parties to figure out that part of the process, but that's the general understanding. So yeah, I'll allow you to offer that, and we'll take care of that in the future in terms of receiving it into the record.
Ms. Ferris, if we're putting in the entire document, are you able to say right now whether Cub will have any objection?
No, I'm not.
That's fair. I just wanted to ask.
Yeah.
Okay.
I'm guessing Attorney Jackson that we won't, because I think it's relevant. It is a little bit of a new introduction, but we're all for as complete a record as possible.
Okay. So yeah, well, understood, Judge. Thanks.
Okay, great. Any other redirect?
I'm thinking.
Don't take too long, but okay.
Right. No, I don't have any more to redirect. Thank you.
All right.
Can I ask a recross question?
Oh boy. Okay, I'll allow it. Be quick though.
It's quick. So Ms. Bulkley, looking back over the past few decades, do you have any historical examples of a credit downgrade or reduction in parent company stock price leading to an inability of a utility to attract capital?
As I discussed earlier, the Pinnacle West case is the most recent case that comes to mind.
Yeah, I think you've answered that in various forms.
Okay. And no other examples going back a decade or two where we could look at the long-term implications of the credit downgrade?
I don't have that off the top of my head now.
Have you
Thank
looked?
you.
Have you looked back that far? Have you done the research?
No, I don't believe we have.
Okay.
Yeah, I don't have that information.
Okay, so any redirect, or is that your redirect?
That's it.
Okay, all right, thanks. Your excuse. Okay, I don't know if, let's go off the record. I'm not sure if witness Adams might be available to take someone quickly. Otherwise, I'm expecting questions for Keim and Singletary to be fairly intense.
Yep. I'm here.
You're here. All right. You got. Don't have to ask twice. I like that. Okay.
Can you hear me okay though?
Yes. Yeah.
Okay. Great.
Okay.
Okay. So Stephanie Bedford, Assistant General Counsel, appearing on behalf of the Public Service Commission.
Okay. Yes.
Are we back on?
Not yet. No.
Okay.
Okay.
Well, let me get back on the record and I'll swear you in. So raise your right hand. And you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay. All right, go ahead.
Please state your name for the record.
Justin Adams.
What is your position at the Public Service Commission of Wisconsin?
I am a financial analyst.
And did you file or cause to be filed direct and rebuttal testimony in this docket?
I did.
Did you also file or cause to be filed 2 exhibits in this docket?
I did.
Are the statements and representations in the testimony and exhibits you filed in this case true and correct?
They are.
Do you have any additions or modifications to your testimony or exhibits at this time?
I do not.
Your Honor, the witness is available for cross-examination.
Okay, thanks. Any questions? No? All right, thanks. You're excused.
Thank you.
So off the record, can other staff witnesses wait through?
Wait.
Yeah. I'm sorry.
Sorry, there was some audio playing. I couldn't hear what you said.
Oh, okay. We're off the record.
Okay.
To my knowledge, other staff witnesses can wait. However, witness Mike Ritzema would prefer to testify sometime between 4:05 and 4:35 due to some incidents of background noise that will be occurring at his location.
Okay, well, that's good enough reason for me. I'm glad it's good that he's precise. Let's just make sure we can appreciate that. Okay, well, why don't we take him out of order and yeah, so if is he available now?
I don't know that he's available yet. There are some piano lessons being conducted at his location until 4:05.
Okay.
So
And
if
we'd
we
have
could
to be
slot
done-
him,
And we'd have to be done by 4:25 because he has a lesson at 4:30.
Your Honor, I think we have one more applicant witness too. Mr. Stasek.
Oh, yeah, okay, that's true. All right, so we'll take Stasek and then see where we're at that point. Yeah, I can't guarantee where we're gonna end up, what time we'll end up on this.
thank you. I appreciate the effort.
All right, so let's call Stasek.
Are we back on?
Let me just rename people here. I got him.
James Goldschmidt again, Madam Court Reporter.
Thank you. Kind of getting to know your faces.
It's unforgiving. That's the hard part.
All right, I think we're ready. All right, let's get you sworn in. Raise your right hand. Swear or affirm, tell the truth, the whole truth, nothing but the truth.
I do.
All right, go ahead.
Mr. Stasek, would you please state your full name and spell it for the record?
Sir, name is Richard F. Stasek. Last name is spelled S-T-A-S-I-K.
Mr. Stasek, did you prepare a cause to be prepared and filed in this matter direct, supplemental, direct, rebuttal, and surrebuttal testimony?
I did.
And did you also prepare a cause to be prepared and filed 15 exhibits supporting your testimony?
I did.
To the best of your knowledge, were your testimony and exhibits true and accurate as of their filing?
Yes, they were.
And is there anything in your testimony or exhibits that you wish to change or correct today?
No, thank you.
All right, Mr. Stasek is available for cross, and I believe Your Honor may have had one clarifying question.
Yes, yeah, I want to just do that first. And yes, okay, so I'm going to display. So welcome back, witness Stasek, to our new case today. Anyway, room here. Okay, so I'm going to just putting on display your direct page 12 that relates to changes made in the method of determining the energy related portion of production plant costs allocated to customer classes. And I was just curious, why did that change from past cases to this case?
Certainly, and the response will be the same as yesterday, but ultimately the change was going from using forecasted LMP data to historical LMP data. So by using the actual historical data, the cost of service studies provided resulting therefrom,
will provide a more precise and transparent allocation of the energy-related costs than had we continued to use the forecasted methodology for this allocation.
Okay, great, thanks.
I also, not to interject, but I believe there were 4 sort of general questions. We're going to tee those up the same way today as we did yesterday, related to where in the record our preferred position is and where in the record it's located, for revenue requirement, gas cost of service, electric cost of service, and then the revenue allocations for both gas and electric.
Yes, okay, why don't you do that while you're here?
Okay. So first and foremost, I was just run through in the same order I did last time, simply because I think it flows. The first is the overall revenue requirement. The company's proposed position prior to the settlement was stated in Joe Zagant's revised Exhibit 1 that was filed on July 8th. The IRF reference number, the PSC reference number for that is 442277. On the cost of service for gas, our preference is for cost of service A, which in our direct case was referred to as the company's base cost of service. The record identifies this preference at page 3, lines 21 through 23 of company witness Korducki's direct testimony. That was filed his revised direct testimony, I apologize. That was filed on June 1st. And the ref number for that is 439200. The preferred electric cost of service, the company's preferred cost of service is cost of service 4, which also, like gas, is the same as the company's base cost of service filed in its direct case. We actually show this preference documented on page 3, lines 13 through 14 within my rebuttal testimony. That was filed September 23rd with a ref number of 447964. Then moving to revenue allocation, first for gas. The company does prefer the revenue allocation that aligns with cost of service A. The record evidence there documenting that preference is on page 3, lines 21 through 23 within witness Korducki's revised direct testimony, June 1st, 439200. It's essentially the exact same reference as the cost of service question because they're combined.
Okay.
On the preferred electric revenue allocation, the company recommends that the commission adopt Ms. Maney's, a witness from WIG's, proposed electric revenue allocation. The record reflects that on page 2, lines 13 through 14, within company witness Nelson's surrebuttal testimony, which was filed October 3rd. The ref number for that is 448619. I think that covers all of the questions that you had, Your Honor.
Great, thank you very much. Okay, so anything else for this witness from the company?
No, Your Honor.
Witness is available for cross? Okay. All right, do we have questions, cross questions for the witness?
Your Honor, Walnut Way has a few questions for Mr. Stasek.
Okay, go ahead.
Thank you. Good afternoon, Mr. Stasek. How are you?
Good afternoon. I'm well. Yourself?
Good. Thank you. My name is Awais Khalil. I'm an attorney and working with Walnut Way Conservation Corp. I'm going to ask you a couple of questions about uncollectibles, something you wrote about pretty extensively in your direct testimony. Let's start by referencing Exhibit 5 of your direct testimony. And I'd ask specifically to go to Schedule 2, which is, I believe, the 4th page in this 6-page exhibit. And that 6 pages includes the title page.
You guys see the Schedule 2, page 101?
Yes, Your Honor. Thank you.
I'm gonna remove that from the screen, provide you the rest.
Thank you. Now, Mr. Stasek, excuse me. looking at that top box underneath jurisdictional allocation, direct assignment from budget, is it correct that what we're looking at here is the total uncollectibles for Wisconsin residential and Wisconsin non-residential?
What we're looking at there are the items that were forecasted to flow through the uncollectible expense in the test year.
Okay. No, I understand what you're saying. The total uncollectibles for the test year 2023, it's estimated to be at, for residential customers within Wisconsin Energy's service area, is $23,284,180, correct?
Yes, that's what's on the schedule.
Thank you. And as part of Wisconsin Energy's cost of service studies, these uncollectibles, there are costs that are factored in, correct? They're just part of the study.
Yes, as is the case with all other costs.
Absolutely. Not supposed to be a trick question, just trying to establish some foundation. Now, referencing your direct testimony, you talk about how residential uncollectible costs are directly assigned to the residential class. I believe that's on page 25 of your testimony.
Specific line by chance?
Yeah, just pull it up here. It's on page, it's lines 9 and 10.
Yep, I see that there.
Okay, so is it an accurate statement that the $23,284,180 in projected uncollectibles, those will be directly assigned to the bills of other members of the residential class, correct?
Yes, functionally, that's how the flow would work through, correct?
Yeah. And these non-collectible costs, these are essentially for customers whose bill was not paid, right?
On that particular, I mean, at the end of the day, the short answer is yes, but it's not quite that straightforward. You know, there's a period of time where they go through collections, are ultimately written off, and at that point become uncollectible.
I appreciate the clarification. That's helpful. Now, to the best of your knowledge, how long has uncollectible costs been included in Wisconsin Energy's cost of service studies?
To the best of my knowledge, well, I can say to this point, I've been in this job for about 6+ years, and it's been there since I've been here. Beyond that, I can't speak to what happened before then.
Sure. And in the 6+ years you've been with Wisconsin Energy and doing the position, or in the positions that you've been in, have you come to learn approximately what percentage of residential uncollectibles are coming from low-income customers?
That's not an area of expertise that I have. We don't get into that level of detail when compiling the cost of service studies. I don't know.
Okay, I appreciate it. Thank you. To the best of your knowledge, is Wisconsin Electric proposing any new initiatives to avoid situations where customers are unable to pay their bills?
You're suggesting as part of this docket?
Correct.
In the context of new, similar to what I believe witness Idukas testified to earlier this morning, we don't have any new programs, but we are looking to extend the LIFT program, the Low Income Forgiveness Tool program, to assist our low-income customers.
Thank you. Now, and you kind of spoke to this already, following up on something you said earlier, customers who are not paying or unable to pay their bills, these are also the same customers whose energy is often disconnected, correct?
I'm going to object just on foundational grounds and that this is beyond the scope of the cost of service study. If he knows the answer, he can answer.
Okay, we'll let him answer if he can.
If I could be so kind as to just have the question read back.
Yes, go ahead. Oh, please, please read it back. That's what I should say.
Question now, and you kind of spoke to this already. Customers who are not paying or unable to pay their bills, these are also the same customers whose energy is often disconnected, correct?
I guess the way I would answer that question is typically disconnections occur after an extended period of non-payment and several attempts to work with customers to find alternative payment arrangements.
Mr. Stasek, are you familiar with Wisconsin Energy's general policy surrounding disconnection?
I guess I'd ask for a little bit more detail, what you mean by general policies.
Sure. Well, let me ask, does disconnection of electric services usually occur remotely or physically?
To my knowledge, again, not being a distribution person, but as I understand it, it depends on the infrastructure that is in place at a particular place of service. If we have the technology to remotely disconnect and therefore reconnect as time is right, we would leverage that. To the extent that that technology does not exist, it would require a physical visit to facilitate a disconnection.
To the best of your knowledge, are the costs of remote disconnection the same or different as physical on-site disconnection?
That's outside of my expertise. I don't know exactly how those costs are allocated and ultimately bubbled up, if you will, on a per instance for remote disconnection.
Okay, thank you. I'm sorry for interrupting. Do Wisconsin Electric customers who are disconnected due to non-payment, do they have to pay a reconnection fee?
I believe that's generally the case, but again, that's not my area of expertise. So to the best of my knowledge, I believe that is correct.
Okay. And so I won't ask you follow-up questions about that. I appreciate your answers. I have no additional questions for this witness. Thank you, Mr. Stasek.
Thank you.
I did have a follow-up since we've already dug into this a little. I just want to make sure we're clear on just one point or two. And I just wanted to look back at your Exhibit 5, Schedule 2, where it shows the uncollectibles by a variety of by functional classes. It's small, medium, large. And I guess what I'm wondering is the forecast for uncollectibles, does that incorporate the proposed rate increase and any prediction of how the rate increase might increase cost of uncollectibles?
I don't believe it does. My understanding, I do not put this particular forecast together. We received this from our finance department, but as I understand it, it is based on a historical trend over the last, I believe it's 3 years, but I would have to confirm that. But I do not believe there's a specific element to account for any specific increase.
And you offered that exhibit as part of the overall cost of service study production. It's one element of the cost service study. You're not necessarily involved in each input to that cost of service study.
That's correct, Your Honor.
Okay, I think that's all I have. And all right, any other cross?
Cup has some brief cross.
Okay, go ahead.
Good afternoon, Mr. Stasek.
Good afternoon again, Attorney Ferris.
In your role as Director of State Regulatory Affairs, in preparing the company's originally filed electric revenue allocation in this docket, the one that was filed on April 28th, did the company design revenue allocation so as to limit the electric rate increase to residential customers?
I would say the short answer to that question is yes. What I would just stop there. The answer is yes.
Okay. And then just one more question about the bill insert that the company began distributing on July 29th. That was pulled up several times as Nelson Exhibit 10. And my question is, will a new bill insert be sent out to residential customers that updates the information regarding 2023 increase?
Based on my understanding and how things have happened in prior rate cases, we are required to provide notice to customers. Typically, we use the bill insert, but should there be different language in a commission order, we would certainly comply with that method to share with customers what the final authorized rate increases were.
Thank you, Mr. Stasek. No further questions.
Okay. Just to follow up with that question, what's listed in Nelson 10 as the impacts of the company's proposal back when it was first applied for, the numbers, the figures that appear on that notice would be different if you were going to use the current proposal from the company. Is that correct?
It would be, yes.
And would it be higher or lower?
Depends which numbers you're talking about, because there's movement across different customer classes in different directions, Your Honor.
Okay, so just pick one here, the electric residential class.
So that one, all other things equal, that number would be higher using the revenue allocation that we support at this stage in the case, Your Honor.
Okay, and that those figures are in the record. We already know.
Yes.
Okay. Okay, that's fine. Thanks very much. Any redirect?
No redirect.
Okay.
Your Honor, I'm sorry to interrupt. I don't know if those numbers are in the record. I don't. know
Wait,
if-
I'm sorry, who's talking?
Sorry, this is Krista Westerberg.
Oh, there we go.
I don't know if I saw that with Nelson's rebuttal.
So maybe a point of clarification, I guess the revenue increase percentage that would go to each of those classes is in the record. But if we're talking about the specific impacts of a 660 kilowatt hour residential customer, I would have to check, but I believe that Attorney Westerberg, would be correct. I don't think that specific number is in the record. So I may have misunderstood the question.
Okay, and well, I don't know, I won't speak for staff. I know they do create exhibits like that in other cases, but possibly not in this size of a case, so. Okay, but that was my point. That was the question I was asking, is the percent is reflected in that revenue allocation update that you had already spoke to.
Yes, the percent would be there, but the specific dollar impact for a 600 kilowatt hour customer, that precision is not there.
Okay, thanks. And thanks for clarifying that. Okay, well, with that, any redirect about that?
No, Judge.
Okay, great, thanks. You're excused.
Thank you. And I believe that's all of the company's witnesses.
Yay. Just a few more to go. We're probably going to be due for a break here. Let's just do it 20 minutes if we can and get back here at 10 after 4. And I don't know, I guess we'll try to take.
You're off?
Yeah, we're off. Yeah. Is
can we Claire?
It's the dog.
Okay, now turn to page 16.
So Mike, are you okay?
Yes.
Yeah, so I think we'll just try to take you next, hopefully.
Okay, that'd work out well. Thank you. Appreciate it.
Your Honor, this is Barry for Walmart. It is almost 5 o'clock Eastern time where I'm at right now, and unfortunately, I have a commitment at 6 o'clock my time. Walmart doesn't have any more evidence to present in this case. Would it be okay with you if Walmart was excused at around 5 o'clock your time?
Oh, yeah, we're taking the witnesses by affidavit, right?
Yes, yes, sir. That's
Yeah,
correct.
so I'll leave that up to your risk.
Okay, all right.
If you want to, yeah.
Okay, thank you, Your Honor.
All right, so we'll be in recess for a few more minutes. So I don't know if Mike, if you heard, we'll be in recess. Fortunately, I said 10 after 4. Hopefully we can get back in enough time to get you done. Hey, Mike, how you doing?
Your Honor, you're on mute. I can't hear you.
Oh, I don't
It's not on mute.
think I'm muted.
I can hear him. I just got a hand massage.
All right. So how many more hours are you ready to go for?
About 45 minutes.
Okay. Just tell me when we're done.
Now. No. No, it's just
Uh,
I start to cramp after a while. So
Mr. Newmark, Klaus here. I can hear you too, so.
Yeah. Let me try if I can do something over here. Yes.
Sorry,
Oh,
my end.
yep. I got you. Okay. So I wanted to mention before we get started, it's just in response to the timing here, we have, is it possible to not give that number in confidential and just
Yes, it's very possible.
speak, and then your refiling could just have the number?
Yeah, I think the route that we're going to go with those corrections, again, is not going back to revise the previously filed testimony.
Okay. Yeah. Not revising. the testimony.
Correct. My understanding is that the witness's testimony today can supersede that testimony without us having to go back and refile.
But then we'll need to go into closed, right? To get
Right. We will, but it'll be the testimony itself will be more brief.
Wait a minute, I don't have any corrections to my confidential.
Oh,
The correction would be all in public.
Okay, then no worries.
I did the confidential correct calculations correctly
For this one.
All right.
for this one.
Second time's a charm. Well, okay,
Yeah,
so
blind squirrel finds a nut once in a while.
We're all getting better with repetitive process.
So I just wanted to be clear though. So when you, regardless of whether you make a correction on the record at the hearing, if you're changing something in, so I think we probably still want to have him have Mike refile the SURB. Well, yeah, it's the public version we're talking about. So the public
Yes.
portion. So if someone just picks up the filing without benefit of the transcript,
Sure.
they won't read the wrong number. Or the wrong
Right.
head. So it doesn't. So either if the correct process would be to put it in with an errata, and then we'd have both documents available for today. But since we don't have the written errata, we'll just make a verbal errata. But then you still want to incorporate it into the final testimony.
Okay.
Okay. But to the extent that his testimony is in response to subsequently filed SUR rebuttal testimony and or testimony that took place at the hearing today.
Right. Then it's just on the transcript.
And it's just that's my understanding.
Yeah. Okay. All right. Whichever way it is, then you know where we're going. Okay. All right. So we're going to get started. Yeah.
So Mike, we're not going to be doing anything with the confidential, just to
Right,
confirm.
that's correct.
Okay.
Okay. Good.
That saves a step.
Okay. So I don't see everyone here, but I don't know if this is all too controversial, and we do want to move ahead given the time of day. So I did say we'd be back at 4:10, I believe. Is that?
Your sign said 4:15.
Oh, the sign said 4:15. Okay.
It was hard. It was hard to not take those extra 5 minutes.
No, that I understand. I guess it was from a previous extraneous number from, boy, when does that ever happen?
So there's other reporters that put up a countdown when they're on a break. They put up, I don't know how to do it, but they put up instead of in my box, it would say the countdown.
Oh,
so when you're supposed to be back. So maybe I should look into that.
Well, now we know who was listening and who was just looking at the screen.
Well, I just saw Mike hop on and I figured I better jump on too.
Yeah, I wanted to talk to him ahead of time too. So. All right, 4:15. So as I've displayed on the screen, we were coming back at 4:15. So I appreciate everyone getting back the time I displayed. But let's take witness Ritzema because of his time constraints, and I believe this shouldn't take very long. So we'll swear you in. Raise your right hand. And do you swear or affirm? Tell the truth, the whole truth, nothing but the truth.
I do.
All right, go ahead.
Please state your name for the record.
Michael Ritzema,
And what is your position at the Public Service Commission of Wisconsin?
Public Utility Auditor Principal.
And did you file or cause to be filed rebuttal testimony in this docket?
Yes,
Did you also file or cause to be filed exhibits in this docket?
yes,
And are the statements or representations in the testimony and exhibits you filed in this case true and correct?
subject to the, what I have to say about witness Keller's Cercer rebuttal testimony.
Certainly.
And given her comments, I believe that her exhibit 3 is probably more accurate at this point than my exhibit 1, and particularly in reference to the calculation of delayed retirements. And in any event, the capacity values that Ms. Keller cited in her Cercer rebuttal and on the stand today of $82.19 per megawatt day for June through August, and $24.16 per megawatt day for September through December are not inappropriate.
And does that complete your clarification of your rebuttal testimony?
Yes, it does.
Thank you. Your Honor, the witness is available for cross-examination.
Okay, great. Just want to confirm you had 2 exhibits. Is that right?
Yes.
Okay, great. All right, any questions for the witness? Okay, seeing none, thanks very much. You're excused.
Thank you for accommodating my schedule, Your Honor. Appreciate it.
I'm glad we could fit you in right on time. Okay, so anyone else that has a time constraint that we can take quickly? No, okay. Someone's knocking on the door here. Okay. All right, so let's continue with our traditional order. We'll start with the next party on the list, which I believe we have Cleveland, Wisconsin. So do we have witnesses that there's, I think Alice has, there's cross?
Yes, Your Honor.
Sorry, who said that?
I think that was Joe Wilson.
Oh, okay.
Off the record. So I'm not seeing the witness yet. So we could switch to Cub witnesses if they're available.
They are, Your Honor.
Your Honor, this is Attorney Patrick Proctor Brown.
Yes.
If our understanding is that as a result of the ruling on the motion to strike earlier today, that there's no affirmative ROE recommendation from Mr. Ellis. And based on that understanding, if that's correct, we would not have cross for him.
Okay, well, so far my ruling is what it is. So if it doesn't isn't overturned, then I guess that's how the record will be reflected. So if under that, with that understanding, then that's fine. You can forego questions. So does anyone else have cross for witness Ellis? No.
Walnut Way is curious about what the affirmative ROE recommendation would be if there's something that he's recommending that would provide savings for residential customers.
It's been struck. So the portions of his testimony that have an affirmative ROE recommendation in it were struck as a result of the ruling. So he doesn't have a recommendation in the record, is our understanding. Where he says 5.45 is my recommendation for Wisconsin Electric, that's no longer in the record.
Yeah, and that's consistent with my ruling. So, so I guess my question's still out there. Does anyone else have questions for witness Ellis? Okay, so can witness Ellis verify filings by affidavit?
Your Honor, we had some direct.
Okay. All right, well, we can wait. Oh, I do see his connection, but he's just not there, huh? Okay, we probably spent enough time on just trying to find him at this point. Let's switch to Cub.
Sorry, you're looking for Mr. Ellis? He's on the line.
Yeah, well, okay, there we go. Yeah, that's what we were doing. Okay, you're unmuted. Okay, great. So let's press on then. I'll swear you in. Raise your right hand. Do you swear or affirm? Tell the truth, the whole truth, nothing but the truth. And you're muted. Just wondering. I can do that for you. There you go. Now you're unmuted. Okay. Okay, perfect. Thank you. All right, go ahead.
Thank you, Your Honor. Mr. Ellis, could you please state and spell your name for the record?
Sure. Mark Ellis, MarkEllis.
Thank you, Mr. Ellis. Are you the same Mark Ellis that prepared and caused to be filed the rebuttal testimony in 33 associated exhibits in this docket, all subject to today's ruling on joint applicant's motion to strike?
Yes.
And to the best of your knowledge, are the answers you provided in your testimony true and correct?
Yes.
Do you have any corrections to your testimony other than the errata filed yesterday?
No.
Great, thank you. We're going to address a few assertions from Ms. Bulkley's rebuttal testimony, beginning on page 6. Ms. Bulkley characterized your employment at Sempra. Is her characterization correct?
No.
I'm sorry, before we move on, is it Sir rebuttal?
Just Sir rebuttal, Your Honor.
And what page were we on?
Page 6. So, Mr. Ellis, you just testified that you disagree with Ms. Bulkley's characterization of your employment at Sempra. Would you like to respond to that characterization?
Sure. So Ms. Bulkley is correct that I was responsible for Sempra's corporate cost of capital function. She then points out that the requested and authorized ROEs that the Sempra Utilities, SDG&E, and SoCalGas made during the—
I'm sorry, the Sempra Utilities.
SDG&E, San Diego Gas and Electric.
Thank you.
And SoCalGas, Southern California Gas.
Thank you.
Were significantly lower during my tenure with Sempra than the ROEs. Actually, I'm not sure how to address this now because she compares the ROEs that they requested and were authorized to my recommendations, but my recommendations have been struck.
The question is about
she tries to make an association between myself and the ROEs that the Sempra Utilities, SDG&E, and SoCalGas requested during my tenure at the company. So in my testimony, I state that I was the chief of corporate strategy at Sempra, which is the parent company, not at SDG&E or SoCalGas. And I was responsible for developing cost of equity estimates for Sempra's entire portfolio of companies, including its non-utility businesses. Due to affiliate compliance rules, I was not involved in any way in the proceedings Ms. Bulkley has cited. Like many other utilities, SDG&E and SoCalGas commissioned third-party consultants to develop the returns on equity they proposed in their cost of capital applications. I should point out that during my tenure, Sempra's internal cost of equity estimate for the company as a whole, as disclosed in proxy statements filed with the SEC, was significantly lower than the ROEs SDG&E and SoCalGas requested in their cost of capital proceedings, on the order of 3 to 4%. This is significant for two reasons. Sempra at the time was a holding company that owned not just SDG&E and SoCalGas, but a variety of non-utility businesses like renewables, natural gas pipelines and storage, energy marketing, and LNG terminals in the US and internationally. Many of these non-utility businesses had significantly higher risk profiles than SDG&E and SoCalGas. In addition, Sempra carried debt at the parent level, which further increased the corporation's equity risk profile and therefore its cost of equity relative to SDG&E and SoCalGas during that time period. Consequently, internal estimates of their cost of equity, i.e. for SDG&E and SoCalGas, would be even lower than the 3 to 4% range for Sempra as a whole. The second reason this is significant is because the recognition of the wide gap between authorized ROEs in excess of 10%, as Ms. Bulkley cites, and an actual cost of equity less than half that amount drove Sempra's strategy over the subsequent years. Sempra went on to exit nearly all of its non-utility businesses. In addition, acquired another utility business, Encore, a Texas wires-only distribution company.
Thank you. Next, I'd like to turn to page 8 of Ms. Bulkley's rebuttal. Beginning at line 10, this testimony claims that you testified that the company's ROEs and equity ratios can be reduced without adversely affecting their ability to raise capital. Is that what you said?
Yes.
Ms. Bulkley claims that they would be adversely affected. Why do you disagree?
I disagree because Ms. Bulkley does not specify what adversely impacted means. Does it mean that they will not be able to raise capital at all? Well, that's clearly not the case. As Dr. Keim demonstrated, utilities always have access to the capital markets, both debt and equity.
Your Honor, I would like to object.
In my testimony,
This is referring to a section of Ms. Bulkley's testimony that's directly responsive to struck testimony for Mr. Ellis.
Okay, so we won't proceed any further on that line of question.
Your Honor, the issue of whether equity ratios being reduced would adversely affect ability to raise capital has been discussed by other witnesses and was a live issue today at the hearing.
And it should have been his direct testimony in accordance with the scheduling.
I'm sorry, Mr. Proctor, I couldn't understand you.
Need to speak up a little bit. Maybe we don't need to, maybe you can shift the microphone closer to you since there's no witness on your end.
Thanks. Sorry about that. Yeah, Your Honor, my response is he should have addressed it on his direct testimony in accordance with the scheduling rule. Now we're living in a world where his testimony has been struck. Ms. Bulkley's testimony will be revised, and it's not appropriate to continue that debate in what is effectively sir rebuttal on the stand here.
Your Honor, this portion of Ms. Bulkley's rebuttal cites Mr. Ellis's rebuttal testimony at page 22, which is not a portion of the testimony that was struck.
That's incorrect to my understanding. I'm looking at it right now, and page 22 is struck entirely.
Okay, let's go off the record for a second. That seems to be what I recall.
Apologies if I'm mistaken. I see nothing struck between page 9, line 4 and page 38.
Okay, so we're off the record. So I'm looking at my notes that I used to make the ruling. And right, so stricken lines end at page 9, line 4. And then they pick up again on page 38, line 12. So in terms of the 20s, I think we're okay.
Okay, well, maybe that I'm mistaken, but what I was given to by an associate of mine is that 22 is struck, that's a response to our direct testimony, that single page of 22. But
well, that was what was moved. Yes, you moved to strike that, and I only accepted your motion in part. And just so you understand, we're off the record. Are we off the record? Okay, you got your eyes down at your keyboard. Just so you understand, maybe I don't know if you were available at the time. So my ruling was to strike what the applicant identified as raising new issues that would prejudice joint applicants and should be stricken from the record. So inappropriate for direct testimony, but the rebuttal to Shipman and I think it was Shipman and Buckley is appropriate for intervener rebuttal. So that's why it's only approved in part. So there are parts of the rebuttal testimony that you move to strike, but are still going to remain in place, and then the subsequent responses can remain in place from the company witnesses.
okay, then I guess the thing that was prepared and given to me was incorrect. So apologies for that.
Okay, no, that's fine. Okay, so let's move on. Yeah, so in terms of discussion of the questioning of Mr. Ellis based on rebuttal Buckley 8, we can proceed and we'll continue to proceed on the record with those.
Did you want to say that again? Wait, did you want to say that again? Because I wasn't on.
Yes, you're supposed to know. No, you're not. All right, it's back on the record. So yes, we are going to proceed based on my original ruling in the morning, and we can continue on with questions on the record for witness Alice related to Buckley's rebuttal, page 8. So go ahead, Attorney Cordy.
Thank you. I'm going to repeat the last question. I think we got a partial answer, but I think there would be more there. So Mr. Ellis, Ms. Buckley claims that they, meaning the companies, would be adversely affected. And the question was, why do you disagree?
Yeah, I disagree because Ms. Buckley does not specify what adversely impacted means. Does it mean that they will not be able to raise capital at all? That's clearly not the case. As Dr. Kime demonstrated, utilities always have access to both debt and equity markets. As I demonstrated in my testimony, across the board, utility authorized ROEs far exceed their cost of equity. So the cost of equity can be reduced without adversely impacting utilities' ability to raise equity because investors could still expect to earn their expected return. Does adverse impact mean that their cost of debt might increase? Perhaps, but adverse impact also applies to customers. Does the increase in the cost of debt outweigh the savings from a lower cost of equity? As Dr. Kime demonstrated, the increase in the cost of debt is unlikely to outweigh the savings from a lower cost of equity. In my testimony, I explained that utility ROEs can be reduced and their equity ratios adjusted to maintain their credit quality, i.e. with no adverse impact on their cost of debt. As I explained in detail in section 4 of my testimony, ROE, capital structure, and credit quality are interrelated. ROE and equity ratio can be adjusted subject to a credit quality constraint to minimize customer costs while ensuring the demands of both equity and debt holders are met. Wisconsin Electric and Wisconsin Gas do not provide the commission sufficient analysis to determine the combination of ROE and equity ratio that does so. For example, how much will interest costs go up for every 100 basis point reduction?
Sorry, sir, can you say, for example, can you slow down a little bit?
All right. For example, how much will interest costs go up for every 100 basis point reduction in ROE? And how will that affect customer costs? Similarly, for every 100 basis point reduction in ROE, how much would the equity ratio need to be increased to maintain the same credit rating? And how would that affect customer costs? As I explain on page 20 of my testimony, it can be readily demonstrated that the net effect of reducing ROE, even after adjusting for a higher equity ratio to maintain the same credit rating and cost of debt, reduces customer costs, not increases them, as Ms. Buckley asserts without any quantitative support. Ms. Buckley simply makes a sky is falling argument that any reduction in ROE or equity ratio will adversely impact the utility's ability to raise capital. But yet her argument is belied by one of the very examples she cites. Arizona Public Service has an A3 rating for Moody's, the same as Wisconsin Gas, despite the recent reduction in its authorized ROE below 9%. Figure 6 in my testimony illustrates that there are many utilities with both lower equity ratios and lower ROEs than those proposed by Wisconsin Electric and Wisconsin Gas, yet they have comparable credit ratings. The burden of proof is on WEPCO and Wisconsin Gas to demonstrate why other combinations of ROE and equity ratio that would reduce customer costs aren't viable. I provide ample evidence that other combinations of ROE and equity ratio could be viable in terms of reducing customer costs while meeting the demands of shareholders and debt holders. But WEPCO and Wisconsin Gas have failed to explore them, or if they have, failed to share that evidence with the commission. Finally, I don't believe adversely impact on the utility by itself is an established regulatory criterion, at least as not as used by Ms. Bulkley. If it were, any reduction in ROE, no matter how excessive the current ROE might be, would be prohibited because any reduction can be construed as adverse. Rather, the regulatory criteria are fair and reasonable. As I demonstrated in my testimony, current authorized ROEs are excessive. They are not fair and reasonable, and they should be reduced.
Thank you, Mr. Ellis. I'd like to turn to page 15 of Ms. Bulkley's rebuttal. Here, Ms. Bulkley criticizes your use of GDP growth rate in your MSDCF model, claiming you use a 1.41% growth rate. Is that the rate you used?
No.
So again, this, I'm fairly certain, is affirmative testimony in his rebuttal.
Okay, well, let's check the page number on it. Do you have a page number, Attorney Cordy?
His DCF growth rate model in general, I believe, is affirmative.
Right, but my ruling is limited to what the company moved. So I'm gonna stick to those page numbers. So we can double check. Let's go off the record for this, just for checking the pages here.
Sorry, I'm trying to find it as well, Your Honor.
You have a better handle on it than me.
Yeah, sorry. We're doing our best to adapt with the ruling this morning. This is on page 74 of the rebuttal testimony, Your Honor. I believe.
No, 74 doesn't reference the DCF growth rate at all.
There's 1.4%, line 8, 1.26. Is that what we're talking about?
Yes.
Yes, Your Honor.
All right. Yeah.
Oh, I heard, are you talking about GDP growth rate, not DCF growth rate? Those would be different things. So
the GDP growth rate, yes.
Growth rate. Okay, I misheard.
Let me just double check here so we're all on the same page. So 77 through 77 line 9 to 79 line 2 is stricken. So we're still okay for now.
Right, and some of the DCF growth rate information, to my understanding, Your Honor, back on 47 is stricken, 47 to 49.
I can ask the question without referencing the DCF model.
Right, but just so we know, I'm sticking to the motion, what was moved to strike, because I can't go through line by line what may be considered appropriate direct or appropriate rebuttal at this time. We just can't go through that. So I'm starting with the company's request, and I approved part of it and rejected part of it, and that's where we're sticking in terms of what's stricken. So,
The specific, this is a very specific correction of something that was in rebuttal where it was claimed our witness used a different figure, and that's what we're looking at on page 74 is the correct figure.
Okay, so let's proceed. Let's get on the record. And I don't know if we have a pending question, but why don't you re-ask what we were asking that started this?
Thank you. Mr. Ellis, on page 15 of her rebuttal, Ms. Bulkley criticizes your use of GDP growth rate, claiming you use a 1.41% growth rate. Is that the rate you used?
No, I didn't use 1.41. I'm not sure what or where Ms. Bulkley, I know where she got the figure, but she appears not to have interpreted my testimony the way I wrote it or the way it was intended. So figure 24 on page 74 gives the breakdown of how I build up to my GDP growth rate. And you can see there in bold, the very last line is 2.69. So I start with a real long-term GDP per capita growth rate, which is aligned with the approximate 100-year history of the market's dividend growth rate. It's grown roughly in line with GDP per capita, not with GDP as is commonly assumed. And that's just due to net share issuance over time. So I start with the GDP per capita in real terms, and then I add an estimate of long-term inflation, 1.41%, to arrive at the total long-term GDP growth rate of 2.69%. And that's there in figure 24, and also in the accompanying text on line 10, 2.69. Ms. Bulkley appears to have confused my long-term inflation forecast with my GDP forecast, and then completely ignored the fact that I explicitly add inflation. Her critique, which she says is, oh, his GDP growth rate is lower than long-term inflation, is just completely unfounded.
Okay, off the record for a second. Did we lose Attorney Cordy, or am I just not?
He's done.
I'm sorry?
I said he's done.
Yeah, maybe that's unfortunate. I heard a bell go off, and
Yeah, I think he's having some technical issues.
I'll hear you.
He's going to log back in right now.
Okay, here we go. So he may need to read that answer back.
Oh, okay.
Okay, so Attorney Courtney, are you back with us?
Hi, Your Honor. Zoom just kicked me off for no apparent reason. Sorry about that.
You know, and I need to restart. Something must have happened here. I need to restart my computer because that answer is all kind of mush here.
All right.
Oh, will that fix the mush, or do we have to restate the answer? I guess we'll see.
Probably restate the answer.
You're leaving us now? Is that
No, I'm not leaving Zoom. I just looked up. I just looked up and it's frozen at before the question was even asked. I have Mr. Ellis on page 15 of her SIR rebuttal and then nothing.
Maybe I should just had it all stricken and be here.
Sorry, I wasn't looking at my computer and I didn't see that. So
we'll need to, okay, we'll see what happens.
Should I go back to this question on about page 15?
Okay, where is he?
He's here. He moved, so he might be on another page for you now.
There you are. Oh, you're the last one down in the corner.
Yeah, usually it kicks you back to the bottom.
Okay, there you are.
Okay, so where are we at with the transcript, Debbie? Is it
Mr. Ellis on page 15 of her SIR rebuttal, Miss Bulkley, and then it doesn't look, it's, okay. I think something like I must have hit something on my keyboard because it just,
you just started
funny.
Question.
Yep.
Okay, all right, there we go. We have our job to do now.
I apologize.
Oh, that's fine. Hey, this is not easy for anybody. So especially you're having the heavy lift. So let's start with the question over again.
Sure, third or fourth time's a charm.
Yeah, let me reiterate for witness Alice just to speak slowly because I think this late in the day, especially, it's difficult to transcribe. Okay, go ahead.
All right. So looking at page 15 of Ms. Bulkley's SIR rebuttal, she criticizes your use of GDP growth rate, claiming you use a 1.41% growth rate. Is that the rate you use?
No, it's not. Ms. Bulkley appears to have misread or misinterpreted that section of my testimony. Figure 24 on page 74, and it was up on the screen a moment ago. In the text just below it, give the breakdown or the buildup of my long-term dividend growth rate. I start from a real per capita GDP growth rate of 1.26%. And this is based on the average of forecasts from the CBO, the Congressional Budget Office, the Energy.
I'm sorry, the what office?
Yeah, Congressional
Thank
Budget
you.
Office. the Energy Information Administration, EIA, which is part of the US Department of Energy, and the Social Security Administration, take the average of their long-term GDP per capita forecasts in real terms, and that's 1.2%. 1.26%. And I use per capita GDP growth because over the last approximately 100 years, dividends for the market as a whole have grown in line with GDP per capita, not GDP, as is commonly assumed. I then add a market-based long-term inflation rate of 1.41% based on the spread between nominal and inflation-protected treasury securities. And this is a widely used method of estimating the market's expected view of future inflation. So when you add those two, and that is 1.41, and then you add the 1 to 1.26, there's some rounding of digits, but it ends up equaling 2.69%, which is my long-term GDP forecast rate. Ms. Bulkley appears to have confused my long-term inflation forecast with my GDP forecast, and then completely ignored the fact that I explicitly add inflation. Her critique is simply unfounded.
Thank you. I'm going to turn to page 16 of Ms. Buckley's rebuttal. On this page, Ms. Bulkley defends her use of EPS growth rates into perpetuity. Do you agree that that is reasonable?
No, it's not reasonable. In section 5A of my testimony, I'm not sure the page number.
Okay, let's go off the record and just make sure we have our pages correct. We're in the right.
It begins on page 23, and we can check to make sure that hasn't been struck. I believe it's still.
I do too, but I want to be triple sure. And I'm sorry, you said begins at page 23?
Yes.
Okay, yes, that's good. So you can proceed with that answer.
So I go through a long list of reasons why estimating the perpetuity growth rate as the constant growth DCF model requires from analyst estimates is not reasonable. I provide actually 6 reasons why estimating long-term perpetuity dividend growth from analysts' 3 to 5 year EPS growth rates forecast is not reasonable. The most obvious one, and this is one that Dr. Keim also identified, is that analyst estimates have a very long and well-known history of being upwardly biased. And so that would tend to inflate whatever number you get when you run the constant growth DCF model. That doesn't mean they should be completely tossed out. And in my testimony, this is where I say I recommend actually using them, just that we should use them with caution and skepticism and make sure our model results are not too heavily dependent on that one input variable. On page 27, if you scroll down, I also show that EPS is actually not a very good proxy for dividend per share. And the DCF model is modeling dividends per share. And how I illustrate this is I just show the correlation of right there, figure 7 there.
So Your Honor, this is, I just want to interject for the purposes of time. We're at 4:45. Other witnesses need to go. We're now just referencing back to rebuttal testimony. It's not.
I will just give I will give just the 6 reasons.
Previous.
We have a pending objection.
I'm sorry, you're both talking, right? Go ahead.
So let me interject here. So we have a pending objection, but if the witness could please conclude answering this question quickly, and we'll move on.
Okay. So first reason is biased in the estimates. Second one is that EPS is a poor proxy for what the input variable, the input parameter that the model actually requires, which is dividend per share. The correlation between the two is actually quite low. Third reason is that the forecast horizon is inconsistent. So for example, Value Line, the forecast horizon is 2018 to 20 to 2024 to 26. but the models used by all parties and the DCF models used by all parties or who use them in this testimony, in this proceeding, the forecast horizon begins in 2022 or 2023, perhaps. So the incompatible forecast horizon. Fourth reason is incompatibility with the DCF model result using the constant growth and analyst estimate EPS growth rate forecast is inconsistent with analysts' own expected return forecasts. So I conducted an analysis that compared value lines, the DCF model using value lines, EPS growth rate and dividend yield to their own internal estimate of the cost of equity. And there's also very low correlation there. Probably the fifth reason is that if the EPS estimates are incompatible with the long-term historical trend for utilities as a whole, their long-term dividend growth rate has just kept pace with inflation, whether you look at the entire sector as a whole over the last nearly 100 years, or the Ms. Bulkley's proxy group over the last 30 years. In both instances, dividend growth has kept pace just with inflation. In contrast, the average of the EPS growth rates that Ms. Bulkley used are on the order of 3 to 4% higher than inflation. And finally, the sixth reason is that it's economically impossible for the analyst estimated growth rates to be sustained into perpetuity. When you project earnings for total earnings for the market as a whole based on analyst estimates, what you find is that they grow from about 8% of GDP today to over 100% of GDP by the end of the decade. So it's economically impossible for companies on average to sustain analyst EPS growth rates for 10 years, much less into perpetuity. And this fact was actually recognized by Ms. Bulkley's Brattle colleagues, who describe in a report that they produced for the Dutch government about the unsustainability of analyst estimates into perpetuity.
Just object to the reference to it. ECMA, it's not in the record.
It is in the record. Sorry.
Well, if it's in the record, then it was described in the rebuttal testimony. So I don't think Sir rebuttal direct during the hearing is an appropriate time to summarize your prior testimony.
We're ready for our next question, Your Honor.
All right, let's push on quickly, please.
On page 18 of Ms. Bulkley's Sir rebuttal, Ms. Bulkley is asked if she agrees with any elements of your critique of her CAPM analysis and responds no. Can you please address that response? We'll try to do it briefly, Your Honor.
I'll object to that question. How can he address Ms. Bulkley's disagreement in a one-sentence answer? Like, what is he going to add to that answer that she already put in testimony?
Your Honor, does counsel have a specific objection? Since
that it's not appropriate
answers need to be
for Sir testimony to restate your prior testimony.
Off the record. So I understand the standing criticism when we get this late in the day that we don't need to rehash what's already in the record. I think we have a standing rule that unless a witness is going to retract something in response to filed testimony, the witness need not state that failure to say they continue to disagree is not waiver that because they didn't make that statement. It doesn't mean that they agree with opposing testimony. So just with that kind of basis, I mean, if there's nothing, if the witness can say, well, I disagree with Sir rebuttal and it's explained on page such and such in my rebuttal, that's all we really need for purposes of tonight's proceeding, because it's laid out in the rebuttal. Is there anything else he would need to add to besides?
No, but could we direct, could we do that and direct people to our rebuttal testimony to respond to Sir rebuttal? Like, point out where we say that?
Well, yes. I think you're just saying you haven't changed your mind.
That's correct.
Yeah. So, and it's assumed that you haven't changed your mind, even if you haven't stated that affirmatively. I mean, so technically you don't really have to do that. But if you want to make sure the commission understands your position hasn't changed, it happens all the time where witnesses will get up and say, I disagree with this because in my rebuttal, I said blah, blah, blah. But just keep that short. If you just say it's in my rebuttal, page such and such, we can move on. It's, you know, as long as your answer isn't changing and you can rely on your rebuttal, that's the easiest and cleanest way to just address your concern that you want the commission to know you haven't changed your position, but not get involved with just rehashing what you said before.
Understood, Your Honor. We can do that.
Okay, great. So with that understanding, should we read the question back?
Yeah, I'll rephrase.
Okay, if that's helpful, let's do that.
On page 18 of her rebuttal, Ms. Bulkley is asked if she agrees with any elements of your critique of her CAPM analysis and responds no. Could you direct the commission to portions of your testimony that address this response?
Section 8B and C.
Sorry, B and B, like boy?
B as in boy, C as in cat.
Thank you.
Specifically address these issues. I'm just checking to make see D. Yeah, D as well.
Okay. And
so B, C, and D. I'd like to add that Ms. Bulkley asserts that she does not agree with any of the elements of my critique of her CAPM analysis and rebuttal, but she actually provides no substantive refutation of any of them. She compares, well, that will be struck. And then she defends her use of she maintains that she examined a wide variety of beta calculation methodologies and refers to the same text that I did in my testimony. But I just want to point out that she doesn't even follow the advice of her colleagues at Brattle to look at a variety. Like she cites the book in which says, it talks about monthly returns, daily returns, and weekly returns, and a variety of trailing price histories from 1, 2, and 5 years. But she actually doesn't follow any of that advice. She only looks at 5 and 10-year trailing histories and weekly returns. So I find it odd that she would defend herself by citing the same book I did, but actually doesn't follow that advice, which was my main critique in citing that book, is that she does not actually look at the spectrum of beta calculation methodologies.
Thank you. I believe this will be our last question, Your Honor. Mr. Ellis, Ms. Bulkley attempts to refute your estimates of Value Line's implied cost of equity estimates by citing Value Line's forecast ROE, which are higher than your cost of equity estimates. Is this a valid critique, and can you briefly respond to that critique?
Sure.
Off the record for a second. So where do we see that in the Bulkley testimony?
Page 17, Your Honor.
And then the table, figure 4.
In the table on page 18 that we referred to during Ms. Bulkley's cross.
Okay, and that's looking for page 29 to 30, which I believe is 29. Yes, okay, all right. Okay, go ahead, thanks. We'll get it back on the record.
So I'll continue. No, it is not a valid refutation. She's comparing apples and oranges. She's comparing ROE, an accounting metric that investors cannot expect to realize, to an expected return based on the projected cash flows they can expect to receive, i.e. a market return or an expected return on equity or a cost of equity. They're all, as we all agree, or as Ms. Bulkley agreed, they're synonymous. As the narrative primer that Ms. Bulkley introduced explains, forecast ROE is not market-based. On page 19, if we want to show it, if you want to bring it up, Brett, the narrative primer.
That's not me, Mr. Ellis. It's
yeah,
Judge Newmark.
In the testimony, page 19.
So this was the narrative primer that Ms. Bulkley introduced today.
I'm sorry, this was the what?
The NARUC.
Oh.
Yeah, we don't have that. I don't have that available.
Oh. Well, I will just quote the relevant passage. Forecast.
That will be in the record. So if you can just cite to the page.
Page 19.
Okay. And you can just generally speak of it.
Yeah, so the forecast ROE is not market-based or forward-looking and is often criticized for being circular. In other words, it's looking at authorized ROE instead of actually trying to estimate the cost of equity, particularly when utilities are utilized in the proxy group, which is exactly what Ms. Bulkley has done. Used utilities as the proxy group and forecast ROEs. So it's not a relevant comparison.
Thank you, Mr. Ellis. No further questions, Your Honor.
All right. Witnesses available for cross. So let's have questions.
No cross-examination from Jenny.
Anyone else for cross? All right, then that's all we have. Thanks very much. You're excused.
Thank you.
Okay.
Your Honor, if I may.
Yes.
I previously noted that Renew Witness Kel wanted to do a live verification. He's had a time constraint come up. Will only be on a little bit longer. If we may be able to fit that in quickly, it would be appreciated. If not, we would do an affidavit.
No, thanks for chiming in. Let's take witness Cal now. It should be brief. I'm assuming no cross at this point anyway. So let's swear you in. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right, go ahead.
Thank you, Your Honor. Good afternoon, Mr. Kell. Can you please state and spell your name for the record?
Andrew Kell, ANDREWKELL.
Thank you. And could you please state the name of the party that you represent in this proceeding?
Renew Wisconsin.
Okay, Mr. Kell, did you prepare and cause to be filed direct testimony and two accompanying exhibits and rebuttal testimony in this case?
Yes, I did.
And is that testimony true and correct as of the time it was written to the best of your knowledge?
Yes, it is.
Do you have any corrections to the testimony?
No, I do not.
And if asked the same questions today, would your answers to those questions be the same?
Yes, they would.
Okay, thank you, Mr. Kell. The witness is available for cross.
Okay, did you need to add a statement?
No, not this time, Your Honor.
Oh, okay, not my mistake. Okay, any questions for Cal?
None from joint applicants.
All right, no one else? Okay, thanks very much. You're excused.
Thank you, Your Honor. And we'll submit affidavits for the other two Renew witnesses.
Yes, that's, yeah, I expect that. Yep, thanks. Okay, anyone else we can take quickly? And staff can still wait around for a while. We're running into issues. Any concerns with staff?
I haven't been alerted to any other time constraints from staff.
We'll push on that. All right, so yes, I see Dr. Keim is at the plate here. Great, so let me swear you in. Swear or affirm, tell the truth, the whole truth, nothing but the truth.
I do.
All right, go ahead.
Please spell your name for the record.
I'm sorry, who's speaking?
I'm sorry.
Oh, okay.
Am
That's okay. Your box wasn't lit up. I got you.
Oh, okay.
Thank you.
My name is Steve Keim, S-T-E-V-E. Keim, K as in Kevin, I-H, M as in Mary.
And Dr. Keim, did you prepare and file or cause to be filed direct rebuttal, rebuttal, and 4 exhibits?
Yes.
And is your testimony and the information contained in those 4 exhibits true and correct to the best of your knowledge?
Yes.
Okay, let's refer to the questions at the bottom of Judge Newmark's offered evidence list.
Yes.
Could you please respond to his question regarding recommended ROE and cost of equity?
Yes, the return on equity in my testimony is 9.0. It's in my direct. I had it marked, but it seems to have scooted off the screen here. Do you need the page number, Your Honor?
If you have it
Right.
I had it, but bear with me for a second. I flagged it. I marked it. Bear with me for a second.
I can find that.
Yeah, I just had it, but it went to the top of my testimony. Oh, here it is. It is on my direct is on page, or my ROE recommendation rather is on page 76 of my direct at the top, lines 1 and 2. Oh, excuse me, lines 6 and 7. I'm sorry, line 6 and 7. And then my, if you're ready for my cost of equity, Your Honor.
Yes, yeah, go ahead.
That is on page Sir Rebuttal 7, lines 1 and 2. So my ROE recommendation was 9 from the 9.0. And my cost of equity range is 6.3% to 7.8%.
Okay, great, thanks.
Do you have anything additional to add to your testimony at this time?
I do not.
All right.
Your Honor, Dr. Keim is available for a question.
Great. We have questions for the witness?
Yes.
All right, go ahead.
Good afternoon. Good evening, Dr. Keim. Joe Wilson on behalf of the applicants.
Good evening, Mr. Wilson.
I think you just stated your recommended cost of equity in the case is now at 6.3 to 7.8%, right?
Correct.
And Cub's overarching argument in this case is that ROE should be driven toward that number. Is that fair?
That is part of the framework is that you would move in that direction, but we also said that it should be modified with performance.
Can I just interrupt? Mr. Keim, or Dr. Keim, can you lower your camera or maybe move it up so I can see? Nope, the other way. There you go.
There?
Thank you.
I'm sorry.
It's okay.
Okay.
Thank you, Dr. Keim. Would you agree that a firm's cost of equity is ultimately set by the investors who buy or sell stock of the company?
Yes, it's set in the marketplace by institutional investors who trade the securities.
Do investors rely at least in part on blue chip interest rate forecasts when making investment decisions?
No, I don't think they do. We talked about that yesterday. I went and did additional research, and it shows that those forecasts simply interest rate forecasts are not used by investors. That they're simply not used.
Okay. You have to subscribe to get the blue chip forecasts, right? That's not a free service.
That's correct.
Okay. So who's subscribing to the blue chip forecasts, in your opinion?
The people who are looking for what is referred to in the economics literature as cover. They're people who don't feel comfortable making a forecast on their own. And so when they make a report or talk to their management, it's usually people within business or within organizations who can say, I pointed to the blue chip forecast as my estimate. That way, if there's something wrong, they're sort of with that crowd, but it's used as they call in the economics literature, sort of cover or a reference point. It's not used by investors.
Are those people within those firms not investors?
That not in the context that I'm talking about. They would be like executives or analysts, things of that nature, not people making buy and sell decisions on stocks and bonds.
Okay, so in your opinion, an executive in an investment firm is not an investor?
I'm not, I was talking about corporate executives. So, but the executives in the investment firms would not, if they're making portfolio decisions, they're not using them.
Okay, so your testimony is that no investors use blue chip forecasts of interest rates to make investment decisions.
The financial evidence suggests that they are not used because they are so highly inaccurate.
I want to ask about your opinion at page 2 to 3 of your rebuttal testimony. We talked about this a bit yesterday, but it has to do with spot estimates.
I'm sorry, did you say page 2 to 3?
Yes, correct.
I'm there.
Okay. at the bottom of page 2 and top of page 3, you advocate for the use of spot estimates to forecast future dividend yields and interest rates, right?
Yes.
And spot estimates of future dividend yields and interest rates are correct only on the day that is picked for the estimate, right?
They're the most accurate on the day that they're used.
The very next day, the spot estimate will change and the prior spot estimate will no longer be accurate, right?
That's how a random walk works. That's correct.
And sometimes volatility in the market can result in a significant change in the spot estimate, even from one day to the next, right?
It can be volatile, but doesn't mean it's changed the accuracy.
Right, but the estimate can change considerably from one day to the next, right?
It certainly can.
The spot estimates used in your original DCF analysis from July 15 are no longer accurate, are they?
Nor would anybody's be. It's always the most recent data that's the best estimate.
And this is borne out by your spot estimates from September 26th. Just to summarize, your estimate of cost of equity has gone from 6 to 7% on July 15th to 6.3 to 7.8% as of September 26th, right?
I'm sorry, I didn't hear the first range of numbers that you gave. I just didn't hear the first.
Yeah, the first range was 6 to 7%.
Okay, that was a general thing. We talked about that yesterday. I actually have a more specific. I'm willing, in the interest of time, it's pretty close to 6 to 7, and I have the more specific numbers that you referenced. So I'll agree with that.
Okay. At page 7 of your rebuttal,
Yes, I see that on the screen.
okay. Sorry, I'm just looking for my spot here. Is it correct that your testimony is that despite the increase cost of equity, which you acknowledge between July 15 and September 26th, that there's not evidence of increasing cost of equity generally?
Are you, well, they're not related. There's no despite there. There's a number at one point, there's a number at the next point. Doesn't tell us anything about where they're headed.
Okay. You have no idea what the spot estimates will be on the day in November that the commission has decided in this case, do you?
Nor does anybody else, but I can tell you what the best estimate it is. It's whatever it is today.
To your knowledge, will the commission incorporate a spot estimate as of the day it makes its decision in conducting an ROE analysis?
I'm not sure what the protocol is these days. It used to do that when I was on the staff. We used to file a spot estimate 5 days before the decision. I haven't been involved in this process for a while, so I'm not sure what the commission will use.
I want to talk a little bit about the 2007 Madison Gas and Electric decision, which was actually discussed in Mr. Singletary's testimony, but I believe you have some knowledge of.
Yes.
If we could take a look at Mr. Singletary's rebuttal testimony, at page 13. There we find an excerpt from the commission's decision in a 2007 MG&E rate case, docket number 3270 UR 115, correct?
That's correct.
And were you a member of the commission staff when that decision was issued?
Yes, and I was the lead rate of return analyst in that case.
Okay. Did you draft the ROE section of that decision?
I provided an initial draft, but it gets edited multiple times by multiple parties, multiple staff people, and then ultimately edited by the commission. But I did the original draft.
Okay. Is the text shown at the bottom of page 13, top of page 14 of Mr. Singletary's rebuttal consistent with the draft that you provided in that case?
I think so. I think the counsel's office added the site to Federal Power Commission, but it's essentially the argument that I made with perhaps that legal site added by the counsel's office.
Okay. Your Honor, could we pull up exhibit Singletary 5, which is the full decision we're discussing here? And specifically page 12 of the Westlaw numbering. It's at the bottom right corner of the pages.
I'm going to try 12 and see how close we get. Okay. There we should be.
Yeah, that's it. Okay. So the commission's discussion of return on equity is mostly contained on one page, which makes it easy here. So based on this decision, would you agree that the commission agreed with your approach in this case of determining a cost of equity using cost of equity models and then considering other factors to arrive at a allowed ROE?
Yes.
And in this case, well, I should ask, would you have been the one running the models referenced here?
Yes.
Okay. In this case, you used a discounted cash flow, a capital asset pricing, and a risk premium model. Is that correct?
I think we talked about this yesterday. I actually don't remember. I certainly would have used the discounted cash flow model because that's the core model for the staff. I just can't recall if I used the other models.
If we look at the second paragraph on this page and just take a quick minute to read it.
Yeah, okay, so I see what you're saying. It says that all those models were used, so apparently that's what I did.
Okay. You don't have any reason to dispute that you would have used all three of those models, right?
I think I would trust the order is correct.
And based on those models, you arrived at a cost of equity range of 8.1 to 9.1%. Is that right, according to this order?
Yes.
And a median cost of equity of 8.4%, right?
Correct.
So what risk premium model did you use in this case?
I'm sorry, so what?
Risk premium model did you use in this case?
Thank you.
I can't recall. It would have been some kind of market risk premium, not an ROE risk premium, because I've never used an ROE risk premium, but I don't remember the actual mechanics.
Okay. Suffice to say, or is it fair to say that you accepted the use of a risk premium model to determine the cost of equity in this case, right?
Well, a risk premium defined as a market risk premium, not a book risk. Excuse me, not a book risk premium.
In our current case, this rate case, 5 UR 110, are you proposing the use of any sort of risk premium model?
Well, the capital asset pricing model is a form of risk premium model, but I think you're asking me a more specific question. Do I have a separate, is your question to me, other than the cap, do I have a separate risk premium? Is that what you're asking me?
It is.
I do not.
Continuing to focus on Singletary 5 here, you identified other factors that would be considered with the cost of equity in order to arrive at an ROE. And those factors, I think there were 6 of them, were provide economic incentives, maintain rate stability, price utility services in keeping with those observed in other industries, consider consumer interests, consider existing investors, and recognize managerial efficiency. Is that fair?
Those are the ones that the commission, I think I came up with most of those, but I think 1 or 2 of those came from the rate analyst who was applying Bond-Bright, BONBRIGHT, Bond-Bright's principles. That was a little bit more of a concerted effort, but those are mostly my suggestions.
The text in the first paragraph on this page says that under commission staff's approach, the cost of equity is just one of 7 key factors. So your testimony today is that there were other staff in addition to you who came up with factors?
Just in this one area, because as I said, the Bond-Bright principles, so some of those look like those are Bond-Bright principles. I was largely in charge of it. They would have been in, so I would have embraced those. I wouldn't have fought them. But I'm just saying that the original ideas, I think, came from, I'm trying to remember who the rate analyst was, and it just escapes me at the time. But I would embrace those as the reasonable numbers, if that's what you're asking, or the reasonable factors.
Would you continue to embrace those today as reasonable?
I'm sorry, the first part of your question cut out.
I'm sorry. Would you continue to embrace those today as reasonable factors for the commission to consider in setting ROE?
Yes, those are definitely useful and important factors.
Based on your estimate of the cost of equity and those factors, you identified an ROE range of 10.5 to 10.75%, and we see that at the top of the second column. Is that right?
Right. To be clear, that's the ROE range. That's what you're asking me? And yes, that's the ROE range.
Yeah, that's what I said.
Okay. Yes. Yeah, I agree. That's correct.
If I might object, these questions are all in the record. One can read the order and see this, and I'm just not sure it's the best use of everyone's time to go through the lines of this order one by one.
Well, I think it's very relevant to understand. Well, we have a unique opportunity to understand what Dr. Keim, the author of, or the architect of this framework, as expressed in this order, was thinking, and how he was applying the approach that he's advocating in this case. So I do think it's relevant to walk through a real world example of how he did that.
Okay, look, we can proceed with that.
So is there an outstanding question? I'm sorry.
I don't think so. Neither you nor Mr. Singletary have identified a recommended ROE in this case other than 9%, right?
That's correct.
So the ultimate outcome of this, the commission's decision in this case, was that they awarded a authorized return of equity of 10.8%, correct?
It's in the order. I don't remember. I'm sure if we scroll down the page, we'll find it. That seems feasible. I just don't. Well, as Ms. Ferris says, the order will speak for itself. I just can't recall.
Assuming that's correct.
I'm sorry. I see it. The commission finds that a return on equity of 10.8% further down the page. It is in the order.
That result implies a premium over the cost of equity of 240 basis points to address the factors that we discussed earlier, correct?
It addresses the specific factors at that time. So the qualitative listing, and then you would have to consider where each of these things were. So at that time, it was the commission deemed it to be 240 basis points.
Right. Subject to check in our current case today, would you accept that staff's midpoint cost of equity estimate for WEPCO is 9.12%?
I'm sorry, I can't remember. I don't accept that if you're combining all of the return on equity models mixed in with the cost of equity models. I think staff's cost of equity is about 6.4 or 6.5. So I need you to point me to something, and I think you understand the distinction I'm making. I'm going to look at those numbers and pull cost of equity numbers out. I think they call them return on equities. This is the issue in the case. So I need an actual reference page to look at.
Sure. Give us a minute. I'll tell you what, in the interest of time, let's move on and we may come back to that. Okay. Can you cite any commission decision since this 2007 MG&E decision that we've been discussing, where the commission has explicitly applied this approach that you're proposing in this case of establishing a cost of equity and then setting a return of equity at some point above that based on consideration of some subjective factors or performance factors?
Not explicitly.
I want to just get a few exhibits into the record with you. We don't need to belabor this, and I don't have any particularly involved questions about them, but we want them in the record for briefing. Your Honor, these were distributed yesterday. Disclosure.
Off the record. So they're the pre-hearing notification?
Yeah, correct.
Okay, I have the email in front of me. If all goes well, they should appear on the screen as you call them up. So what's the first one you want to?
Sure. The first would be the document labeled Myers Finance Theory. There's maybe a couple we can handle together. The other one would be the Myers and Oruki. Basically, these are both referenced in Dr. Keim's direct testimony. They were not provided as exhibits to that testimony, but they were provided in Cubs Discovery responses on Monday. And we'd like to include them in the record for.
Okay. Is it possible we could reach the stipulation to include these in the record?
I'll stipulate to it.
Anyone object to just stipulating those?
Cobb can stipulate to that.
Okay, so let's see, are these?
So I think that would be Keim 8 and 9 for those two.
Yeah, and they are significant lengths, so we'll keep them separate. Yeah, let's go back.
I've got a couple more that fall in that category too.
So we're let's get on the record. We can mark. So we do have 3 Keim exhibits being 5, 6, and 7 being offered on my direction, and then
those, Your Honor, at least one of those is the MG&E order from 2007, so we can just reference Mr. Singletary's exhibit for that. And then I'm not sure what the third one is. So I would say it would be safe to label this one Exhibit 6. And then we can number ours subsequently.
Okay, well, I hate to take more time on this, but I think we do need to clarify this point. So I had created Keim 7, and it's the ER12 exhibit order.
Okay.
And
okay.
I think
Sorry, what was the ER? What was that ER12?
Are we? I think we're off.
No, you had me go back on.
Oh,
Do you want me to be off?
Yeah, take a break. Sorry about that. Yeah, so Keim 7 was 6630 ER12, and I think he cited to that in somewhere. So
Yeah, I did, Your Honor.
okay, and then 6. Is the MISO order, which is that a Keim reference? Do you recall that, Steve?
I referred to, I think I did refer to this, but I didn't put it in. Have you added it, Your Honor? Oh, yeah, that would be, let me just check. That's the Court of, yes, that's the Court of Appeals decision. Yes.
Okay. And then 5, because I may have switched this up with witness Singletary's presentation. So 5 is great. My computer's quitting on us. minutes. Okay, I'm not able to bring that up, so I'll have to leave it at that. May be the Mgenie order, but it's not letting me look at it. So let's just continue numbering as it is, and if there's a duplicate, we'll just leave it at that. Yeah. So let's.
If you'd like, Your Honor, I can run through the other three I'd like to introduce, maybe all off the record, and then we can do it all at one time.
Sure, that's fine.
Is that okay?
Yeah, go ahead.
So the next two would be Cubs discovery responses dated September 27, 2022 in this case.
Oh, I think I'll need the way you, so let me just show that on the screen.
Yeah, this was also in the, yeah, there you go. That second document.
Okay, so just general, let's just get informally, any objections to any, can we stipulate to putting that on the record?
Cub can stipulate to that.
Accept that as everyone. And
all right, and then next would be Cub's response to one WEPCO RFP 4.
WC, okay.
Yeah, that's the top document. This is again the Rethinking ROE article Dr. Khan wrote.
Okay, we'll want that in. I think we'll.
Okay, and then the last one in Dr. Khan's Surabottle at page 12, he introduces an exhibit, KIME 4. That exhibit is a blog post that talks about a new study on what he alleges are excess compensation to shareholders of utilities. We'd just like to introduce the actual working paper that the blog post is about. So yeah, that's the blog post. Attached to my email was the actual working paper. I think under the rule of completeness is the appropriate on the record. It's the Haas. Yeah, that's it.
Let's see what that looks like. So does that include the article and then additional?
That's so the blog post that Dr. Kime exhibit was about this paper.
Okay, any objections? So let's just informally see if we can stipulate to that.
Cub can stipulate to that.
Okay. All right. So that's fine. So I'm going to take those. I think I still have them in order that you've asked for them, Attorney Wilson. So Myers Finance, Myers, and somebody, Cubs first discovery, Cubs response to WEC RFP core, and then the Energy Institute Haas working paper. Is that all of them?
Correct.
Okay. Okay, so let's get on the record. So we've reviewed a number of documents. Joint applicants are offering for the record as supplemental KIME exhibits related to KIME's testimony, I believe cited in testimony and related to citations and offered exhibits. So at least informally, we have stipulation to put those in the record. And I'm going to just mark them at this point. So we have first available KIME exhibit is KIME 8. And that'll be titled, or it'll include the Myers article, the application of finance theory to public utility rate cases. KIME 9 will be another Myers article, discounted cash flow estimates. Keim 10 is the Cub response to applicant's first set of discovery requests. Keim 11 is the Rethinking ROE article from Dr. Keim. I just want to note if we can get a text searchable version for the final exhibit.
Your Honor, I had that was one of the articles I had trouble finding, and that was the best item I could. We can continue to look for it. I guess it's the company trying to put it in, but I'd be willing to help them try to find it. But that's the best one I could find.
Okay, that's fine. Okay, and so finally we had Cub. Oh boy.
12, I think.
12, yes.
Keim 12 or Cub 12?
Keim 12, yes.
Thank you.
The work paper from Energy Institute at Haas that relates to Keim's exhibit, the blog from the same institute. So we've gotten stipulations informally. So just wanted to double check any objections to receiving those exhibits. No, okay, thanks. All right. So any other questions for Cross?
Yeah, just one last series of questions. Okay. Dr. Keim, are you familiar with the S&P Capital IQ Pro Rate Case History Database, which is also called the RRA report?
Yes.
Okay. Do you consider that to be an accurate source for historical authorized ROEs by regulatory commissions?
Yes, as a source of returns on equity, I think it's widely accepted as being accurate.
Subject to check, that report says that no Wisconsin IOU has had an authorized ROE set below 9.8% since 1980, which is as far back as the report goes. Would you have any basis to dispute that?
I do not. I would like to see the document to do it subject to check, but that wouldn't surprise me if that were true.
We're willing to submit it as a delayed exhibit, particularly if CUB wants to stipulate to it. But it
would be helpful for me to see it to I think you're right, but I can't speak to it without having seen it.
Sure. What if it's okay?
We would like to see that and would stipulate to that.
Okay, we make that CUB 13 or Keim 13.
Keim 13. Oh yes. Sure. I guess. So I would just caveat that I wouldn't go so quickly as receiving it at this point. If you could frame the offer again as a request to submit additional evidence, and then it'll just give a time period for parties to object, just in case it's something that we didn't expect, since we haven't seen it here today.
Okay.
Okay, so and I think we have Commissioner Huebner. So let me just finish up with the applicants, if they have anything else for this witness.
No.
Okay, great. We've got, so it's off the record for a minute here. So we got up to Keim 13. Is that correct?
Yes.
And we have, and that 13 will be the RAA or RRA.
Yeah, RRA authorized ROE report.
Okay, and I don't remember if we mentioned that on the record. So let's just get on the record quickly, and we can mark as Keim 13 the RRA S&P report, as was discussed in testimony, and that'll be offered through a request to receive additional evidence. Okay, so Commissioner Huebner, did you have a question for Dr. Keim?
Yep, I had a couple quick questions.
Okay, go ahead.
I'll point you, Dr. Keim, to page 79 of your direct. And I asked applicant's witness, Ms. Bulkley, about this scenario. I don't know if you were present for that discussion earlier today.
Yes, I was.
Okay. And I just wanted to clarify your example here would be, should an ROE be reduced to Cub's proposed level, in this case of 9%. The third table that you've listed there has a scenario where the cost of long-term and short-term debt would increase by 1%. Can you explain kind of the bounds of that scenario and why you chose that debt would go up 1%?
Yeah, so that's actually an extreme scenario in two ways. The historical spread between AAA to down to BBB, so the full range of investment grades on average is 91 basis points. So if the bond rating for the utility were to fall 3 full classes, that would typically add 91 basis points. So that's a large overestimate because we're not talking about 3 full notches. And the other reason it's an overestimate is it assumes that the entire debt base is refinanced at the higher interest rate. And that's only going to be the higher debt cost is only going to come into play as it unwinds its debt and retires some. It has to issue some new stuff. So this is really a very, very conservative estimate. In the first year, there may be no debt issuance, and then you'd get the full 75 basis points in the first year. And then in the second year, you might get 68 basis points. As they start to issue new debt, then the higher interest rate would come in. But you would go probably 10 years before you actually got the full debt refinanced. It would be $100 million of savings for customers. A bond rating downgrade is just a minor feedback. The ROE every year, you will get not 100 basis points, you'll get about 135 basis points because of the tax savings. So every year you'll get 135 basis points off of equity, and then you will get a turning over of the debt. But again, I'm overestimating the rate impact. So the return on equity savings will swamp any debt cost, and it'll never be more expensive. If we stay within the bounds of the 91 basis point spread, eventually it could get to that, but then it's still cheaper. So I said in my testimony, this is a very conservative way of looking at it. But even if I push it all the way to the limit, I still save 30 basis points.
Okay, thank you. During the testimony today of Clean Wisconsin's witness Ellis, he talked about his capacity as an executive at Sempra and how the company has, I don't know if you call it tools or levers to avoid credit downgrades. Do you have an opinion? Do you agree with that? Or do you not have a professional opinion about whether those levers would exist?
Well, I guess I don't know what the adjective I'm looking for. I guess I would softly agree, somewhat agree that they can move things around and try different financing vehicles. They can adjust the capital structure. So there's some ability to adjust. I'm not exactly sure what Mr. Ellis was referring to be specific.
Okay. No problem. Back to your previous answer, you mentioned moving down 3 classes on the debt side from AAA to BBB would be 91 basis points. Is that roughly equally split between those 3? 30 basis points?
No, it starts to go up a little bit more toward the as you go. So if you go from AAA to AA, it's not as much as going from single A to BBB.
Got it.
But I was giving you I was giving you the cumulative effect.
Right.
Which is 91.
Okay, thank you. Okay, that's all. Thank you.
All right, other cross questions for the witness? All right, redirect?
No redirect. Thank you.
Okay. All right, thanks very much. You're excused.
Thank you, Your Honor.
Okay.
All right.
So,
Corey here, witness Singletary.
Can you hear me, Your Honor?
Yes. How extensive will this cross be?
Likely less than was for Dr. Keim, I think 15 minutes.
We'll try and see how late it goes. We may need to take a break in the middle, just so you have a heads up. All right, let me swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
All right, go ahead.
Please state and spell your name for the record.
Corey Singletary, COREY, SINGLETARY.
And Mr. Singletary, did you prepare and file or cause to be filed direct rebuttal, surrebuttal testimony along with 6 exhibits and errata for your direct?
That is correct.
And is that testimony and the information contained in those exhibits true and correct to the best of your knowledge?
Inclusive of the errata corrections, yes.
Okay, and let's go to the questions at the bottom of Judge Newmark's service list regarding costs and ROE. You could please address those.
Yeah, I'll try to take these in the order the judge has presented them. So 1A, with respect to electric cost allocation or cost of service study, my preference or Cub's preference on electric cost of service study method is represented, described generally as method 6, 12 CP capacity basic customer method. And I start discussing my support for this at about page 34 in my direct. Keeping with cost allocation on the natural gas side, my stated preference in the record would be for the cost of service B or cost B. And I discussed that at pages 60 to 61 roughly in my direct. For revenue allocation for electric, I state in my direct testimony at about page 58 that I support the company's filed electric revenue allocation. And then for natural gas, I state at about page 61 of my direct that I support commission staff's proposed natural gas revenue allocation. And then for 1B of the judge's questions for return on equity, as noted by Dr. Keim, Cub's recommended return on equity for WEPCO and Wisconsin Gas is 9.0% in this proceeding.
So just to follow up, did you have a recommendation for preference for revenue requirement?
On revenue requirement, we don't have anything specifically articulated. We flagged some issues for the commission to consider. Many of them are addressed in the settlement agreement, which is being addressed in parallel. So we do not, with respect to sort of where we are, what we're addressing today, have anything related to revenue requirement.
And I also listed rate design. Is that anything separate you need to add to answer that question? Or?
Rate design, I guess, keeping with what's in the before us in the testimony, insofar as rate design, I did testify that for residential electric customers, I believe it would be reasonable to reduce the electric residential customer charge from the currently authorized level of $16 down to $15. And then, yes, sorry, I almost blended cases there. So $16 to $15 for WEPCO electric, but that has been to a certain extent, superseded by the settlement agreement should it be approved by the commission.
Okay, great, thanks. Okay. Anything else from Cub?
Do you have anything further?
In the interest of time, I do not at this time.
Okay.
Okay. Mr. Singletary is available for question.
Good afternoon, Mr. Singletary. Joe Wilson on behalf of the applicants.
Good afternoon.
You've testified that Cub believes in gradualism when setting authorized ROEs, and you've recommended 100 basis point reduction in WEPCO's ROE and 120 basis point reduction in Wisconsin Gas's ROE in the interest of gradualism, correct?
I think that'd be a fair characterization, yes.
In 2022, inflation rates in the US have risen to their highest levels since the 1980s, correct?
I can't confirm that specific comparison that you're making, no.
The Federal Reserve has raised its benchmark interest rates considerably this year, including by another.
Objection, Your Honor. I don't believe Mr. Singletary testifies to macroeconomics or interest rate.
Well,
is there place on the record where that's discussed?
Well, I think the entire point of the approach that Cub is suggesting here is that you have to start with the cost of equity, which these items matter to, and then consider other factors in setting an ROE. And these factors would also come into play with respect to that consideration. So I think it's fair game for Cub to acknowledge the existing economic picture.
Okay.
I don't,
yeah.
I don't think Cub would deny the existing economic picture. And Mr. Singletary does not testify to cost of equity at all. That is outside of his wheelhouse.
Yeah, he's certainly testifying about the return on equity, and his recommended return on equity has as its basis estimated cost of equity. Mr. Singletary and Dr. Keim have also described their analyses and contributions in this case as going hand in hand. So I don't know that there's a hard and fast wall between the two of them.
Yeah, I guess he can answer the questions to the extent he knows.
I mean, I guess I've already answered the question as to being able to confirm the information that I'm assuming you're using as foundation for your follow-up questions. Do you have a question related to interest rates that I could answer?
Yeah. The Federal Reserve has raised the benchmark interest rate considerably this year. Would you agree with that?
Yes.
And just in the last couple of weeks has raised it 75 basis points, such that it currently stands at 3.75%, correct?
For the purposes of discussion, I'll accept your representation of that.
And isn't it true that one of the reasons the Fed has consistently cited for raising interest rates has been to attempt to curb historic high inflation rates?
Objection, Your Honor. Again, this is asking Mr. Singletary to testify to Fed policy and statements that he just does not testify to. And
yeah, okay, I'm going to agree with that. If there's something you can cite to the record to have in the basis of his expertise, he can refute or
look at Mr. Singletary's rebuttal testimony. At page 24, Mr. Singletary refers to his consideration or the fact that the commission ought to consider macroeconomic factors such as inflation, at least with respect to revenue allocation. I would argue that Mr. Singletary is very well aware of Fed policy and setting interest rates and the reasons for hiking interest rates this year.
So just as a point of clarification, this discussion is within the context of revenue allocation?
No. It's in the context of.
Your Honor, this question lacks foundation. And it's irrelevant.
Sorry, you're not question. Your citation is pointing to a portion of my testimony.
Yeah,
related
that
to revenue
portion of the
allocation.
testimony was in reference to revenue allocation.
okay. Does that change anything for you, Attorney Wilson, that the testimony is related to revenue allocation?
No, I mean, I'm asking Mr. Singletary a question about the economic condition in the United States at present, and I think he's very well suited to talk about the interest rate environment and the Fed's actions in setting interest rates in response to inflation. I also think it's a widely known fact, well reported.
Objection to this line of questioning for this witness.
Yeah, I'm not sure how it relates to the expertise of the witness. I mean, we can take note of what the Federal Reserve has done. At that point, what would we do with that information?
Yeah, it's fine. I can move on. Maybe can I just get one concession that I think Mr. Singletary can make, which is that the applicants are operating today in a high inflation and high interest rate environment.
To the extent that the applicants are within the
Objection.
economy, yes, as well as the customers are also operating within a high inflation environment.
Thank you.
Okay, I think that.
So circling back to the concept of gradualism, in your opinion, can this concept of gradualism work the other way? In other words, could authorized ROEs be increased gradually?
Yes.
Would your view of gradualism support an increase in ROE in a high inflation and high interest rate environment?
Objection. This is vague. Could you be more specific about other factors? You're asking him you've provided a hypothetical, and
I don't think the fact that we're existing in a high interest rate and high inflation environment is hypothetical at ever and whatsoever. And Mr. Singletary has conceded as much.
Mr. Singletary is not advocating for increases in ROE.
I understand that, but I'm trying to understand if he ever would.
I think that's fair. Go ahead. You can answer that question. Do we need it read back?
Yes, please.
Question, would your view, oh my gosh, question, would your view of gradualism support an increase in ROE in a high inflation and a high interest rate environment?
All right. So in order to answer your question, I have to unpack it a little bit. As I put in my testimony, consideration of things like inflation are handled within the estimation of the utility's cost of equity. So it's as I testify, the commission should not be viewing this as a factor in sort of an ex post way in terms of trying to adjust for the model. Now, in considering the sort of macroeconomic factor generally, which is, I guess, how I'll interpret your question, once we've estimated a cost of equity, the framework could support an increase, or the framework would support an increase to ROE if the commission determined that whatever that ROE is, it fairly balances the interests of customers and shareholders. And in an environment where in your hypothetical, where there would be high interest rates and high inflation, that the commission could consider the economic impact being borne directly by the customers in determining that balance. So the framework can support it, but there has to be evidence to support it with respect to the balance of the interest, fair balance of the interest between the customers and the shareholders.
So is your testimony that it should be considered with respect to its impact on customers, but not with respect to its impact on shareholders?
Largely, yes, that is my testimony, because as you know, it's been discussed in primarily Dr. Keim's testimony, the investors' required return is covered by or captured by the estimate of the cost of equity, and an authorized ROE at that level would satisfy the would satisfy the investor's required return. So as we've already testified, as the commission considers an ROE at increments higher than that cost of equity, you are essentially moving your any incremental revenue requirement impact is being borne at the expense of customers, right? Increasingly. And so the commission, in weighing that balance, needs to consider that for each increment of ROE, call it 10 basis points, 20 basis points, that it adds on top of the estimate of cost of equity, that our view is that the commission should be at least qualitatively justifying that within the framework of balancing shareholder and customer interests.
Can we look at exhibit Singletary 5 back on page 12 of that exhibit, please?
Okay, off the record. So it's Singletary 5, page 12.
Correct.
Oh, the order. Okay.
Yeah, the order. Yep. Yeah. Next page. There you go. Yep. Are we back on?
Oh, yes.
Mr. Singletary, I'm showing you what you submitted as exhibit Singletary 5. This is the commission's order in a 2007 MG&E rate case. Are you familiar with this order?
I recognize that, yes.
Okay. And is it fair to say that CUB is holding the commission's approach in this order up as a model for how the commission might approach setting ROE in the current case?
I mean, the specific way that I referenced this in my testimony was holding it up as an example of how this commission has already in the past affirmed the conceptual model. So that's how it's used in my testimony.
At the end of the first paragraph on the first left column there are the factors that the commission considered in the 2007 case in establishing the premium to cost of equity and setting MG&E's return on equity. Do you see that?
I do see that, yes.
Okay. And one of those factors is consider existing investors. Do you see that?
Yes.
Would you agree that the interest rate and inflation environment that is extant in the economy at the time of the commission is making a decision would affect the interests of existing investors?
I believe questions as to, how the investors would be impacted as it relates to their consideration of their, the changes in utility stock price or returns on investments in the company's equity would be better directed toward Dr. Keim.
Okay.
Well, so I think that's what you're asking about. That would be outside of my area of expertise.
Well, you've testified that the interest rate environment and inflation environment should be considered with respect to customers, but not with respect to shareholders. And I'm suggesting that this order is inconsistent with your testimony on that point. And I'm asking if you disagree with the order to the extent my reading of it is correct.
I mean, I would agree that the commission, when it issued this order, included that amongst the items that it explicitly notes that it considers.
So it's your testimony that even today with a high interest rate, high inflation environment, gradualism only works to lower the ROE, not increase the ROE. Is that fair?
I believe I answered that question earlier.
No, I've forgotten. Can you answer it again?
No, I think that was asked and answered. Let's move on.
Okay. Mr. Singletary, you were aware that yesterday the Florida Public Service Commission approved NextEra's application for.
I'm sorry, approved.
Yeah, NextEra's.
Thank you.
Application for Florida Power and Light to adjust its allowed ROE midpoint to 10.8%, up from 10.6%, and the upper end of its allowed ROE band from to 11.8%, up from 11.7%.
I'm not aware of that. We had some things going on yesterday.
Yeah. So presumably you're not aware that the basis for that increase was the rise in the 30-year Treasury.
I have no reason to have an opinion one way or another.
He said he's not aware of that order.
Mr. Singletary, I want to talk a little bit about the concept in your testimony that performance factors can justify higher ROE premia for utilities. Okay.
Sure.
And it's your position that a utility should earn a premium over the cost of equity only if the utility proves or establishes that it deserves such a premium through its performance. Is that fair?
That would be a fair characterization. Yes.
I want to just compare how you describe the performance of WPSC and WEPCO as described in your testimony in errata. I think, Your Honor, there could be a lot of flipping around here, but I think I can summarize. And if Mr. Singletary agrees with my summarization, maybe we can avoid the flipping, because it's just a couple of questions about each.
Let's give it a try.
Okay.
All right, we'll try it. I think, my impression is the commission would probably benefit from getting the citations to the testimony.
I'm happy to give the citations as we go.
Okay, if you can give citations during your summary, yeah, go ahead and do that.
Okay, Mr. Singletary, you evaluated the WEC utilities on 3 performance metrics, right?
I gave examples of how those companies could be evaluated against those 3 criteria. Yes.
And the criteria were reliability, rates, and customer satisfaction.
As broad categories, yes.
On the topic of reliability, with respect to WPSC, you said that it performed well across all 3 reliability metrics when compared to its Wisconsin peers. That was in your direct testimony at pages 18 to 19.
That sounds correct.
Okay. And with respect to WEPCO, you said it had, quote, improving reliability, end quote, representing, quote, a trend which brings WEPCO in line with the average of other Wisconsin utilities, end quote. And that's at page 19 of your direct. Does that sound right?
Again, that sounds consistent with my testimony.
With respect to the second performance metric, rates, you said that WPSC rates are among the lowest WPSC rates are the lowest among Wisconsin IOUs and have experienced the second lowest growth rates among Wisconsin IOUs. That was at your direct testimony, page 18, and your errata, correct?
Again, that sounds correct. Yes.
And with respect to WEPCO, you said, and I'll quote, that WEPCO's rates were, quote, the effective cost of electricity is the second highest among Wisconsin IOUs, end quote, that WEPCO has held that ranking since 2012 and has the second and third highest growth rates among Wisconsin utilities. That was in your direct testimony, page 18, right?
Again, subject to check, that sounds right.
Okay. And on the last performance metric for WPSC, you said Wisconsin Public Service Commission Corporation customer satisfaction scores are good and notably above average when compared to Wisconsin IOUs and other large Midwest utilities. That was in your direct testimony at 19 and in your errata, correct?
Again, that sounds consistent with my testimony.
Okay, and then finally, you said WEPCO's customer satisfaction scores are, quote, unremarkable and are near or slightly below average, and quote, between 2015 to 2021 as compared with Wisconsin peers and Midwest comparators.
I'm sorry, 2021 as compared.
To Wisconsin peers and Midwest comparators.
Thank you.
That was in your direct testimony at page 20, correct?
Again, that sounds consistent with my testimony.
So on the performance metrics that you measured in this case and in the WPSC rate case, would you concede that WPSC is a relatively high performing utility?
I would concede when looking at those three items specifically and in isolation that yes, WPSC performs better than its sibling utility, We Energies. Yes.
Could you characterize how much better WPSC performs than WEPCO in your opinion?
I would say that given the, fact that Wisconsin rates overall are amongst the highest in the region, being one of the lowest average cost utilities is definitely, a plus. But in terms of, I guess I'm uncertain if Attorney Wilson is asking me for, well, what kind of result are you at? How are you asking me to describe that performance difference?
Well, that's part of the difficulty is that these are qualitative judgments in some ways, right?
Yes.
Okay. So, would you say that WPSC is a much better performing utility than WEPCO?
I would say that, again, because it's a limited, as I noted in my direct testimony, I do not believe that this set of evaluation criteria or metrics is comprehensive. The commission could consider any number of other factors. I provide a number of examples the commission could consider. Within that very narrow scope of things, I would say that WPSC is doing a little bit better. But if one steps back and looks at the entire utility, or all of these utilities at sort of a higher level, right? Trying to capture trying to look at the utility picture itself, without, going through and identifying what additional criteria, which we're essentially asking the commission for some guidance there. Both the utilities are doing fine. Nothing's on fire, but I would also say none of the utilities are lighting the world on fire either in terms of doing something exceptional for their customers. And again, from our perspective is for their customers. Their rates are lower than their peers. And admittedly, it was a little bit of a surprise to me, but I presented the data anyway. It was a little bit of a surprise to me that their reliability metrics were generally speaking better than other Wisconsin utilities. And we recognize that actually in the other docket that the commission could consider, again, because we're looking at a narrow range of criteria, the commission could consider, say, a 10 basis point differential between those utilities to recognize that.
Sorry to interrupt, Mr. Singletary, but you keep criticizing the sort of narrow range of criteria. You chose the criteria you were going to focus on in this case, right?
I did.
Okay. Nobody set parameters that told you could only look at those three criteria, did they?
No, but if you look at my testimony, the central thrust of my testimony is the applicants in their application requesting a 10% ROE from Cub's perspective had not met the burden of proof for why that 10% ROE is deserved or earned or reasonable, given our estimation of the cost of equity and the complete lack of any discussion of how the balance between customers and shareholder interests is fairly struck, particularly considering things from the customer perspective. That is the basis for our recommendation that the ROE be lowered from the currently authorized level of 10% to 9.0, is because it's supportable by our estimate of the cost of equity, which is lower than that. So within our framework, that would be a reasonable number in that it's not lower than the cost of equity. It is gradual in the sense that we're not arguing for a return on equity of, say, 7% as an authorized return on equity. We're requesting a reduction in return on equity that is within the bounds of what the commission has authorized in the past. And again, from our perspective, it circles back to a lack of supporting evidence from the applicant.
So I want to explore something you just said. A 9% ROE is within the bounds of ROEs that the commission has authorized for Wisconsin IOUs in the past?
A reduction in the ROE of 100 basis points, as we're suggesting. That reduction is within the bounds of what the commission has authorized in the past, not the authorized ROE level, but the change in the authorized return on equity.
So I asked you that question yesterday. Have you done additional research to uncover situations in which the commission has dropped a utilities authorized ROE by 100 basis points between yesterday and today?
Your specific question is if I was aware of any instances where the commission has lowered the ROE by 100 basis points or more or something like that. And I was not aware at the time. And so, yes, the answer to your question is yes. The research, or as it were, is presented in Commission Staff Adams Exhibit 1, Schedule 9, page 3 to 4, where he presents historic commission authorized returns on equity. And looking only at Wisconsin Electric and Wisconsin Gas in Mr. Adams' exhibit, he shows it appears there's one or two time ranges where it's a little. I'm having to make some assumptions as to what was the currently authorized and what wasn't, but it appears that there were reductions of ROE of at least 100 basis points on about four different occasions, and reductions of ROE from 50 up to 100 basis points, so 50 to 99, we'll call it, on about another 4 instances. All right. So the reduction we're asking for is not out of bounds for the commission. So I will note that there were also increases to ROE that were also fairly large. And again, if supported by the evidence and supported by a fair balance of the customer and shareholder interest, that is supportable within the framework. But if you're asking about gradualism, that's the commission has made changes like that in the past.
Judge Newmark has the document you're referring to up here. Can you point to the examples that you're?
Yes, schedule 9, page 3 and 4. And I believe Mr. Adams has an Adams 2, which I think updates some of this information, but and I didn't have an opportunity to check, but I think the specific pages I'm referencing haven't changed because it's historic. But this is a history of PSCW rate case decisions, and there's an authorized return on equity over here in the second to last column on the right. And so there are instances there, for example, in a 1986 issued order for Wisconsin Electric Power where the authorized ROE, if I'm assuming these are sequential based off of the time, all right, between 1985 and 1986, it was 150 basis point reduction in ROE. Mm-hmm. And there are other instances where there's, reductions in ROE that range from, 50 to about 150 basis points across both Wisconsin Electric and Wisconsin Gas.
Right. And the one you pointed to was in 1986, and the authorized ROE went from 14.5% to 13%, according to this document, right?
Yes.
Were you present for Dr. Keim's cross?
Yes.
All right. Without belaboring it, we went through a report there that subject to check showed that the commission has not authorized an ROE under 9.8% since 1980. You recall that?
I do recall that, yes.
And do you have any basis to dispute that conclusion?
I do not have any basis to refute the conclusion that the commission has not authorized a specific return on equity lower than 9. No.
So
lower than 9.8.
Mhm.
Lower than 9.8. He said that.
Off the record.
Yeah. Sorry.
Okay. How many more questions do we have?
Just a couple. Just a couple. I want to go back to the line of questions that I was on and finish it. But I think Mr. Singletary may have just misspoken and said that the commission has not authorized an ROE lower than 9%, when in fact, I think the number is 9.8%.
Okay. Yes, not 9.8.
Oh, wait, we're
on the
we're
record.
not on there.
Are we off? We're off. Okay.
Let's get on and clarify that.
Mr. Singletary, in your most recent answer, you said, we think that the commission has not authorized ROE under 9.0%. But in fact, as far as you're aware, since 1980, the commission has not authorized an ROE lower than 9.8%, correct?
Yes. My intention was to agree that I have no reason to dispute your statement.
Okay. I want to just circle back to this performance metrics issue. We were talking about the difference between WPSC and WEPCO. And I think you had conceded that WPSC is a better performing utility according to the metrics you selected than WEPCO, right?
Yes.
But your recommendation to reflect that performance difference is just 10 basis points, right?
Yes.
How did you select 10 basis points?
Again, given that it was sorry, let me backing up. That concession, as it were, was in response to Ms. Bulkley's testimony, wherein she, in that proceeding, right, so we're bringing in things from a different proceeding here for a moment here, but in that proceeding, and I guess to a certain extent in this one, she critiqued Cub's method as being arbitrary because we did not reflect a difference in performance between Wisconsin Public Service and WEPCO, wherein she argued, I think she used the word superb or superior or some adjective to that effect to characterize the differential between the two companies. And in my, I believe, sir rebuttal, I agree that conceptually she's not wrong, that if the commission were to determine that there is a performance difference between Wisconsin Public Service and We Energies that merited a differential treatment with respect to authorized ROE, that would be consistent with our framework. And in basically an act of good faith in that proceeding, we modified our ROE recommendation such that if the commission, agreed that the 10 basis points, or I should say that the performance difference as described across those three metrics was worth 10 basis points, that we would agree that would be consistent with our approach.
You're describing this as an act of good faith or a concession, but in fact, isn't it just the operation of the methodology that you're suggesting the commission adopt?
I guess the priority that Dr. Keim and I had when we reviewed the estimate of the cost of equity and what Cub's recommendation would be for a return on equity, an authorized return on equity. The primary issue was the large delta between the cost of equity and the applicant's requested ROE or currently authorized ROE. So the primary goal was to, again, due to a lack of evidence and just simply due to the magnitude of that delta, to move in the direction of the estimated cost of equity. And if you're asking me as to why the numbers initially were the same, it's because from our perspective, a 300 basis points is still a very large premium over, sorry, 200 basis points is a very large premium over, say, a cost of equity estimate of 7. I'm going to use that number for discussion here. And that essentially we weren't trying to split hairs because what we're trying to get, what we're asking of the commission is for it to more explicitly adopt the framework that it has used in the past and that we're recommending here in terms of identifying a reasonable estimate of cost of equity and then articulating specifically as to how it arrived at a reasonable return on equity. So, you know, from our perspective, it wasn't essential to split hairs when given the premium between the cost of equity and a 9%, again, given lack of evidence presented by the applicant, right, in terms of how we originally proposed that. But in response to Ms. Bulkley's criticism, we acknowledge that there could be a difference. And again, when assessed, because within that conversation of essentially conversation between witnesses, between myself and Ms. Bulkley, we're talking about those 3 metric areas specifically, a 10 basis point differential was reasonable. And I would argue that usually historically that's the band that we've been arguing about. The utility fights tooth and nail to avoid a 10 basis point reduction or fight for a 10 or 20 basis point increase. And so to concede 10 basis points doesn't seem like a very small item here.
Well, in the context of a proposed 100 basis point reduction or 120 basis point reduction, I would argue that it does. Would you concede that?
I mean, that's certainly the company's position.
I don't think you answered my original question, which was how you selected 10 basis points. What I'm hearing is it was essentially arbitrary. Is that fair?
10 basis points is often sort of an increment that we use when we talk about ROE in this state historically as just sort of a practice, right? And again, as sort of a, you know, if you could characterize it as arbitrary, for us, we characterize it as a good faith attempt to reflect a performance difference.
Okay. Under the performance metrics that you have identified, what's the best performing utility you're aware of?
I did not seek to determine that.
Did you consider the performance of any utilities other than the applicants in this case and in 6690 UR 127?
I did not, no.
So you wouldn't be able to answer whether under your approach to setting authorized ROE, any utility should be higher or lower than 9% or 9.1%, right?
No, because I think that misses the point. Our testimony, you know, between myself and Dr. Keim is that, you know, the commission should not be relying primarily on looking at either what it's done in the past or looking at what other utilities are receiving, but a fact-specific determination for a particular utility as to what return on equity is just and reasonable based off of the evidence in the record.
Last couple questions on these performance metrics. Is it?
No, hang on. Let's go off the record and just take a break. Just the stretch break. So give us all a minute just to do that. So off the record.
Okay.
Yeah. Don't go anywhere. Just sit and take a break.
Understood.
I the only one that got up and stretched?
I've been standing all day, but
I wish I could stand and do this. That would be so much better.
all right. So let's get back to it. We still have questions from the applicant. A few more, I'm assuming.
Are we ready to go?
Yes.
Okay, sorry. Mr. Singletary, the performance metrics you've been discussing could change from case to case, rate case to rate case. Is that fair?
Yes, that would be up to the commission to decide.
Okay. Should the same metrics apply to all utilities in the state?
I believe it would be fair for that to be the case. Generally, there might be fact-specific considerations that might come up, but those would probably not fall under what we are thinking about in terms of metrics.
Okay. Would you concede that the commission has not, before now, put utilities on notice that they would be measured against these metrics that you've proposed for purposes of setting authorized ROE?
I would agree that the commission hasn't articulated that they would be evaluated against criteria like the ones I present in my testimony specifically.
Okay.
I believe you went through with Dr. Keim some considerations in the MG&E 2007 order that the commission considered. But with respect to, I guess, the type of, again, metrics that we're talking about, I believe your characterization would be accurate.
Okay. Final series of short questions, hopefully. Dr. Keim's estimate is that the cost of equity is 6.3 to 7.8%, right? And CUB's approach is that we ought to drive toward that level for setting authorized ROE, correct?
Absent countervailing policy evidence to support a higher ROE than that, then yes, incrementally we should move towards that.
You have not identified a landing spot for the commission. Well, let me back up. You're not proposing that the commission set the authorized return on equity at the cost of equity. Certainly not in this case and not in the future either, correct?
Certainly not in this case, and that there could be reasons why a commission could authorize an ROE at the estimated cost of equity. I believe that has happened around the country from time to time, again, based off of performance considerations for utilities. But as we sit here today, CUB's proposal is not to explicitly set, I guess, to use your word, a landing zone or whatever it is, a target of the cost of equity explicitly, again, absent some other evidence.
And CUB hasn't proposed any specific landing spot for ROE relative to cost of equity, correct?
No, we have not suggested a specific landing spot when considering a downward adjustment to ROE, in the same way that the company, in preferring a higher ROE than staying status quo, has not recommended a landing spot in that direction either.
Wouldn't knowing that landing spot be helpful to the commission as it considers CUB's approach of driving toward the cost of equity?
Certainly something like that would be helpful, but I don't believe it's a prerequisite.
No further questions.
Okay, other cross? Redirect?
No redirect.
All right. Thanks very much. You're excused.
Thank you.
So is that all the interveners we need to take tonight?
That's everybody we have cross-board.
Okay, and we're not missing any interveners, and we're expecting them to verify testimony by affidavit. So let's push on to staff. We have Adams and Ritzma already taken care of, so let's call the next staff witness.
We'll call Mitchell Horry to the stand first.
All right, there you are. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
Yes.
All right, go ahead.
Please state your name for the record.
Mitchell Horry,
What is your position at the Public Service Commission?
focus on energy performance manager.
Did you file or cause to be filed direct testimony in this docket?
Yes, I did.
Are the statements and representations in the testimony you filed in this case true and correct?
Yes, they are.
Do you have any additions or modifications to your testimony at this time?
No, I do not.
Your Honor, the witness is available for cross-examination.
Okay, any questions? But I did have a couple I asked in the last case, so I just want to be consistent despite the time tonight, but so let's be quick. So witness Horry, did staff consider inflation when making its recommendations with respect to adjustments to the voluntary energy efficiency program budget?
No, that's not a common practice for staff to do in that review.
And same question with respect to the proposed focus contribution budget.
No, that contribution is determined by formula. It doesn't consider inflation.
Okay, great, thanks. All right, any redirect?
Yeah, I just realized because of the error in the testimony chart, I forgot to ask him to verify his rebuttal testimony, which I'll do now.
Okay.
Did you file or cause to be filed rebuttal testimony in this docket?
Yes, I did.
And are the statements and representations in that testimony true and correct?
Yes, they are.
And do you have any additions or modifications to your rebuttal testimony at this time?
No, I do not.
All right, the witness is available for cross.
Okay, okay, no questions at this point.
Or any other questions.
All right, great. Thanks for catching that, and we can excuse you now. So take care.
Thank you.
The commission calls Andrew Eider to the stand.
Can you give me a minute to get him on the screen here?
Oh yeah, you have to find him. Yeah.
Okay, thanks.
All right, swear you in, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right, go ahead.
Please state your name for the record.
Andrew Eider.
What is your position at the Public Service Commission of Wisconsin?
I'm a public utility rate analyst.
Did you file or cause to be filed direct testimony in this docket?
I did.
Did you also file or cause to be filed 2 exhibits in this docket?
Yes, I did.
Are the statements and representations in the testimony and exhibits you filed in this case true and correct?
Yes.
Do you have any additions or modifications to your testimony or to your exhibits at this time?
I do not.
Your Honor, the witness is available for cross-examination.
All right, any questions? All right, thanks very much. You're excused.
Okay, thank you.
All right, the commission calls Tyler Mellemans to the stand.
Good evening. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
Yes, I do.
Okay.
Please state your name for the record.
Tyler Mellemans.
And what is your position at the Public Service Commission of Wisconsin?
I am a public utility financial analyst.
And did you file or cause to be filed direct and rebuttal testimony in this docket?
Yes, I did.
Did you also file or cause to be filed 2 exhibits in this docket?
Yes, I did.
Are the statements and representations in the testimony and exhibits you filed in this case true and correct?
Yes, they are.
Do you have any additions or modifications to your testimony or exhibits at this time?
I believe Judge Newmark identified one clarifying point in the offered evidence list as it relates to my SIR rebuttal on bottom of page 4 onto page 5. Technically, it would be lines 2, 3, and 4 on page 5, where it reads, the commission has considered and approved several projects served on MG&E's renewable energy rider, which suggests that this model can be successful in MG&E's jurisdiction. I think through rounds of internal review, my intent may have gotten a little skewed. My intent with that statement originally was to say that since MG&E has had success in their jurisdiction, that it could be reasonable for the commission to authorize this program to see if it could be successful in other jurisdictions in this proceeding WEPCOs.
Thank you. And does that conclude your additions or modifications to your testimony and exhibits?
Yes, it does.
Your Honor, the witness is available for cross-examination.
Okay, thanks. Any questions? All right, none. I see none, so you're excused. Thanks very much.
Thank you.
All right, the commission calls Kara McFerrin to the stand.
All right, we swear you in. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, go ahead.
Please state your name for the record.
Kara McFerrin,
And what is your position at the Public Service Commission of Wisconsin?
consumer analyst.
Did you file or cause to be filed SIR rebuttal testimony in this docket?
Yes, I did.
Did you also file or cause to be filed one exhibit in this docket?
No, I didn't. I'm actually Judge Newmark gave instructions and asked for it to be offered in the evidence list, so I will be.
Okay. And are the statements and representations in your SIR rebuttal testimony in this case true and correct?
Yes, they are.
Do you have any additions or modifications to that testimony at this time?
Nope, other than the changes that Judge Newmark has asked in the offered evidence list.
Thank you. Your Honor, the witness is available for cross-examination.
Okay, any questions? No, not seeing any. Okay, great. Yes, and thanks for clarifying that. That's all we need. You're excused.
Thank you.
Take care. All right. Go ahead.
Your Honor, the commission calls Klaus Mailata to the stand.
Okay, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
Yes, I do.
Okay, so let me ask you first, were you here the whole time?
Yes. And didn't drink a Red Bull either.
First person to join us today, so okay. All right, go ahead.
Please state your name for the record.
Klaus Mailata,
What is your position at the Public Service Commission of Wisconsin?
financial analyst.
Did you file or cause to be filed direct testimony in this docket?
Yes, I did.
And did you also file or cause to be filed one exhibit in this docket?
Yes, I did.
Are the statements and representations in the testimony and exhibit you filed in this case true and correct?
Yes, they are.
And do you have any additions or modifications to your testimony or exhibit at this time?
No.
Your Honor, the witness is available for cross-examination.
All right, any questions? So, okay, let's go off the record for a second. So I'm not seeing WEPCO applicant attorneys connected.
They're just off the screen.
Yeah, it looks like the camera's just off.
Okay, I just want to make
sure, Your Honor. I didn't take advantage of your stretch break, and I was just doing so.
Okay, I just want to make sure you're still here.
Still here.
Hard to tell if I can't see you. Okay. Yep. All right, so let's get back on the record. So we're ready for questions for witness Mailata. Any questions? No. All right, great. Thanks. You're excused.
Thanks.
Great. And finally, the commission calls Deborah Probst to the stand.
Okay, raise your right hand. Swear you in. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
Yes, I do.
Okay,
Please state your name for the record.
Deborah Probst.
And what is your position at the Public Service Commission of Wisconsin?
I'm the audit supervisor.
And did you file or cause to be filed direct and rebuttal testimony in this docket?
Yes, I did.
Did you also file or cause to be filed one exhibit in this docket?
Yes, I did.
Are the statements and representations in the testimony and exhibit you filed in this case true and correct?
Yes, they are.
And do you have any additions or modifications to your testimony or to your exhibit at this time?
No, I do not. I did file a rebuttal. Sorry, I missed that when we went over the offered evidence list.
Okay, are the statements and representation in your rebuttal testimony in this case true and correct?
Yes, they are.
And do you have any additions or modifications to that rebuttal testimony this time?
No, I do not.
All right, that should do it, Your Honor. The witness is available for cross-examination.
okay, sorry, I missed the rebuttal on the offered evidence list, so I'll include that, receive that into the record as well. Let me briefly ask the question I asked in the pub service case as well. So I'm directing you here on the screen to page 19 of your direct witness probes. And I was just curious, did the applicant request escrow accounting treatment for the cost categories you identify on the page here?
So no, the applicant did not request escrow accounting treatment for their pension and other post-retirement benefits. It is something commission staff is suggesting, consistent with prior commission's decisions with other utilities or other IOUs.
Okay. And could the commission also consider, as an alternative, applying deferral accounting treatment to these items?
That would not be staff's suggestion. Deferral accounting treatment would not exactly be appropriate in this case because escrow accounting treatment would capture any of the increases or decreases to these costs that would ensure both the applicant and customer remain whole. Deferral accounting treatment is normally for items that have specific costs that occur in 1 year that would be recovered in the next, that would meet certain criteria that would be eligible for deferral accounting treatment, and this pension and other retirement benefit might not, but it would qualify for escrow accounting treatment if the commission wanted to authorize it.
Okay, great. Thanks for clarifying that. All right, any redirect?
No redirect.
All right, great. So at this point, you're excused. Thanks very much. Did I ask for cross? I can't remember. I don't think there's any cross. No, okay. We're all done here. Okay, that's all we have for witnesses, is that right?
I closed it out,
Okay.
like Josh Hader.
Okay, so we have no more witnesses. We have a bunch of filings to be expected. We have the post-hearing schedule already in effect. Anything else we need to deal with before we adjourn? No. All right, thanks very much. We'll disconnect now. I appreciate everyone for sticking out to the end.
Your Honor.
Thank you, Your Honor.
Thank you. Have a good night. Thank you.